A very good morning to all the dignitaries, eminent speakers, participants, and fellow students. My name is Soumya Khanna, faculty at IPM Law Academy, and it's a moment of great privilege and honor for me to extend a hearty welcome to all of you in today's International E-Conference on Intellectual Property Rights, the Contemporary Issues. The theme of the international conference is a highly deliberated subject in the world which is not only limited to the people from the law background but to each and every one of us who makes use of it. Before we move forward, I would like to share a few lines about IPM Law Academy, which is a part of the IPM group under the aegis of Lakshya Educational Society. On the completion of 25 years of excellence, IPM Group continues to build on its reputation as a premier institution offering programs in the field of management, information technology, law, and education. The fundamental mission of IPM Law Academy is to provide its students with the knowledge, skills, and ethical values needed for a career in law. Collaborative effort of our faculty members, guest speakers, and legal scholars consistently endeavor to develop in the students a sense of responsibility to serve the society in the field of law by developing skills in advocacy, judicial, and other legal services, to impart high quality legal education and to develop overall personality of the students in a disciplined environment, to prepare lawyers of tomorrow for handling legal issues not only restricted to the national boundaries but also complex cross-border transactions, developing legal skills in core specialized areas such as business laws, intellectual property rights, cyber laws, and trade laws, to organize lectures, seminars, and conferences for the dissemination of legal knowledge and to make laws and legal processes efficient instruments of social development. IPM Law Academy considers aspects of teaching and assessment where students are given different choices and flexibility. It adopts different teaching methodologies, imparting knowledge, for instance, through lecture, discussions, problem solving, role play or simulation, debates, etc. There is always a regular evaluation which improves the quality of the course as well as teaching. Also, I would like to mention that we have already launched our two books and journals under the international conferences which took place in the previous years. Now, I would like to invite all the dignitaries to commence this international e-conference with the lightning of the lamp. Thank you, sir. Thank you, ma'am. Moving further in direction of today's International E-Conference, I would like to invite Dr. Neelam Singh, Head of the Department Department, IPEM Law Academy, to introduce the theme of the conference and welcome the gathering. Over to you, ma'am.
A very good morning to everybody. Can you hear me?
Clear.
I'm Dr. Vashishta. I apologize for a little delay because of this connectivity problem here. It took me a little while to be.
Dr. Neelam Singh, the head of the department, welcome you all. Our honorable chief guest, Professor Dr. V.C. Vivekanandan sir, Vice Chancellor of Hidayatullah National University, our learned eminent speakers, Dr. Enrico Bonadio, reader in intellectual property law, the City Law School, University of London, Colonel Dr. A.K. Vashishta, member, International Council of Jurists, and peer reviewer, Geneva Convention 4, Advocate Rodney Ryder, member, International Council of Jurists and peer reviewer of Geneva Convention, Advocate Vijay Kumar Makhyam, IPR attorney, registered patent and trademark agent for Indian Patent and Trademark Office, Dr. Anna Penfido, adjunct associate professor, the University of Northern Australia, Dr. Elfria, lawyer, mediator, trainer, ODR system designer, founder, and general director of Star Area, Mr. Abhinav Kumar Mishra, research fellow, Institute of Intellectual Property, Tokyo, Mr. Stephen, assistant professor, Business Law School, Germany, our secretary, Mr. Anupam Goyal, sir, our Director General, Colonel A.S. Malhotra, sir, our Director of IPM, Dr. A.S. Singhal, sir, our Dean Academic, Dr. Sugandha Goyal, ma'am, our prestigious academicians of the university, dynamic advocates, enthusiastic students, brilliant research scholars, energetic faculty members, ladies and gentlemen. It is a matter of great honor for me to welcome you all and express my gratitude for inaugurating this international conference on the theme Intellectual Property Rights, the Contemporary Issues, being organized by the Institute IPM Law Academy, India. The Institute, since its very inception, has made notable contribution to organizing national and international conferences. The presence of you all amidst us today provides tremendous encouragement to our organizing team. The presence of learned experts in this field is a matter of great satisfaction for us. We are grateful to internationally well-known experts from India and abroad for their participation. Thank you very much for being with us. Ladies and gentlemen, the world is experiencing multiple transitions. The old world order is vanishing, but the contours of a new world order are uncertain. The importance of intellectual property right was first recognized in the Paris Convention for the protection of intellectual property and the Berne Convention for the protection of intellectual property rights. Both the treaties are administered by the World Intellectual Property Organization, and India is a member to both. Besides these conventions, India is also a member of other important WIPO administered treaties and conventions relating to IPR. In the year 1994, an agreement on trade-related aspects of intellectual property rights emerged from the Uruguay round of trade negotiation, and final act of these negotiations created the World Trade Organization. India has been a WTO member since its 1st January 1995 and is also a signatory to the TRIPS agreement of WTO. To keeping the importance of this topic in the mind, we have started planning to organize the important international conference on the theme before 6 months. The conference will explore several complex interconnected themes, including jurisprudential aspect of IPR, the emerging issues in patent, trademark laws and challenges, legal recognition to various IPR. Holding such a conference would not have been possible without the invaluable support of all experts and paper presenters. I would like to plan on record our deep appreciation to the organizing committee in making this conference a reality. I hope this conference will help us to come out with the solutions and the alternatives of many issues which are going in the field of intellectual property rights. So once again, from the bottom of my heart, I welcome you all in this international conference. Thank you so much. Jai Hind. Over to you, Soumya.
Thank you, ma'am. Now, I would like to invite Dr. R.K. Singhal, Director, IPM, to share some words of wisdom. Over.
Good morning to everyone. Must be feeling great to be present in today's International E-Conference on Intellectual Rights, the contemporary issues. Why not? It is a hot topic of discussion today among all individuals, intellectuals, artists, innovators, and of course, industry professionals. Well, since in our audience we have students, industry professionals, academicians, so let me set the tone of the today's international conference. At the outset, IP, that is intellectual property rights, refers to the creation of the mind, such as interventions, inventions, literacy in artistic work, designs, and symbols, names, and images used in the commerce and the industries, and even an idea. It also includes patents, copyrights, industrial designs rights, trademarks, plant variety rights, trade dresses, geographical indications, and innovations. However, there are four types of intellectual property rights, that is patents, trademarks, copyrights, and trade secrets. I'm sure today this seminar, this conference would definitely give a lot of insights on the subject, and for sure may give answers to many queries of yours. In short, IP protection is critical to fostering innovations, and innovations that is the key of all types of development. Further, no one can ensure benefits from the inventions, from the idea creations or creativity that somebody is coming up, and research that somebody is included or indulged without having the protection. Therefore, we choose this theme which is really significant in the contemporary world. I again welcome to all dignitaries present over here. I also welcome and give my best wishes to the people, particularly the paper presenters who have come from all different part of the world, rather different part of the India and world as well. I wish them a great success of today's presentation. Thank you very much. All the very best.
Thank you, sir. Now, I would like to invite the keynote speaker, Professor Dr. V.C. Vivekanandan, Vice Chancellor, Hidayatullah National Law University. It's an honor for me to welcome you, sir. Kindly join us and enlighten this session with your valuable thoughts. Over to you, sir.
Thank you very much. Am I audible to all of you there? Yes, sir.
Right. Thank you.
Yes, sir, you're audible. So thank you so much.
Thank you. So let me first say a very warm good morning to all of you. Honorable Dr. Singhal, Director of IPEM, who addressed just before me. Dr. Neelam C, HOD of IPEM Law Academy. And apart from that, as I see from the screen, Dr. Arun Kumar Vashishta was joined us to deliberate.
So very
And
great.
all the other participants, students, and other well-wishers of IPM. It's an immense pleasure for me to be invited for this conference and to share my thoughts about the contemporary scenario of intellectual property rights. So let me put it this way. If I don't know whether the organizers could enable my share screen, I can even show a few slides, but I also can go extempore. For normally students do follow, slides much better than extempore. If they can do that in the course of my talk, I can share my screen. But to start with, as I said, intellectual property rights, if you really look, has assumed significant importance during pandemic, because in the last 2 years, the only priority or the foremost thing in everybody's mind is about the health. Health was always a priority, but we had other competing interests in a very fast world. And probably people even took it for a little bit granted. Health is something which is tackled. But that has become the primary thing the last 2 years, and also the impending new variant people are feeling. It is in this context we need to discuss about intellectual property rights than in times which is non-pandemic times. So let me, what I call as, so I'm going to share my screen with you so that it's easy for younger audience to, follow things, right? So let me put a few slides what I have, so it's easy for people to get along with what I am having in my discourse. So if I look at pandemic, I think all lawyers are prisoners of definition, whether we like it or not. And sometimes that is the way we move. So what's a pandemic? In a Greek thing, it says, comes from a Greek word, as usual English is Greek, Latin, and nowadays other languages, which are spread across large region, multiple continents worldwide, affecting substantial number of population, which is very different from epidemic, which we see quite often. There have been epidemic in different parts of the world, which the difference being, if one part affected, the other parts can, function, and that could be contained and that could be done. But in pandemic, the biggest problem, we use the word pandemic also in a meeting or something, everybody running away, we say there is a pandemic, there are pandemonium, we call it in English, which means we simply lose track what we need to do also in a big way when disease spreads. So let's keep that in mind before I go to connect it back to you. What I want to tell was two different era of IPR in the contemporary times. One is called pre-TRIPS, one is called post-TRIPS. The word TRIPS, all of you are following in different level of IP will know trade-related intellectual property agreement under the WTO, or called as World Trade Organization, which has the agreement. Now, this agreement of TRIPS came into force in 1995. 20 years it was negotiated, but finally the gavel fell on the agreement and it became enforceable from 1st January 1995. Approximately, we are talking around 25 years plus. India is a signatory. Of course, this agreement doesn't compel everyone. Whoever wants to be a signatory, we can be. That's a very complex subject of WTO. About the pros and cons is not for today's discussion. But to tell, post 1995, the landscape of IP changed. And that is what my slide says. Pre-IP, it was very diverse way we looked at IP. It depended on nation states' history and how does they shape and put their things, how to develop their economy, trade, and their inputs inside. It was also, different types. It's not necessarily uniform. It was also, in a way, I would call it democratic, because whenever we say democratic in a global sense, each country deciding for itself. And it was a rainbow shade. You had complete socialism to capitalism reflected in terms of IP creation, enforcement, and the results. For example, USSR had a different thing before it even broke away. China had a different thing. And then even within the third world, UK and Canada will be where public health is a priority. Even private practice of doctors is very, very, very limited. Contrast to that on the other side called United States of America, where private is something, a cornerstone in terms of an aggressive intellectual property, rights regime. So I'm only giving you pre-75. Post-75, there were 10 years time given, almost 5 years given for developed countries to change their legislation, and other countries like India, which is clubbed under developing countries, were given a period of 10 years. 2005 was the deadline for us to, what I call as, comply with TRIPS agreement, which we have signed. So what happened in post-TRIPS? If I look at my next slide for you, once you are a member, you have to be TRIPS compliant. That is 2005 was the timeline which India had to put its legislation from the older regime to the new regime. And what is that? TRIPS does allow exemptions on certain conditions, but TRIPS has to tell a country's parliament cannot decide what will be the exemption. So I call this as a regime complex has developed, which is setting the agenda, not only agenda, it is also the arbitrator if there is a dispute comes. So what is the net result, I would say, post 95 or even 2005? You have two types of narrative or discourse happening. One is the first world way of looking. Another one became a third world way of looking. The referral points and the clashes and the difference of opinion and the move to dominate, all that is from a first world to third world perspective. Obviously, India is a third world country with a 1.23 plus billion population, which is almost 1/7 of the world population. If you make 7 people to stand in a queue, one will be Indian, one will be a Chinese, and the remaining 5 will be 200 plus countries. And this is the reality of the world. And so what happened? There is no second world, that's called mostly the Soviet Union satellite, they vanished. Now, the question in front is, they say either you join the first world so that you are very progressive, or they say third world says, many of the, what I call as ideologues or authors will tell, no, this is all an unequal world, cannot have an equal race. That is the whole concept everywhere. So this is post-TRIPS for you. If I quickly move, what did India do after 2005 was an interesting thing. Being a professor and partly involved in the ringside of policy making in the government, what has happened is, we, as usual, third world problem is always not a very big debate about many legislations. In 2005, suddenly time has come, and otherwise we are a defaulter. So what did we do? We put all the legislations in place. Once you put the legislation in place, then we are thinking how to manage this legislation. That is what I call it as putting the cart before the horse. Whereas in the first world, horses have been trained for a long, and they developed a cart suiting the horse. Whereas in our case, what happened? We took the horse which has been designed and given to us, and then we are searching for a horse. Probably the cart is tall, the horse is shorter, or the horse is heavy, the horses cannot pull. And this is what I would call it about the dilemma, confusions, problems, what we are facing from a policy level, legislation level. I'm not telling we're always stuck in 2005. We were doing certain important things. What is happening, I will explain to you. So the whole question is there is a great march forward, they call, right? One of the important thing as people from this subcontinent, whether teachers or researchers of IP, in my opinion, should understand that there has been a carrot and stick policy. You follow certain prescriptions from the West, and then probably you will get investment. You follow that, you will get these goodies. This otherwise, I'm going to put sanctions. For example, all of you know in international law, trade, United States can put sanctions called 301 or Super 301. What is 301, Super 301? Simple. If any country's trade policies are detrimental to United States framework of trade policies, you will be considered as a hostile country as far as trade is concerned. They are not bothered about, it's not a military conflict, trade conflict. And what is that trade? Probably the problem is we know what trade is and we know what is the best model for the world. And this, I need not tell, many commentators will tell even within the United States that in spite of a world agreement, which is supposed to be a common rules and regulations to play a game in a ground, separately you are having another type of rules which is a separate rules and games sometimes, which happens. And that is the tension. India has been twice put under 301 for different reasons. For our first nuclear program, we were put under 301. Again, we were put under 301. And that had a lot of implications for a country which has issues. Having said this, now I just wanted to touch few minutes for people who are beginners as well as people who are already there. Please remember, fundamentals are very important, especially in patents. If you look at Lockean theory, Hegelian theory, Benthamite theory, I call, because we now talk about act and sections. No lawyer is worth can understand without knowing where the foundations come from. The foundations came from right to property, expanding right to property to intellectual property. Let me tell you, right to property itself is quite often debatable in many ways. And so intellectual property is no exemption, which needs always a revisit, relook, audit often. So people talked about natural right. People talked about property and personhood. And Bentham slightly modified and said greatest good for the greatest number. I don't mind going a Benthamite way. We need to look at every policy, every law from a perspective of how good it is for the greatest number. And when I talk number, who else can talk other than India, which is basically overburdened with huge population in a small landmass. And then naturally, we need to look at the policy in that perspective. Now, when I talk about patents or IP, please remember, IP is not simply we are talking a profit. IP is not an industry-driven concept. Let me tell you, state plays a role. What is a state? For a company, the shareholders are important. For a state, every citizen is important. Every citizen is a stakeholder. So you have incentive and access, and put together is what they call a development agenda of IP. The development agenda of IP is very simple, that one side we all understand nothing works like incentive. So you need incentive for investors, you need incentive for inventors, no doubt about it. That is how education system works. We incentivize you with grades, then only you do well. So that is okay. But at the same time, we also know in education, not just, who are flying colors will get it, not winners takes all. We are talking about access. A society which is highly divided into knowledgeable and not knowledgeable will eventually fall. Similarly, a society without access to a few things will fall, especially fundamental rights like health. That's why I'm bringing pandemic to you in picture. So forget about whether you can have the latest Mac Air or iPhone, right? Nothing will happen in life you don't have that. But you need your medicine. Your medicine many times is not your own making. It could be your genetic thing. It could be a worldwide thing. And look at pandemic. Did any one of us gave a red carpet to pandemic or the virus? No, it just spreads in air. It affects the rich and poor. They affects, young and old. So in that case, important is health. And how does health play with IP? With that last part, I'll conclude my talk by stating it is the World Health Organization which talks about highest attainable standard health. People may laugh, all this organization gives some very high funda thing. How is it possible? Let me tell you, if you don't aim high, you will achieve nothing on the ground level. And that is what health organization simply says. In a world of abundance, in a world which has evolved to a long time, where it can land people in moon, where it can put vehicle in Mars, this is not a great stuff. Giving health as a fundamental right to all. It will have its own modeling problem. It will have own its issues. Then it is in this context, how does IPR or intellectual property, especially patents, play a role? Indian Constitution again talks. Right to live is enshrined in Article 21. Every other law, including IP law, is subservient to your constitutional mandate. So this is very much clear. I am talking, you all know many laws, many cases. We keep on talking about these things, but how to move about it? Then that's what I said. Even though India was a kind of a reluctant player in IP, India did a tremendous role in 2001 itself by aligning nation states to declare what is called as Doha Declaration. Much before our laws came into place, we played a stellar role in terms of international negotiation, where not just for India, let me tell you, it is across those who have access problem, not just in India, but also in wealthy Western countries. There is a segment which has an access problem of, health or medicines. We played an important role, and this, what I put in the slide, you can always see in the internet. So if I look at finally, how do we move about future? That is my last few minutes. Who are the players? Government, political parties, business, academics, media, civil society groups. I'm not putting in a chronological order, but we all know government is all supreme and sovereign. It needs the biggest modeling role, which is done by government. Obviously, political parties with different shades of ideology form government, and it's very important. I am sometimes worried how much political parties inside think tank, down the cadre, they know something about IP and its positive or negative impact. I really don't know. That needs to be really taken up by political parties, because Indian political parties, let me tell you, are vibrant. Indian political parties are much more connected to grassroots than in many other countries, if you see. But at the same time, they need to be knowledgeable. And business, obviously, we know we are not in a communist era where they tried and could not succeed. We are in a mixed economy, you would call it, more of private, less of public sector now. But at the same time, business cannot function in isolation. Business needs to be morally and physically to be supported by the society. So it has its own thing. All your corporate social responsibility, all are designed in that sense. Then comes academics. Even though, interestingly, we have a time and kind of capacity to decide and talk many things, we all know that on action front, academicians cannot do, but we can create new generation. Then obviously media, is the one which disseminates. At times it does correctly, at times it confuses, at times it even jumps and gives you a kind of things which are definitely not correct in certain analysis. Then civil society groups is volunteers who come on their own, who sacrifice their time instead of earning which they are capable of, but they try to do. These are the capacity building players, in my opinion, who will really do. So if I try to conclude my discussion today, that this conference, what you do, this conference, what you are doing is, can I think, can I complete? I think there are some who open the mic and talk. So, point I'm trying to tell, so I'm happy to be part of this capacity building exercise, what you do, and the way we do as academicians, understandable, knowledgeable, and analytical, will be taken cue. It will be the input to government, parties, business, media, and even civil society groups. That way, I would like to, what I call as, place my strongest appreciation for IPM for doing this, attempting this international conference, trying to bring dialogue between us as well as the first world. I see quite a few, people who are speaking from there in your column, and then I think you have done a very good exercise of putting all this together, and it starts today. What else can I tell other than wishing all of you the very best for the conference, and then this outcome to be continued as part of your academic teaching, research, and advocacy and on IPM. And I also thank the HOD and then the other, important directors who chose me to come and speak and share my thoughts with you. Thank you very much.
Thank you, sir. It was indeed very insightful. I would like to invite Dr. Meenakshi Tomar, Principal, IPM Law Academy, to give the vote of thanks. Over to you, ma'am.
Thank you, Soumya. A very good morning, all. I propose the vote of thanks on this special occasion. First and foremost, I thank our keynote speaker, Professor Dr. V.C. Vivekanandan, Vice Chancellor, Hidayatullah National Law University, who despite of his busy schedule has found time to grace this occasion. We are thankful for our director, Dr. R.K. Singhal sir, for his word of encouragement. His ever guidance was always encouraging. I, Dr. Meenakshi Tomar, on behalf of IPM Law Academy, once again thanks all the dignitaries and wish all best compliments for this moment. Thank you.
Thank you, ma'am. Moving on, I would like to invite Ms. Shraddha Shukla, faculty at IPM Law Academy, to move forward with the technical sessions. Over to you, ma'am.
A very good morning and namaste from India. My name is Shraddha Shukla, faculty at IPM Law Academy, and I am here to moderate the technical sessions of the conference. As a business owner and entrepreneur, we should care about intellectual property because it is one of the most important business assets that we will ever own. Intellectual property, often referred to as IP, is a legal term covering various forms of valuable business assets. The three primary areas of IP are trademarks, copyrights, and patents. IP is often misunderstood and confused. To most people and businesses, everything seems to be a copyright when it may actually be a trademark that applies. To protect IP, you need to know what it is. Identifying what type of IP we are talking about is oftentimes the most difficult thing to do. In our first technical session, we'll be having a discussion around the sub-theme copyright, trademark, and design. We have 4 speakers in this session: Dr. Enrico Bonadio, Colonel Dr. A.K. Vashishta, Mr. Rodney D. Ryder, and Mr. Vijay Kumar Makkya. I heartily welcome all the speakers of the session. We'll have a questionnaire round at the end of each technical session. I request all the participants to kindly put their questions along with the speaker's name in the Zoom chat box. Well, without further ado, let me introduce our first speaker, Mr. Enrico Bonadio. Mr. Bonadio is a reader at the City Law School, University of London, where he teaches various modules on intellectual property law. He holds law degrees from the University of Florence and the University of Pisa, and is associate editor and intellectual property correspondent of the European Journal of Risk Regulation, as well as a member of the editorial board of NUART Journal. His current research agenda focuses on copyright protection of unconventional forms of expression, including graffiti and street art. It is an honor for me to welcome you, sir. Kindly join us and enlighten this session with your valuable thoughts. Over to you, sir.
Can you hear me now?
Yes, sir.
Yes, doctor, we can hear you.
That's good. Thanks for the kind invitation, for having me today with you. As has been stressed, I will cover the relationship or the intersection between publishing, book publishing, and copyright, right? I've recently made some research on this topic, and it's a topic that touches many academics' life, of course. May I ask the administrator to make me a host so I can share my screen with I can share my slides, if it's possible.
Yes, sir. Yes, sir. We're doing this.
Okay, good. Are you able now to see my slides?
Yes, sir.
Okay, so from the very beginning, I would say from the Middle Age, I would say book publishing has been very important because it has been able, and it still is able, to transform ideas into books, right? Or newspapers, because we have also publishing a newspaper publishing in addition to book publishing. So publishers are intermediaries between authors and the public, okay? This has been so for centuries. I mean, publishers have been providing services, important, crucial services, such as manuscript production, book binding, book lending, marketing strategies, book sales, and also other various book-related accessories, right? So they are committed, and their commitment has been very crucial in the history of the books, right? It is through the publishing process that the distribution of information can be enhanced, improved, and information value can be added to the creative exercise via, for example, marketing. So it's a kind of division of labor. While the authors, for example, the novelists or the academic, concentrates, focuses on the production, on the actual intellectual production, the book, publishers focus on all the other activities which are necessary to bring the book into existence and distribute, market the books, and many other services. So publishers, they do an important activity, and to make sure that this activity is done properly and successfully, of course, publishers rely on copyright laws, right, in order to prevent copies from being distributed to the market. So copyright is a legal tool to recoup those investments, and of course also to do to maximize profits. Of course, in the latest 25 years, I would say 30 years, the internet has created electronic marketplaces, and the books are no longer just seen. Now they can be heard too. You may be aware of the audiobooks that have been around for a while now. So retail, for example, has become e-tail. So almost any step of the publishing value chain, from producing the book, writing, printing, distributing, selling, and even consuming the book, has been impacted by the internet, the digital revolution. The news market as well, not only the book market, also the news market has also changed, has gone electronic. So this boom of new technologies, digital revolution, the internet revolution, has opened up new streams of revenues for publishers, because the same publication can be read, can be sold at the same time, electronically, exponential, right? And therefore also the costs of production and distribution are reduced. So from this perspective, publishers are saving costs, right? Of course, there are also challenges, as we all know, because as technology expands, piracy and unauthorized sharing of copyrighted material, books, newspaper articles abound in many countries. And the publishers often respond to these challenges by strengthening their copyright credentials, by strengthening their copyright rights, even contractually, and even lobbying with governments for new special IP rights. The latest, the recent EU publishers' rights for newspapers is an example. We will come back on this later. So also publishers wear many hats in this value chain. They are, at one time, they are managers and custodians of IP rights of others. They may own their own IP rights in some parts of the books. And also they have a fiduciary duty and the moral obligation to treat the IP of others with great respect, with great care, and to use their own rights to guarantee to recoup their investments. For those, of course, for us academics, we know that when we publish something, a book or a scientific article, we know that the publisher is very, very careful. No, they always ask us, are you sure that it is all yours? There is no drawing, logo, design, or part which is subject to IP rights of others. So publishers are very careful about that. And as I said, through the history, publishers have been always the strong contractual party in the relationship between publishers and authors, right? Novelists. They have always kept privileges. It is true that the first copyright laws, the Statute of Anne of 1910 in England, the first copyright law in the world. No, it is true that these copyright laws from the Middle Age gave authors, novelists, and not publishers the rights over their works. And it is true that in England, in the United States, publishers eventually had to accept the fact that they could not rely on a perpetual common law right over the book. Yet, despite this lack of formal initial authorship and ownership, publishers' powers have as often remained very strong and untouched throughout the centuries until now. I mean, publishers have always been able to put pressure on authors, novelists, poets, academics, journalists, any creator of a literary work that needs to be published with a view to obtaining the transfer of rights. So, although the statutes throughout the centuries formally gave ownership rights to authors, the way the market has always worked is that the publisher has often been able to impose on the author the transfer of the rights from the author to the publisher. Why? Why has the publisher historically been able to do that? Well, because what publishers are able to do is to offer something that novelists, authors rarely can do. Very important services, such as I said before, printing, binding, design and book packaging, distribution, marketing strategies, sale strategy. Authors, novelists, academics are not able to do that. And therefore, they end up being the weak party in the contractual relationship. And they end up accepting contractual clauses which transfer to the publisher a variety of rights and ultimately the balance of power to the publishers. Okay, so having said that, as a way of the introduction, let's now look at two relationships: the relationships between publishers and authors, and then the relationship between publishers and the users of copyrighted works. The relationship between publishers and authors may get tense sometimes. For example, publishers might be requesting the author to waive moral rights, at least in those jurisdictions where moral rights are waivable, right? This because publishers are able to exploit the book, the literary work, with more freedom if the author waives the moral right of integrity or attribution, right? They have more freedom to operate in the market if the author waives the moral rights. So during negotiations, publishers may attempt to try to offer, for example, a higher consideration, offer a higher sum for the creation of the book. So may pay the author more in order to convince the author to waive the moral rights, especially the moral right of integrity. This happens quite commonly during negotiations between publishers and authors. What about the relationship between publishers and users? So here the issue is to what extent copyrighted works can be used without the right owner's consent or not. This is a very sensitive issue, right? Here we talk about fair use, basically, under US law, or fair dealing under UA law in other common law jurisdictions. There are exceptions, of course, on which users may rely. Exception from criticism and review. Now, we are able as users to quote parts of a book in an academic publication or in a journalistic article if you want to criticize some other works. This is a very important exception, of course, because it allows people to use certain copyrighted works without the publisher's authorization. And disputes involving publishers have been so frequent in the course of history. And publishers, I mean, those disputes have often covered the use of copyrighted works for educational purposes. Of course, here two opposing interests may clash. Copyright, and on the other hand, the right of access to content, to information, to culture. In the US, since the very beginning of the 19th century, and even in the 20th century, and even in the 19th century, US publishers have often prevailed in these disputes. In this case, Macmillan versus King, the court found that an economics tutor's reproduction of experts from a textbook did not amount to fair use. Such reproduction of experts from a textbook were contained in the study notes that the tutor provided to his students. Kind of educational purpose. It is also not a surprise that the first fair use dispute in the US was between two publishers in the 19th century, Folsom versus Marsh. In this case, the court, delineated the famous 4 factors, the fair use 4 factors, which were then crystallized, codified in the 1976 US Copyright Act. It was a case about the use in a George Washington biography of some excerpts from his letters that had been previously published in a collection of some papers of Washington. Well, the judge here said, no, there is no infringement because there was infringement because significant amounts of the work had been taken and had diminished the value of the original work. Okay, and also the court added that a person, a copyright owner, needs not to reproduce the entire work to qualify as infringement. So in order to have a copyright infringement, the infringer, the defendant, does not need to reproduce the entire work, even just some parts of it. And then there was the famous Indian case, of more recent one, 2016, of which I think most of you are aware. Oxford Press, Oxford University Press, and others against Rameshwari Photocopy Service and the University of Delhi. Here, several publishers tried to prevent the photocopy shop in India from the regular mass reproduction and circulation of their materials in the form of study packs to students of Delhi University. Well, these very powerful publishers claim that what the photocopy shop was doing was not fair use because they were selling the course packs for profit, right? They were selling. The students were paying at the detriment of the business, the publisher's business, no? Because students no longer would buy the book, they would buy the copies at a much lower price, but still at a price. An economic exploitation. Well, the court disagreed, right? Court of Delhi, as you all know. I found this part of the ruling very interesting. Copyright, especially in literary works, is not inevitable, divine, or a natural right. Now, before the previous speaker was talking about natural right. It's not a natural right that offers an absolute ownership over the creation. Rather, it is a right aimed at stimulating activity and program in the arts for the intellectual enrichment of the public. Copyright is meant to increase and not to decrease the harvest of knowledge. Very important, right? And you may know that in this case, several academics, hundreds of academics, Indian and foreign academics, wrote letters of support for the photocopy shop, for the university photocopy shop, because they said, look, even if our articles, our books are published by these publishers which have taken action, they don't speak on our behalf. We want students to be able to access our articles, books, our content, without being obliged to pay a huge amount of money. So the fact that the very creators of the literary works in question sided basically with the photocopy shop is something telling, which send a very powerful signal, message, I would say, okay? And what about the current situation with COVID, right? More than 1 billion, more than 1 billion children in over 186 countries have been out of classroom during the global pandemic, especially last year, right? At the beginning of 2021. These are data from the World Economic Forum. So there has been an upsurge of e-learning, with most lessons being conducted via digital platforms. And the strategic response to this changing scenario has been for publishers to proactively harness the boundaries of fair use. So publishers, at least some of them, have become more flexible with open access policies. For example, some of them have allowed educators to post their publications on closed platforms like Google Classroom and Schoology until the close of the school year, which is a quite break from the previous customs, right? Here, publishers seem to be making preemptive strategic decisions to grant users access to their content, but of course under their own direction and subject to some limits, but it's still an important move on the part of some publishers at least. And lastly, I would like to spend just a few words on this new European Union right, a sui generis right for publishers, especially newspaper publishers, not book publishers, the so-called publishers' rights. It has to do with the news aggregators mainly. As you all know, news aggregators are platforms where news are aggregated, news from different sources, newspapers from all over the world, and presented to the user, to the internet user for their choice, right? Historically, news aggregators have been doing these without paying the publishers of newspapers, right? Of course, newspapers publishers have been quite annoyed by this practice, by this news aggregation phenomenon, because of course the result of this has been a decline in sale of newspapers, both physical and online, and therefore many publishers have basically lobbied the European Parliament, the EU institutions, to introduce a publisher's right, basically a compensatory right, a royalty right that publishers can rely on. So publishers are not allowed to prevent news aggregators from aggregate their news, but what they are allowed to do is to get compensation, so just a compensatory right. Now EU member states are in the process of implementing this right. Whether it will be successful or not remains to be seen. There are not really optimistic signs, because even before the 2019 directive, which created this right, was enacted, the publisher's right had already been implemented in Germany and Spain, and it was basically a failure. In Spain, Google, which in the past has been, still is, a very strong news aggregator, basically left the country because of the introduction of these rights. So we'll see in the next years if this right will keep his promises or will be just a failure. So this was my last slides, and I'm open to question, of course, and the comments. You there? Hello?
Yes, sir. Yes, sir.
Good. Did I speak too much? Was it too long or?
No, sir. Thank you for brilliantly engaging us in your discussion and explaining how IP acts as a strong business strategy for publishers. Thank you so much, sir. Now we're moving on to our second speaker. That is Colonel Dr. A.K. Vashishta, Member, International Council of Jurists and Peer Reviewer, Geneva Convention Court. Military judge advocate in courts martial for almost 20 years, former Dean of Maharishi Law School, Noida. He'll be presenting his paper on Journey Through IPR, a mesmerizing name. So please join us and edify the gathering with your knowledge.
Thank you very much, Radha. Thank you very much. A very good morning to everybody. First of all, since Dr. Enrico asked a question whether he was too long, I would say that no, he wasn't. It was, in fact, his discourse, his speech was very informative. It was full of so much of knowledge. And I feel very grateful and honored to have been a part of this platform. Thank you very much, Doctor.
Thank you.
Coming to my subject, Journey Through Intellectual Property Rights, a Mesmerizing Maze. I come from a discipline where the dominance is of the administrative law, and the having dealt with the administration in various capacities, and having seen a lot of ups and downs in the surroundings, of the environment. The intellectual property rights, the subject is relatively new for me, but very relevant and very important at the same time. I come from a land which was once known as an Aryavat, and where we believe and we all know that the Vedas were composed and later on compiled by Krishna Dapayana, the great Brahmarishi, the great Maharishi, the Vedavyas. So with my roots so deep and so profound background, I selected to talk a little philosophy on this subject. And I started my topic with a quote from Vivek Chudamani, which is a commentary by Adi Shankara, the great philosopher, the Shaiva philosopher. He says, Vedantartha vicharena jayate jnanam uttamam. It's by intense study of the Vedas, and the Veda means the word, the knowledge, the books of knowledge, that the wisdom is ultimately acquired. That's right. Can I request Dr. Seem or the organizers to have my presentation here? PowerPoint presentation? If you're going to have it, fine. Otherwise, I'll just carry on with the just like that. Ladies and gentlemen, well, before I commence my lecture, I must put on record my grateful thanks to the organizers, to the great seer, to the great scholar, Dr. Vivekanandan of the Hidayatullah Law School, Dr. Singhal, and the rest of the August gathering, and the great scholars and professors and teachers listening to my words here in India and abroad. A very good morning and greetings to you all. Ladies and gentlemen, whenever there is intellect, there is intellectuality, which connotes, can we have the next slide, please? Which connotes the interaction of mental faculties dealing with the finer aspects of life in society. We do understand that when the pristine knowledge came into being, the Vedas, there was no question of copyright. And even thereafter, subsequently, I have given the reference to the works of the Bard of Avon, whom we know by the name of Shakespeare. Then Wordsworth, his immortal daffodils, or the essays of Charles Lamb or Francis Bacon, or the great works like Abhigyan Shakuntalam by the great poet Mahakavi Kalidas, or the Ramayana of Tulsidas, or Srimad Bhagavatam of Vedavyas. We did not discuss, we did not come across any reference to the copyrights at that point of time. These are the immortal works or the Mahabharata. But as the developments in the field of the information technology started taking place, as the cultural and the social interactions started happening between countries and civilizations, the requirement of having a code of conduct with respect to the intellectual property, it was felt. Surprisingly, despite having very old and profound civilizations in the East, it's the European continent which has the roots as early as the 14th century in the IPR. And even today we see that the host of conventions, the conferences, and even the regulatory bodies, they have originated in Europe or the American continent. Today we are governed by, as I mentioned a short while ago, that it's a code of conduct. And a code of conduct to which all civilizations are subjecting themselves to. We in India, our parliament has been very absolutely alert and aware of the developments in the globe. And we had the Patents Act as early as 1970. Then we had the Trademark Act in the 1999. And not only that, prior to that, of course, we had the Companies Act of 1956. Not only that, we have also been keeping in tune, in sync with the rest of the world. And therefore, we have even been carrying out amendments and corrections and the course correction, midway course corrections to our existing acts. We have brought them in sync with the international, say for instance, the resolutions passed during the GATT, the General Agreement on Tariff and Trades. We even went to the extent of putting ourselves in line with the decisions which became a part of the final act or the Uruguay round. We follow the TRIPS, we follow the WTO. And prior to that, we followed the WIPO. That is our faith and subjection to the international understanding and the international moral conduct. I don't think I need to mention that what all is included in the intellectual property rights. We have the patents, we have the copyrights, we have the trademarks. But yes, I do wish to make a reference that how all this started. We talk about the law because whenever we talk about the intellectual property rights, we also talk about the law which is in place or which is required or which has come into being to protect the intellectual property rights. We take the example of Rome, the earliest among the lawgivers to the Western world. We got the decemvirs, we got the 12 tables, and then we got the Justinian Code to follow. These were the unique offerings from the Rome to the rest of the world. Now, how to go about these things when it comes to the trademark or when it comes to the intellectual property right? Well, my take on this is, will anybody be able to write the Justinian Code all over again? Will somebody be able to rewrite the Decemvirs? Will somebody be able to rewrite the Arthashastra of Kautilya? Well, to say that nobody would be able to do it would be underestimating the existing and the coming generations and their intellectual capabilities. But yes, as a student of literature, as a student of history, and a student of law, I definitely would say that they are going to be absolutely different from what was written while conjuring the Roman law or while writing the Arthashastra, what Kautilya thought. But yes, such profound ideas, those ideas which have had the influence over the world civilizations, which has changed the complete thinking of the world. These ideas have to be brought within the parameters laid down by the world community, where the people have unification of minds and an universal thought which is accepted by everyone without resistance. When we talk about business, we talk about trade, definitely. The trade and business is governed by rules and regulations. It has to be. And why is there a requirement of the rules and regulations? Can we have a bohemian society where we don't need any rules or regulations to guide our course? No, we cannot. The requirement of the law has been felt as the humanity has evolved from an untrammeled and unregulated society to the nations of today, which are governed by these respective ground norms. Some of us call it constitutions. When we have this system in place, we have the civilization looking inwards and asking itself, are we right? And when we say, yes, we are right, how do we say that we are right? We are right when we extend our arms, but we do not hit the faces of the others. There's a very popular belief that yes, walking on the streets cannot be avoided, but you are not supposed to be walking on the toes of others. Stepping on the toes of others is what has to be avoided. That's why these innumerable conventions, these innumerable covenants, and these regulations. What is the objective of TRIPS? What has been the objective of WTO? What has been the objective of WIPO? This doesn't need to be highlighted when we talk about the philosophy. But we have seen that the world community, by resorting to adherence, it may not be 100%, but substantially. It could be by way of enacting laws in their own parliament, as we did in the Trademark Act. We brought, by Chapter 4A, we brought it in sync with the international thinking so that we can join the international community, and be a part of what we generally refer to as the Vasudhaiva Kutumbakam. The whole world is a family. Yes, it is. I was elated when I heard Dr. Vivekanandan giving a reference to the pandemic and the pharmaceuticals and how the whole world came together to fight this menace. So we eventually, whether we believe it or not, we are a family. And whatever has to happen in the family, it has to happen without causing any damage, direct or collateral, to anyone forming a part of that family. And to that extent, the decisions which are taken, I was going through the the compilation of the final act, the Uruguay round. And I found each and every provision of the covenants contained therein so favorable to the humanity at large. Though it puts regulations, it puts certain restrictions, because we cannot have an unfettered society. We cannot have unfettered freedoms. The restrictions have to be dovetailed with freedoms. Thereafter, listening to Dr. Enrico Bonadio. Dr. Bonadio spoke about the execution part of the law, the regulation on the intellectual property rights. He spoke about the publishing business, the publishing trade, and he spoke very eloquently and very impressively. And yes, very sensibly too. Now, coming back to some of my viewpoints, so that I do not digress too much. On the international scene, we have the World Intellectual Property Organization. We had WIPO for short. It has been an international consortium through which public and private sector organizations, they use this platform to share intellectual property expertise with global community. I am compelled, I am persuaded to every time refer to our own scriptures where we say, Sarve bhavantu sukhina, Sarve bhavantu niramaya. Let everybody be happy. Niramaya. Let everybody be without disease, without ailment, without distress. And that's what we saw during the advent of the pandemic COVID-19. Can we have the next slide, please? The humanity has been working continuously, and that is the best part. That each one of us, and of course the responsibility lies more on us because we are educated and we are better privileged to have to have access to the literature, the philosophy available on the subject. That we share and exchange our points of view, so that those of us who sit together to find a solution to a problem, they have some material available to them for reference. And if not directly, at least indirectly, we are being of assistance to the international community. And we have the example of all this here right in front of us. There have been prominent treaties which I have listed out: the Paris Convention, the Patent Cooperation Treaty, the Strasbourg Agreement concerning the international patent classification, the Patent Law Treaty, and the Budapest Treaty. The international community has been going over and over and over and trying to find solution. Even it's trying to, the main purpose, I was reading the objective of WTO. The purpose of WTO, or the purpose of these treaties, these organizations, these programs and platforms has been to smoothen the trade, to smoothen the business activity in a manner that one is not different from the other. We read it in the Universal Declaration of the Human Rights that everyone on this planet is equal. We adopted it in our Constitution, in Article 14, and accorded equality before law to everyone without exception, a citizen or a non-citizen. As long as it's a human being, the equality has to be extended in treatment. So this is the kernel, this is the gut. This is the main objective of any human relationship. This is the objective which governs the framing of the law, whether it is a criminal law, or it is a civil law, or it is a law pertaining to trade and business and commerce. Dr. Vivekanandan mentioned about the Bentham's philosophy of the greatest good of the greatest number. Of course, that is what actually is encapsulated in those 4, 5 words, Sarve Bhavantu Sukhina, those 3 words. We have been following this philosophy in India. Ladies and gentlemen, though it's an international forum, and we are exchanging our views, which are universal and which are applicable in all situations. But it's very natural to have a lot of pride in your own self, in what you are. I'm very proud when I refer to my own books or to our own treatises and scriptures. And I find that we are extending this universal feeling, this feeling of brotherhood, and all of us living together, a peaceful coexistence, and even looking at the laws in the same manner. The other day, I was talking about the Geneva Convention, since I also happen to be a peer reviewer for the Geneva Conventions. We went to the extent of our parliament went to the extent of adopting the Geneva Conventions. We have a Geneva Convention Act. And it's not limited only to the Geneva Conventions. It is connected, it extends to every sensible and a practical thought of international community, how much ever far it may originate. But if it concerns the humanity at large, India, that is us, we the people, are there to accept, adopt, and adapt it to the best interests of everyone. Going back to the subject all over again, we have the TRIPS, as I mentioned to you. Now, these are the subjects in which the TRIPS deals with: the trademarks, the copyright, the geographical indications, the patents, the industrial designs, the layout designs, integrated circuits, and the undisclosed information on trade secrets. There is one very interesting aspect, in fact, which I came across while researching: the undisclosed information. Now, the intellectual property rights are applicable to the disclosed information which is shared in public. But there are certain things which are undisclosed. Say, for instance, certain formulae, certain recipes, or certain mindsets, or certain intellectual bents of mind, or certain philosophies. So these are not brought on the public platform. But should the regulations be extended even to the intellectual, even to those undisclosed informations? No, that's a question to be debated, and definitely for our scholars on board today, it's a subject it could be a subject of interest, and the ways and means how it should be, how those should be protected, as we call them, trade secrets. How should those trade secrets be protected? Could there be a covenant to that effect, an exclusive covenant, which is different from the covenants with respect to the disclosed informations? That's a point which we also can be pondered by the scholars on board today. Can we have the next slide, please? Now, WTO, I don't need to spend much time on this because we are all aware what WTO is all about. Though on the international scene, there have been some nations have not been very forthcoming in joining the thinking of the WTO. But today we find, as I've already recorded here, about 90% of the global trade and the global GDP is what is a subject matter of the WTO. And it's the world's largest international economic organization with 164 members. Let's have the next slide, please. Yes, As I mentioned at the beginning, ladies and gentlemen, that uh, I would generally be talking about the philosophy of the intellectual property rights. I find it as a very intriguing and a very mesmerizing study. And that's why I titled my lecture as it's a journey. When we travel through this and the uh, the labyrinth of intellectual property rights and what all has been done by the various countries of international community, uh, I find it really mesmerizing. I really find it very impressive. Uh, and yes, these are tangible rights, even though these are they generate at mind, at the level of mind, at the level of intellect, which generally is um, it is not an extraterrestrial attribute. It is definitely terrestrial and tangible and perceptible and 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 something which can be governed by rules and regulations. It cannot be allowed to be held at ransom by fanciful thinkings. Let's have the next slide, please. Yes, this is just for the information of the audience uh, that we had WTO, the WIPO, and the other conventions which have taken place from time to time at international stage have helped the humanity at large in every respect and also safeguarded interests of the inventors with respect to intellectual property. All new products and inventions are coming forth with the unfolding of each day as new discoveries are taking place. Yes, the scope, the dimensions of the intellectual property rights and the regulation, they are increasing by the day. It's like the sound that the waves they move in a circle and a concentric circle, of course, but it keeps expanding. It keeps expanding. And fortunately for all of us, that we have been able to almost overcome those factors which are threatening the civilization. And we have seen the recent one is pandemic, that the humanity eventually has got over everything. It has vindicated its belief in life. As I was just recording when I heard Dr. Enrico and Dr. Vivekanandan, that of late pandemic has been dominating the scene, the canvas of this universe, but the life and business dominated everything else. Yes, business and trade, though we generally talk about business and trade as an economic activity, but I personally feel that it is the most, it has got a very strong social and spiritual trappings. Trade, interaction of ideas is a trade of ideas, and the trade of ideas, the trade of philosophies. It cannot be called business, but well, as going into a philosophical aspect, everything on this planet is business. As we say, let's talk business. Anything that deals with the human existence has to have the color, the tinge of trade, business, and yes, of course, the commerce. And as long as the intellectual uh, property, the ideas, they keep generating into the beautiful minds of the people inhabiting this great planet Earth, there would be a requirement of regulation. And with all the wise there being there, we are lucky. We are lucky. Our hands will be full, ladies and gentlemen. We shall be kept occupied. And God bless all of us. God bless you, that you spend most of your time thinking about the welfare and the well-being of everybody else. I have concluded. There are certain books which I have written. I don't know whether the house would be interested in knowing about them. But anyways, I had some slides about them. So,
Thank you, sir. Thank you for giving us an intellectually elevating experience and wonderfully explaining how IP has always existed in our society since ancient times and how IPR has evolved all these years. Thank you. We now have with us
Thank you.
a leading technology, intellectual property, and corporate lawyer, partner with Scribble, a full-service law firm with an intellectual property, technology, and media specialist practice. He is presently advisor to the Ministry of Communications and Information Technology, Government of India, on the implementation of the Information Technology Act 2000. Please allow me to welcome Mr. Rodney D. Ryder, nominated as a leading lawyer in his areas of practice by Asia Law, Who's Who Legal, amongst other international publications. Over to you, sir.
Thank you, ma'am. Thank you so much. It's an absolute honor to be here and to be amongst you. If you could help me, I, for some reason, cannot share my screen, which...
Yes, sir. We have made you the co-host now.
Sure. Just let me now. Right. It's an absolute honor and delight to be here. I had a wonderful time so far listening to all the illustrious speakers before me. And I intend to be as painless as possible while I try to make a few points over the next 10 to 12 minutes as per my allotted time. The topic that I have chosen for today is part of our practice, a core part, dealing with online risk in intellectual property and managing intellectual property in the era of the new media, some of the threats face and what we do around it. So very briefly, I'm going to take you through the key provisions of the IT Act, read with the amended evidence law, intermediary liability and online marketplaces, and what we as lawyers do, dealing with trademark issues on the internet, and of course, monitoring intellectual property, monitoring brands, social media handles, so on and so forth. And if we look at the impact of the Information Technology Act, in a phrase, it is functional equivalence. It amended the Indian Evidence Act and the Indian Penal Code to enable traditional law to connect to the internet. Digital evidence and the cornerstone for digital evidence is found in the newly inserted section 65B. In terms of platforms, they have both safe harbor protection as well as a certain liability for their role as intermediaries. The intermediaries are liable for content to an extent relating to the distribution of content which may be violative or infringing intellectual property, prohibited content of any form, obscenity, hatred, hate speech, fake news, so on and so forth. And the Indian information technology law has evolved steadily from the year 2000, where it was enacted first, amended in 2008, the rule soon thereafter, and many interesting cases which have come to the fore. In terms of the intermediary or the platform, The platform has certain duties. All intermediaries have certain duties. They must appoint grievance officers. They must respond to notices. They must comply with takedown provisions. And if they do not, non-compliance would mean that the intermediary is liable themselves. What do? We help our clients recognize online threats in terms of counterfeit goods, unauthorized reproduction, the use of brands online, the creation of fake sites, fake email addresses, unauthorized applications, so on and so forth. So this is what we do as part of our organization, Scribboard, the law firm, and Metarion Knowledge Solutions, our tech, legal, and software company. So what does Metarion do? We look at counterfeit, or rather we search for, investigate counterfeit listings. We collect evidence. We check for infringing and abusive registration of domain names. We look at copyright violations online, anti-fraud monitoring and takedown, and of course, ways in which brand value can be enhanced. In terms of reporting counterfeit items, the first part is collection of evidence. And this can vary from screenshots of the website to actually ordering the goods and videographing the opening of the box to ascertain for sure and to give courts in India a good chance of examining evidence that is collected in a proper way according to due process and procedure. Issuing the notice under Section 79 and the rules, looking at responses and advising on further action. Further, under Section 65B, taking the proper steps to ensure that the evidence is collected properly. There is a method that's followed that is accepted and prescribed by the courts, that the affidavit answers the correct questions. We also look, and here for would-be lawyers and law students, it's important to understand the importance of Section 65B to see that the requirements of Section 65B are completed and completely carried out. We have an interesting collection of case law, starting with Dharambir, which famously said that the entire hard disk needs to be produced as evidence, the importance of mapping the hard disk, the importance of the hash function, the importance of computer forensic, reiterated in Navjot Sandhu. But any doubt as far as the affidavits, as far as the certificates required under the law have been put to rest in Arjun Pandit Rao and Kailash his case, and you have that as the latest deciding precedent by the Honorable Supreme Court. So what do we do for clients? For example, for Hike, we help them to monitor the Play Store, the Apple iStore, and to look for infringing apps. Once infringement is noticed, we prepare reports. In fact, we prepare regular reports. The client decides on the action which we are to take further. For MS Dhoni, we looked at crucial bits of infringement, not just people using his image on t-shirts or mugs, but more serious forms of infringement, people selling pharmaceutical products and deo sprays in his name, which would open a different set of liabilities. What makes a good trademark on the internet? The rules are pretty much the same. Generic and descriptive words, often as in the traditional world, do not hold or do not have that strength of protection. What's good, or rather what begins to be good, are suggestive marks, marks that take a quality and blow it out of proportion. Lux being suggestive that our beauty soap can make you as fair as light. A whirlpool suggesting that the inside of my washing machine or my washing machine is as powerful as a whirlpool. No one in their right minds would want to look as bright as light or wash their clothes in a whirlpool. These are just figures of speech, but excellent marks to begin with. Even better are arbitrary marks, which have no connection between the goods and or services and the word. For example, there is no earthly connection between an apple and a computer or an orange and a telecom network. So you have the ultimate words which are totally and fully protectable are words that are coined or invented, which do not exist in any language. So when George Eastman wanted a new brand that began with K and ended with K, his managers gave him Kodak. Kodak does not exist in any dictionary anywhere in the world. Similarly, for some of our brands, Metarion, Metacept, and of course, Scribord, which is the name of our law firm. Another very important and crucial aspect, not only of our practice, but in terms of online dispute resolution, has been the UDRP. It is the first truly successful global online dispute resolution system between two parties anywhere in the world. The beauty is that this is contractual and mandatory. That means when anyone registers a domain name, they agree as part of the registration agreement to this dispute resolution. There is direct enforcement because when a case is filed, the domain name is locked. It cannot be transferred during the pendency of the proceedings and is only transferred after the result. It is international. That means it is between two parties anywhere in the world, irrespective of jurisdiction. The scope, however, it is limited to cyber squatting. It cannot, due to the time frame, 45 days or less to handle a dispute, we do not see the UDRP going into complex trademark issues. Cyber squatting means that the complainant, the person or entity bringing about the complaint, has to prove three factors. One, that the complainant has trademark rights, that the respondent does not have trademark rights, and third, that the domain name is registered in bad faith to take advantage of, to misrepresent or misuse the brand. There are due process safeguards in terms of the neutrality of the forum and the panel, the notice to the respondent under the rules, the burden of the proof being entirely on the complainant, the independence and impartiality of the panel, as I noted earlier, the decisions to be reasoned, and an appeal procedure, along with, of course, administrative fees. So here are the system which is put in place by ICANN. One of the popular service providers is bullet point number 3, the World Intellectual Property Organization, which at present handles over 90% of the cases. There are thousands of cases filed every year. These are some of the cases which we've done over the years. Indian Oil, discovering that indianoil.org is registered by some Mr. Nitin Jindal who lives in the United States. The complainant proving that they own the trademark Indian Oil, that Nitin Jindal does not own or have any rights to Indian Oil, and it is being used for a pay-per-click website to garner ads on everything under the sun, including almond oil and massage oil. Hike discovering that a certain Mr. Jared Hanstra registered hike.app and is trying to sell it. Hike has trademark rights. Jared Hanstra did not, and he is misusing someone else's brand, offering it for sale. MS Dhoni, our client, along with Riti Sports, took on David Hanley, who registered msdhoni.com and made it available for sale. Again, MS Dhoni has trademark rights. We handle their trademark portfolio. David Hanley has no rights in MS Dhoni, and he is offering this domain name for sale. Similarly, in the case of Havells, there are no little or no rights for the other party to be using Havells India. It is well known that trademark lawyers, unlike copyright lawyers, do not have many provisions for fair use, especially parody. Compared to copyright lawyers, trademark lawyers have no sense of humor. People for the Ethical Treatment of Animals, who had their main site at PETA or PETA.org, discovered that there were people eating tasty animals. The ruling obviously was in PETA's favor. You cannot make fun or make a parody of somebody else's brand, although you can of their copyrighted works. For Indian domain extensions, you have the INDRP, which is very similar to the UDRP, and now during the COVID pandemic times has also accepted a totally online mode of filing, just like the UDRP has become the EUDRP. Our client Schlumberger, discovering that schlumberger.co.in is being misused by an anonymous person who calls himself Manoj Kumar, living in Bulandshahr in Uttar Pradesh, registered schlumberger.co.in and creates a fake email IDs. In fact, engineering students from all over India got emails from alex.juden@schlumberger.co.in. Alex Juden, the global human resources head of Schlumberger, sitting in Houston, Texas, hadn't the foggiest idea that someone was up to these kind of things over here in India. Similarly, for General Motors, who discovered that some anonymous gentleman, not his real name, registered General Motors Recruiting.in and even set up a fancy website that even looks a lot like the original General Motors website. So these are some of the things we do for our clients: manage their domain name portfolios, manage the registration services, and these are all things that are becoming important for us in the legal profession as well as for our law firm as well. So with this, I've come to the end of my little presentation. I hope it was somewhat interesting. I'll be ready to take questions at any time, maybe towards the end of the session. Thank you all so much, and my grateful thanks to the Institute, to everyone. Thank you for having me here and for this wonderful and kind invitation. Thank you so much.
Just for a little word, Mr. Rodney, your lecture has been really very, very impressive. In fact, I passed a comment to the organizers also just now that it's not only informative, it's very rich and legal and legal literature. You talked about the Navjot Sandhu case, you talked about electronic evidence. I don't think there was any field which you left untouched. Thank you. Thanks for
Thank you, sir.
doing so much of research. God bless
Thank you, sir.
It's
Thank
really
you, sir.
impressive.
Thank you. God bless you. Too.
Thank you.
Thank you.
Thank you so much, sir,
For
for wonderfully explaining.
how IP Act and evidence law run hand in hand to ensure safety from online risks in IP. Moving on to our next speaker, we have with us Mr. Vijay Kumar Makhyam, IPR attorney, registered patent and trademark agent for Indian Patent and Trademark Office. Mr. Makhyam graduated from Osmania University and has a master's with specialization in intellectual property rights. He is a guest faculty at National Institute of Micro, Small and Medium Enterprises, Hyderabad, National Institute of Pharmaceutical Education and Research, Hyderabad, and also a resource person for University College of Law, Osmania University. It is indeed my honor to invite you, sir. Please join us for the session.
I request Mr. Vijay Kumar Makhyam, sir, to please join us. Sir, you're not audible.
Are you audible now? Are you audible now?
Yes, sir. Yes, sir. You're audible.
Yeah. Can you help me with sharing my PPT?
Yes, sir. We're making you the co-host, but sir, you're not visible to us.
Not only that, I think there's a lot of echo in his voice, so he needs to do something. The other computer on at the same time, it appears to me.
Exactly. I'll do one thing. I'll remove the other system.
Yes, please do that, because that's what causes this echo, and it will spoil your lecture completely.
However, you might not able to see my video because my camera in this system is not working. Hope that is okay.
Your
No
speech is
issues,
clear
sir.
now, but yes, his speech is clear.
Great. Can you make me the co-host?
Yes, sir. We have made you the co-host.
Thank you. Good morning to one and all. I'm sorry for small hiccup in the beginning. Thank you for the organizers to be having me here today for this presentation. I think Rodney has fairly covered the complete gamut of trademark law. What is mark and what is a trademark and what is a service mark? I would like to go directly into the issues instead of discussing about what is mark and what can be called as a trademark and what is service mark and all. Now the issue is trademark and copyright and design law are interconnected and conflicting sometimes each other. An artistic image, when you make an artistic image, it can be protected as a copyright. And the same artistic image, if you apply it to goods or services to sell in the commerce, to run a trade, then it becomes trademark. And the same artistic image, if you apply through industrial process to an industrial product, then it becomes industrial design. It is the same, mind you, it is the same artistic work that can be protected as copyright, that can be protected as trademark, and then industrial design. When the conflict comes to trademark versus copyrights, copyright will be registered only when there is no similar registered trademark existing in the registry. This is as per Section 45 of the Copyright Act. The copyright registry makes it mandatory for applicants who file registration of a copyright in an artistic image to obtain a no objection certificate from trademark registry. It is a mandatory provision. Unless they submit the no objection certificate, that artistic image, which is capable of being used for products and services representation as a trademark, will not be registered. So the conflict has been resolved through Section 45 of the Copyright Act, saying that unless you have a trademark registry, no objection. If there are similar artistic images already registered under trademark law, you won't get a copyright. So having said that, copyright is automatic. You don't require registration. When you go for registration, there is this mandatory requirement. However, if there is no registration, still you can claim copyrights on the image. However, Bombay High Court recently has given a judgment for filing copyright infringement. It is not necessary for you to go and register the work. Copyright is automatic the moment you create it. So the conflict still persists between copyright and trademark. When you take a copyright versus design, the moment you apply the industrial article, the artistic image more than 50 times, as per section 15, it automatically ceases to be copyright. And if you have registered for design, you get design registration. If you have not registered for design, design rights are given only on registration, not automatic as copyrights. So when you register for it, then you get the registration of design rights for 15 years. Copyright is lifetime of author plus 60 years. However, design rights is only for 15 years. So once you apply it to industrial article, your copyright ceases. And if you have applied for design registration, it exists for 15 years. The requirement of the law is more than 50 times. The moment you make the 51st product of that artistic work is a design of a product, then automatically your copyright ceases and design acquires. Now, trademark versus designs, a particular design of a product, if it identifies the source of origin, for example, the Coca-Cola's contour bottle, that shape has been recognized as a product emanating from Coca-Cola company. So Coca-Cola company made that bottle shape as a trademark. Initially, they used to file design registration that lasts for 14 years, and then they again you come up with new design like that. They every 14 years they used to change it. However, they felt that changing it every 14 years is cumbersome process, and finally they adopted it as a trademark, and it automatically protected to them as a trademark perpetually. Trademark protection gets every 10 years renewed. Initially, it will be given 10 years, and every 10 years it renews as long as you use it in the market. However, there is a difference between trademark rights and design rights. Design rights are given to the product as such. It can't be used to, it can't be associated with any particular trade. However, for a trademark, the product has to be used along with the particular trade. For example, a bottle, it can be sold hair oil, it can be sold some pharmaceutical composition, or it can be sold aerated water or cool drink. So there are various categories of classification of business trades have been made under trademark law. NICE classification provides about 45 classes. 1 to 34 are products, 35 to 45 are services. In case of hair oil, it falls under class 3. So the bottle design is protected only for class 3 products, and class 32 aerated water or cool drinks, they are free to use that bottle. So like that, if it is a trademark, it is associated to particular product or process. Again, when it acquires immense reputation, it becomes well-known mark, then it is protected for all 45 classes. Now, domain names already Rodney has covered to larger extent. However, some more aspects of it. Domain names are considered as trademark, and in this digital world, e-commerce world, domain names are quite essential to be protected as a trademark. Then comes to generic top-level domain names like .com, .net, .biz. Nowadays, the more unique top-level domain names like .biz, .music, .tv, .bharat, .hyd, .hyderabad, and now more it is coming like .reliance, .tata, .infosys. So your registered trademarks can also act as generic top-level domain names. What if somebody obtains rights to own that generic top-level domain name of your registered trademark? So the UDRP policies, the UDRP policy provides that if a registered trademark owner has interest in a particular word which is registered to him, he can go and claim the registration, or if somebody registers it, he can stop him from using it. Now, domain names are also coming in local languages, regional languages. Then another issue is Google search engine. They have provided this AdWords. When you do a search for a keyword, you get 2-3 ads on the top. So that ads are based on the keywords purchased by the advertisers. So what these advertisers were doing is they are purchasing the prominent brands to sell their products. It is not a brand registered to them, but if you are searching, suppose I'm, for example, I'm a Bata store of shoes in Hyderabad, and somebody like Action or Nike. I buy Nike as a keyword, and when Nike is searched, Bata website will come on the top. So that is what Bata is doing, is trying to gain the market of Nike. So that kind of things, it is misused largely, and there are several cases filed around the world. Now, Google has come up with a policy saying that if a registered brand is being used as an AdWord, if the registered brand owner complains to Google, they will withdraw that AdWord from the AdWord business. And coming to comparative advertisements or parodies, I think Rodney also discussed on this. Freedom of speech and expression and commercial expression are quite important, and of late there are several cases happened. You can always say that your product is great, but when you are saying that, when you are deteriorating other person's product, when you are showing other person's product as lower, that is not allowed. And that disparagement is not allowed. If it is defamatory, it will be stopped. And that is what happened in the recent case of Harpic versus Domex, where Hindustan Unilever's product has been shown as not efficient than Domex. That has been stopped by Delhi High Court. Then another aspect of trademark law is trademark bullying by large companies. Large companies, whether they have a right or not, they file a frivolous trademark infringement suit, trademark and copyright trade dress infringement suit, and try to stop small companies to grow in the market. File 3-4 suits against them and make them occupied in the litigation and stop them from growing in the market. That kind of trademark bullying is prevalent in the market. So either claiming trade dress violation or some descriptive term. Maybe the description is required. Every trader is free to describe their products, right? So when I describe my products, you claim that is an infringement. So that kind of anti-competitive suits have been filed, and injunctions have been obtained, and small traders have been stopped by large companies. Likewise, small companies, which are fly-by-night companies, they start the company, adopt a famous brand and sell an inferior quality of products. And then when large companies come and file a case against them, they usually demand a huge amount to settle. This amounts will be more or less equivalent to the litigation cost. Litigation cost, if it happens 10 lakhs, they'll ask 7 lakhs or 8 lakhs as their compensation to close their company. So that kind of strategies have been adopted by small companies to make illegal monies. So either large companies as well as small companies doing this is bad in law. Then well-known marks, we already know that there are very famous marks. In the slide you are seeing the Play Store, Google, WhatsApp. These are not the software applications, but they are selling cloth stores in some market. So using well-known brands for dissimilar goods is called dilution of the brand. In India, we have there is a case called Daimler-Benz versus Haibo Hindustan, in which the Benz logo has been used by Haibo Hindustan for their undergarments, which is considered as diluting their brand, because of the Benz logo to undergarments is a dilution law. So the injunction has been granted. So however, this concept of well-known mark designed to protect the repute of the brand, however, sometimes it negates the entire classification system. That is, it is automatically protect all 45 classes. The moment your mark becomes well-known, it is automatically protecting all 45 classes and removing the classification system at all. The last aspect of my presentation is religious symbols and names of the gods as trademarks. India, being a secular country, it has several religions, various freedom of faith and freedom of expression has been guaranteed by Constitution of India. And even Supreme Court recently ruled that a bench of Justice Ranjan Gogoi and N.V. Ramana, they have ruled that names of gods or holy books cannot be trademarked and sell goods and services. However, large number of trademarks in India with God names. Balaji, Surya are the common trademarks you see in all the 45 classes, and people have registered that, and people are filing enforcement. When people file enforcement of their rights, which had religious names or religious symbols or God names, then the courts had dealing with that would feel it difficult to stop others from using that name, because of their faith or because of their belief, they were using that name or symbol for their business should not be curtailed, is what courts have observed in several cases. However, courts have also upheld the registered trademarks which are used for long for a particular product or service with the God name, that is allowed to be continued, and injunctions are also being granted. So these are the specific objects of trademark law. If you have any questions, I'll be open for them.
Thank you, sir. We definitely imbibed upon a lot of valuable information from your presentation with respect to the conflicts between different domains of IP. Since we're running short of time, so we'll keep this questionnaire round to minimum time limit. Our technical team has provided us with a few questions from the participants. I can see that Mr. Rodney sir has already addressed the questions. So the question for Dr. Enrico Bonadio is that in the current developing world, who should have the absolute right of IPR over a book, author, publisher, or user? And up to what extent can right and freedom to use of patent should be given? Repeat my question. In the current developing world, who should have the absolute right of IPR over a book, author, publisher, or user? And up to what extent can right and freedom to use of patent should be given? I think Dr. Enrico Bonadio is not here with us. So we'll move on to the next technical session. But before that, I thank all the eminent speakers of technical session 1 for joining our conference and gracing us with their presence. Thank you so much. Before we begin with our second technical session, I've been reminded to capture this moment. Therefore, I request all the dignitaries, our eminent speakers, participants, faculty members, and students to kindly switch on their cameras and wait for the technical team to take a screenshot of this gathering. I would please kindly switch on your camera so that we can capture this memorable day.
Look.
Thank you so much for your cooperation.
देख वीडियो कितनी क्लियर आ रही है आज है। कौन सी? ये दिखा रही है मैडम। ये किसका है? शर्मा की। मैम रो करिए हाँची को क्या हो गया सर? अरे योन अच्छा ये पेपर प्रेजेंट कर रहे हैं अरे नहीं पेपर प्रेजेंट नहीं
मजे लेने के लिए कर रहे हैं।
देव सिंह चौहान
अरे यार ये सेटिंग कहाँ है
क्या करना है मुझे बताओ
Awaited technical session of the conference, which is on the subtle jurisprudential aspect and patent issues. We have indeed exceptionally insightful and experienced group of people with us here today. So keep your mind open and get your pen and paper as we are about to embark upon the most scholarly journey of today's international conference. We have 4 speakers in this session: Dr. Anna Pintiado, Dr. Elif Thiria, Mr. Abhinav Kumar Mishra, and Mr. Stephen. I extend a warm welcome to all the eminent speakers. Again, we have a questionnaire round at the end of this technical session if the time allows. I request all the participants to kindly put their questions along with the speaker's name in the Zoom chat box. Our first speaker of this session is Dr. Anna Penteado, a professional legal researcher, a legal professional registered at the Trans-Tasman IP Attorneys Board since 2016. Dr. Penteado received her law degree in 1994 at Mackenzie University School of Law and master's from the University of California. From 2003 onwards, Dr. Penteado focused on international intellectual property rights theory and indigenous knowledge to examine the commodification of First Nations cultural assets. In 2009, as an IMUR scholarship holder, she was awarded her doctorate with her thesis entitled International Intellectual Property and International Environmental Law, a study of ownership of indigenous peoples' intellectual property rights. Her doctoral journey took her her doctoral journey took her studies to investigate a question of joint inventorship from multidisciplinary aspects of ancient history, philosophy, economics, politics, international law, intellectual property law, constitutional law, business law, and economics to dwell into the inclusion of cultural assets as valuable property. She has presented several submissions to the Australian Parliament and IP Australia in intellectual property legislation and public policy regarding indigenous knowledge and policy making affecting Aboriginal peoples' intangible rights in intellectual property theory. Currently, she is co-editor on a book about indigenous knowledge and climate change approved by Springer Nature. She will include 142 countries from the Southern Hemisphere in 2 volumes, a project focused on indigenous tribal peoples and local communities and their first evidence of climate change experience. We are truly honored to have you with us today, ma'am. I extend a warm welcome to Dr. Anna Penteado. Please join us, ma'am.
Good morning for everyone. It's good afternoon for me in Canberra, and I am very thrilled, to be joining you today. Thank you so much for your invitation. I was just wondering if I can put my slides. It's a very short presentation. Basically, I am looking into my paper, and I will provoke everyone to think a little bit out of the box. We had a beautiful first session that we involved law per se, and now we are going to go a little bit further so we can actually make look for the concepts, because my experience with law all those years has been that we are losing a little bit of our moral compass. And that affects quite well the way that we see law and the way we allocate rights and obligations for everyone. So I will just, if I may, have the slides on. I'm not sure if the slides are available. If not, I can keep going.
Ma'am, we have made you the co-host. If you're finding any difficulty, we can share it from our end.
I think would be nice if you share from your end, because I cannot find here exactly, but I keep going. So
all right.
Basically, my paper is about orality. Orality as a foundation to share knowledge. We have a theory that is very old, from 1950s. It's called idea submission theory. Normally, it's applied to copyrights. But if you think about the theory per se, it can be applied to many, many other fields in IP, in intellectual property. So I go, yes, in the name of, I'm gonna just say this because it's important for Australians and Australian Aboriginal and Torres Strait Islanders. In the name of reconciliation, I acknowledge the traditional custodians of the land on which I work and live, and recognize their contribution, their continuing connection to land, water, and community. I pay respects to elders past, present, and emerging. So thank you very much for putting the presentations. If I can go to the next slide. So ideas as useful content hasn't been quite explored, but we are seeing now in traditional knowledge that we can do this. Why? Because normally indigenous peoples, local communities, and tribal peoples, they don't have the writing as the main medium, but the orality. So they have actually groups where they share the knowledge, and when they share the knowledge, it's passed to another generation. What happens is that since we have times of colonization and after, we are looking into international human rights from the perspective of those groups. How can we effectively, I would say, can have their rights respected, especially when they are misappropriated in many, many ways? I would say through their culture, through their lifestyle, through their traditional medicine, and other things. So for that particular matter, I looked into the idea submission theory because it's about pitching ideas for people in a particular industry and receiving a compensation back for obviously pitching your idea. There are a little bit of controversial sides on this theory. When we look at the US, for instance, we have a case, Disney versus Wilder, is a case about the Paramount Pictures. A screenplayer pitched his idea to the Paramount Pictures via a secretary of Billy Wilder. For those that they like the movies of the 1950s, Billy Wilder was the most prolific director of movies. I mean, from Kirk Douglas to everyone and the celebrities he would have under his films. So he was very prestigious. However, this Victor Desby actually, he offered the idea for his secretary. And she said, no, you're going to have a compensation for that. No worries, you offered to me and I will pass the idea to director Billy Wilder. Well, she did. She passed the idea. And he decided to do a movie, but he didn't involve at all the screenplayer, I mean, Victor Desby. And he came out with a lawsuit that is very famous. Up to today, there are 200 citations to this case. Obviously, the screenplayer, he lost this lawsuit in the US. The fact that I could say today is that the public comments was very important in this case. So they said that the plot could have been used by anyone. However, if you think about it, that all those three people, the secretary, the director, and the screenplayer, they are all connected. You keep thinking, well, perhaps the idea was not exactly an idea that came from nowhere. It was an idea connected to the screenplayer and to the person that offered the idea. However, he was never compensated because the lawyer in Los Angeles was a very famous lawyer. He actually said, this is public commons. The idea of having a man that is in a cave is pretty much any idea, but they didn't quite see that the originator of the idea has been the one in touch with those two people. So what I did on this, I was looking at Dennis versus Wilder and looking at traditional knowledge, the way that we share every cultural content for everyone, for universities, for industries, for scholars, and how this content is used without prior informed consent from the parties that they gave the permission in the first place. And then there is another aspect, which is the aspect of not even considering to involve those parties in the idea submission theory. So my paper looks into a little bit more than law. I go to anthropology, I go to philosophy, I go to economics. Today we are talking about efficient law, but law is not efficient. Law is about fair and just compensation. So we have actually to rethink the way that we see law and economics. Those are two disciplines that one is profit, one is set of preferences. The other one should be as well, but should be also about the rights of the privacy and the rights of people that they give the ideas in the first place. So with this, I finish. I mean, here you can see as well that the WIPO had an initiative that is very well known, the GAP, but it's the World Intellectual Property Organization Secretariat on Traditional Knowledge, where they are studying the protection of ideas in this context that I just mentioned to you. I hope you enjoy, I hope you read the article, and I'm open for questions. Thank you very much for your attention and time.
Thank you, ma'am.
Thank you so much, ma'am, for imparting the views of your research on our conference and its participants. It was truly a delight to hear you and be witness to your session. Thank you so much. Our next speaker is Dr. Eleftheria, lawyer at the Supreme Court, member of the Thessaloniki Bar Association, and a doctor of law. She is also one of the first lawyers to deal with the institution of mediation in Greece since 2009. She also has an accredited mediator for civil and commercial affairs, ADR Group accredited mediator from the Ministry of Justice, Transparency and Human Rights, ADR Group in London, and INAGR in Chicago, USA. Eleftheria Papadimitriou is a pioneer in mediation, one of the first accredited and trained in electronic dispute resolution at an international level. ADR accredited international online mediator. While she has been additionally trained and certified in countries like the world renowned ADR Group, ADR Group accredited international mediator trainer. She is also specialized in the full range of commercial, civil, and labor law, with further specialization in intellectual property law, copyright industrial property, information technology law, and energy law. Please allow me to welcome Dr. Eleftheria. Please join us, ma'am.
Good morning from me as well, from Thessaloniki, Greece. I would like to thank you, first of all, the Institute, your Law Academy, for the kind invitation, and of course, the organizing committee for this exceptional event with, and it's an honor for me, real honor for me to be here with such an esteemed colleagues and scholars. So without further ado, if okay, I am the co-host now. I will share with you my presentation. Just give me a minute. Okay. I think you can see my screen now.
Yes, ma'am, your screen is visible.
Okay, and I will start my presentation right away. So, as you can see from the topic that I've chosen for my paper and this to present to you today has to do about intellectual property law and new technologies, and especially blockchain technology, and what happens when these two fields are interconnected and they are crossed. First of all, because we talk about a new technology, blockchain technology, I would like to firstly say a few introductory words. First, blockchain-like protocol, it was introduced back in 1982 by David Cham, which I think it was the forerunner of the blockchain technology. However, the blockchain technology, as we all now know it, it was first introduced in 2008. It was the famous by now Satoshi Nakamoto's cryptocurrency Bitcoin in 2008. But what is actually the blockchain technology? Blockchain is according to, as I may say, a definition is a distributed ledger technology, which is based on a distributed transactional database governed by a consensus mechanism and secured by cryptography. But this is, I would say, a very technical term. In more plain words, we could say that the blockchain is just a chain of blocks which are linked together via cryptography, and each new block contains a cryptographic hash of the previous block, and timestamp, and of course, a transaction data. The main characteristics of the blockchain technology, we could say that are could be summarized in two, and followed by the principles that apply in blockchain technology. First of all, blockchain technology cannot be modified in any way, and especially in a retroactive manner, as it is immutable and it's not managed or administered by a central authority due to its decentralized structure. So a very a main characteristic of the blockchain technology is the immutability and the decentralized character. So the principles that could say very briefly that apply in the blockchain technologies: trust, integrity, resilience, transparency, effectiveness, and safety. But where we can find this blockchain technology, because all of us know the Bitcoin, the cryptocurrency Bitcoin, and the use of blockchain technology in cryptocurrencies in general. But blockchain is more than that. It's a technology that is used already in finance, in real estate, in public administration, in the music industry, in cross-border payments, in supply chain and logistic monitoring, in original content creating, in tracking of music royalties, and so on. But the question and the topic of my paper is about this new technology, about the blockchain application in the domain of intellectual property rights. What has this technology has to offer in the registration, management, or even we could say enforcement of copyright, trademarks, industrial designs, and patents. Very briefly, because actually the time is we have a lack of time to go into very much detail. I would say that potential blockchain applications in the field of intellectual property rights could be, first of all, in the realm of counterfeit products. We could use them in relation to trademarks, designs, and patents, and of course, in the copyright domain. Very briefly, I will say a few words about the counterfeit products and trademarks, and I will go into more detail in the copyright section. In the counterfeited products, blockchain technology could combine with RFID technology, and this could be the answer to the traceability problem. In this case, the collection of data through the radio frequency identification devices could be more reliable in comparison to a manual collected data. In trademarks and designs and patents, there are a lot of scholars saying that we can use them, the technology, blockchain technology, for the registration, management, or enforcement of IP rights. However, in my opinion, this should be supported, I believe, by I think by the relevant legislative reform at the domestic level or at the European level, with respect to, it has to do in what domain we're going to apply the blockchain technology, because a very basic principle, at least under the European law, in IP rights, is the principle of territoriality. There are also international level, international and European treaties in European level. So I think in order to effectively use blockchain applications in IP rights, especially in trademarks, designs, and patents, which are registrable IP rights, I believe that there should be a legislative harmonization of IP law, which alone it is an ambitious project, let alone to be combined with blockchain application technology in this field. However, in my opinion, we could find very useful blockchain applications in copyright. Why is that? I think a useful tool to be employed, it will be a useful tool to be employed for the registration of copyright music, for example, books, plays, photos, and so on. Because as we can see, as we have already seen in legal practice and as a lawyer in Greece, an IP lawyer, many times copyright holders may face difficulties in even providing proof of the time of the creation of the copyright itself, or at the time of the creation, or of the copyright itself. And especially I have seen that in cases that I have dealt with, in law cases that had to do with co-authorship in collective works. The issue here and the question is how courts of different jurisdictions will treat such an untraditional, still tamper-resistant evidence. However, another possible application of blockchain technology in copyright could be with regard to authors. Authors could sell directly, for example, book authors. They could sell directly with no intermediaries their works to end users. This could possibly with application and deployment with smart contracts, which could be embedded into blockchains in order to facilitate peer-to-peer transactions. Blockchain then could validate the transaction, and the smart contract will execute the royalties payment. In this case, the only intermediary in this case will possibly be the platform providing the blockchain infrastructure, probably applying also a fee per transaction as a remuneration policy. For example, we have seen already such applications. You can see for yourself, for example, Swarm City. There are a lot of scholars in this case, and I believe this is the case where they are talking about a new type of sharing economy, like the Uber or Airbnb models have introduced. And there's a there's a term, if I may say, that is already being used. It is we can see the blockchain economy. Um, Finally, with respect to copyright, blockchain technology could successfully, I think, address the management problem of royalties in the music industry, especially in the field of collective management organizations, uh, because the latter could actually use such applications in order to have an effective, low cost, and of course transparent manner representing artists such as songwriters, musicians, or even singers. In the case of the blockchain technology, the decentralized nature could offer artists the trust, possibly lost in some cases. I think Greece, we have the same problem here with such CMOs. And CMOs in this case could provide a fair, transparent, and an effective administration of licensing the rights, collecting the royalties, and of course enforcing the songwriters, musicians, and so on their rights. Very briefly, before I reach my final conclusions about the intellectual property dispute resolution and the use of blockchain technology in this realm as well. First of all, I will say that ADR and ODR can be used for the resolution of disputes relating to digital copyright or digital content. We have seen that already being used, and if I may say, it is a successful example by the WIPE Arbitration and Mediation Center. These disputes usually include advertising, animation, broadcasting, films, database protection, books, and so on. The advantages, of course, is the speed. Okay, it's the low cost of the procedure for all the parties. We have, in the case of online dispute resolution of IP rights, we have sustainable outcomes, the confidentiality, which can be provided for both parties, especially in IP rights, in most cases it may be a very important factor for all the parties. We could maintain business relationships, of course, and we have an easy, low cost enforceable solution. The disadvantage, what is the major disadvantage of ODR? I would say, as in all types of dispute resolution, even in litigation, the disadvantage is that we face the problem of enforceability. And how could the blockchain technology, excuse me, when used in the ODR, combined with ODR, could help us solve the problem of enforceability? First of all, blockchain technology could be very effective in low value, high volume intellectual property disputes. For example, disputes concerning the collection of copyright royalties, music, photos, videos, and so on. But with the use of smart contracts that actually employ blockchain technology, we could use the enforceability issue. So for the first time with this application, the enforcement of a contractual obligation could rely not on a judicial, administrative, or other legal authority, but on parties' autonomy. It will be on parties' hands to actually enforce the agreement reached. So, having said that, I would like to summarize a few conclusions of the paper, of my paper. I would say that blockchain technology could become a key player when it comes to intellectual property rights. Intellectual property rights such as copyright that require no registration, I believe, in my opinion, could benefit more by the use of the blockchain technology in comparison to registrable IP rights such as trademarks, industrial designs, or patents. IP holders and IP organizations could better protect, manage, or even effectively enforce IP rights with the use of blockchain technology. But in my opinion, after all, I think we need time, because time will tell if blockchain technology will deliver what it seems that can promise, at least in the field of IP rights. And with these concluding remarks, I would like to thank you very much for your attention. And of course, you are feel free to reach me for any question after also the presentation and the session, and to direct me any question you may have. Thank you very much. I will stop sharing my screen and give back the floor to you, ma'am.
Thank you, ma'am. Thank you for brilliantly explaining the relationship of blockchain technology in protecting and managing the IP rights. Thank you so much. Moving on to our next speaker of the conference, Mr. Abhinav Kumar Mishra, LLB from Banaras Hindu University, LLM IPR and Human Rights from Indian Law Institute, New Delhi. Mr. Abhinav Kumar Mishra is a research fellow from the Institute of Intellectual Property, Tokyo, Japan Patent Office on Blockchain. So please join us for the session and enlighten the gathering with your valuable knowledge.
Thank you. Thank you for the invitation and this wonderful introduction. Good morning, all committee members and chair of this international conference, Dr. Anna, Dr.
Good morning, Mr. Abhinav.
Alcateria.
Good morning, sir.
Good morning, sir. Good morning, sir. Good morning, all, and welcome all, Dr. Anna, Dr. Alcateria, Dr. Stephen, from this session, from the technical chair and the colleagues. It was very interesting and delightful to listen to the address of Dr. Alcateria and Dr. Anna. Thank you. Now, it is also my privilege to address this auspicious gathering, and keeping in mind the paucity of the time, I would like to keep my address short if I could be given the chance to share my presentation. Okay, yes, I got this right. Thank you. So I shall be dealing with the topic new technologies, innovation, but keeping in mind the short stint of the time, I have tried to keep it pinpointed towards the artificial intelligence and the convergence of the technologies, wherein one technology cannot be enough. The technologies converge themselves together and provide us with the beautiful innovations, beautiful new examples to whom the human knowledge cannot reach, or the human alone cannot reach. So the new emerging technologies in today's time has been one of the backbone to the industrial and economic growth, including the technologies of the artificial intelligence, 3D printing, blockchain, Internet of Things, and the big data. We have seen that these technologies have been very important in the growth of the startup economic growth of the countries. Therefore, we have seen that they have had a high jump from multi-billion-dollar industry, and 4 times, 5 times external investment growth have been seen by them. Therefore, WIPO even 2019 had addressed the issues of the new technologies and the emerging technologies, including artificial intelligence, to address the issue of the protection of IPR in the report. Now, I would like to skip this basic introduction of the artificial intelligence, wherein I just wanted to describe it through one example, that there are the simplest example cases can be found in the use of the different websites, Netflix, Amazon, Uber, Google, wherein they are using the ML and the AI use cases to showcase the items which the people have been searching for. People want the same to use, and the simplest boring cases can be seen in the robotics industry, wherein the artificial intelligence is being used to synchronize the actions of the robotics and all. Then in the complex entertaining and the complex boring examples could be seen in the artificial intelligence, in the story writing and the creativity, wherein the Japanese artificial intelligence software has written the whole of a novel, and that novel is now being a hotcake among the geeks. And the complex boring can be the prediction and data analytics. The data analytics professionals can be using these kind of technologies to achieve the maximum optimum use of the technology, but that we would not be knowing. Alongside, when I discussed about the big data, the use of the big data is possible because of this new introduction of the artificial intelligence technologies and the softwares. Now again, blockchain is one of the technology which uses a data structure algorithm to provide you a tamper-proof environment, which was not possible till the date on this internet. So it is a kind of P2P technology which provided an umbrella term, which we have already seen in the in the lecture of Dr. Ria. So it offers us the tamper-proof, decentralized, and distributed environment, which shows us the different features of the democratic behavior and the power of the computing, which has been given in the hands of the people. Alongside, I would like to ask a question to the gatherings that what is common in all three? If we see the new technologies, if we see the computer and internet on which these kind of new emerging technologies are based on the blockchain and all, we see that the life and the fuel of these technologies are data. When the data is there, that has come from only the idea of the lot of processing power, when the devices and hardware has growth and achieved the best of the technology. The good algorithm, which is in the making and using the technology of the artificial intelligence systems and the machine learning, and alongside the use of democratic behavior over the internet of the people, which has given us the data and a lot of data. That lot of data has actually created a problem of managing them all, that how it should manage. Now, artificial intelligence, along with the different other kind of technology, has reached to the level of the AI 2.0, wherein Internet of Things, smart contracts on the blockchain, big data, deep and big knowledge of the data, 3D printing, face detection, NLP, these kind of new technologies have, furthered the growth of the examples wherein we can find out that human knowledge is going to surpass now the previous innovations, and new innovations are coming in. I would like to take quick two examples, the story of the next Rembrandt, wherein we can see the 3D scanning has been taken of a data, and then artificial intelligence software has used that data in the form of the 3D printing and rejuvenated the painting of famous Dutch painter Rembrandt. The famous Dutch painter Rembrandt was a painter who used to paint portraits. Now, one of the portraits was created by the AI by analyzing the artwork using the deep scanning technology, wherein the 15 GB of the data was taken from those paintings, all the paintings of the Rembrandt. With the help of the museum, they then analyzed the data. After analyzing the data, then they converted that data into the output form by using the 3D printing technology. In that, they could produce one of the paintings, the next Rembrandt painting, the same as the Rembrandt would have created. Now, we must keep in mind when the artists create these kind of paintings, they have their own stroke, they have their own, the handling of the pen, the touch to the canvas. Now, those touch to the canvas was measured by these deep scanning. So we'll have to keep in mind that three technologies at the same time work. The deep scanning of the camera, by which even the short measure that how and where the brush of the Rembrandt was working was taken in. Then the artificial intelligence software, which the humans could not have, analyzed it, and then the artificial intelligence received instruction to create a portrait of a male and created the same next Rembrandt. That next Rembrandt then was processed through the help of the 3D printing technology, wherein any person excelling in the recognizing the Rembrandt painting could have seen the painting and could have told that yes, it is the painting from the Rembrandt. The same happened. I would like to take the next example of the last speech of the Kennedy. We know that the President Kennedy was shot before the speech, just before the speech. Then Edinburgh-based company Cereproc took 831 speeches, reprocessed them. You took the help of the artificial intelligence software, reproducing the 2,590 words, the speech which was written for him to be taken before that he was murdered. This speech was processed by the artificial intelligence software, and now this speech, if I will show you, you can see this on BBC website. Now, when it is played, the people who have seen and listened the GSK can get that yes, it is the speech of the GSK. Now, these kind of superhuman activities which are being done with the help of the technologies, artificial intelligence, the other new emerging technologies, create certain legal questions about the authorship and also the infringement. If we see these six types means that these similar kind of examples, these are not the copy exactly, because Kennedy did not spoke in that speech, although it's a speech which has been created using the voiceover of the Kennedy. Similarly, in the example of the next Rembrandt, we see that the Rembrandt painting has not been made by the Rembrandt itself, and neither it is a copy of any of the painting of the Rembrandt, but it is the next Rembrandt addition to the painting in the same way as the Rembrandt would have created. So the question regarding the authorship and infringement is there, whether it could be said to be a copy. No, it cannot be said to be a copy, but still the question for the copyright law and before the IP scholars, that whether the protection should be provided to the Microsoft or the Rembrandt Museum. Here in case Cereproc, in the case of the GFK's lost speech, I like to take certain scenarios based on the law, wherein I would like to talk about the monkey selfie case, and then from the monkey selfie case we'll reach to the next analogy from the copyright law, wherein computer databases, the curious case of computer databases, and the new emerging rights or the celebrity right and the character right could be taken into consideration. I will skip these slides, and then the monkey selfie case creates a question before us in the mind, wherein the monkey selfie case, the court said that the work not created, not caused to be created by the author. Now, going on to the same lining, if we go, then herein the machine fed by the data by the museum. Again, the Microsoft processed that AI. A lot of processing which was required by the artificial intelligence software was required and was given by the Microsoft. The Rembrandt gave his data, the Rembrandt Museum gave his data. After the processing of the data, this painting was created. Why not give these two persons the right, the joint authorship, rather than making it open? Whereas the monkey selfie case was involving a monkey which took the selfie. So therefore, we'll go to the next step, the curious case of computer databases. In the cases of the computer databases, the computer scientists have been including the data from different sources. In using the different sources, then involving the modicum of creativity, the court has been of the different opinions, as the IP scholars would be knowing the state of the approach, modicum of the creativity. And in India, which we follow the combined approach, wherein the mere compilation are not protectable, the incurring significant labor or the money would become one of the important aspects to see whether the databases could be given a certain kind of protection. So if we see here in the both cases, the next Rembrandt and John F. Kennedy's last speech, to these both products, sometimes the significant labor and the money have been incurred by the persons, and therefore the protection could have been provided. Now, in the again, if we take the analogy from the character celebrity right, wherein the copyright law could not protect celebrity and the characters itself, but the UK courts and courts in common law countries have provided the protection on the basis of justice, equity, and good conscience, that their character rights should be protected as if they are the trademark, or the celebrity rights should be created and should be protected as if they are the trademark. The same concept and idea have been protected from the copyright law to provide the unjust, to undo and change the unjust situation. It could be said that AI works can be protected in two kind of situations wherein the AI has been co-produced. In the case of the co-production, the AI works are completely protectable. Wherein the human selection of the AI generated work have been there, the involvement of the human intervention becomes one of the crucial aspects to provide the protection of to the AI generated work. But if we go to the two different scenarios, the AI brute force, wherein the artificial intelligence in the machine has been given the access to data which is open over the internet and have been given the instruction to create the work out of that. Who would be the author of that? In the case of the Japanese novel, who would be the author of that? Whether the artificial intelligence, a machine itself, can be provided the authorship, or the authorship would be with the company who has created and caused that artificial intelligence to work. Then again, the last question would be about independently generated and selected work by the artificial intelligence, wherein artificial intelligence has been created by one of the parties, but then they create their own work from the data taken over the internet, wherein the data also does not involve. However, in my case, when we or any of the court is determining regarding the automation and the human intervention, alongside, the court should also keep in mind the very important aspect of data, while keeping in mind that from where the data has been taken, the court would or the person would be able to judge or identify and decide over the workings of the AI to these work. Still, it is a work in progress, and we'll have to see that wherein any of the court of the India comes in picture to provide a decision on. In some of the foreign jurisdictions, we have seen recently that the courts have taken a liberal approach in providing the authorship to the AI generated work, patentability to the AI generated work. Therefore, we can see and we can look forward for the future that yes, this kind of work could also come within the meaning of the copyright and other works and other IPR. Thank you. With this, I would like to conclude my presentation. Thank you.
Thank you, sir. It was indeed an engaging session. Thank you for introducing us to the dynamics of artificial intelligence and their emerging role in the IPR. Moving on to our next speaker is Dr. Stefan, professor at Vicarious Law School, Germany. He will be presenting his paper on the title Database Reconstruction Theory and the Invasion of Privacy, Differential Privacy. So please join us for the technical section.
Thank you very much for the introduction. If possible, I'd like to share my screen for the PowerPoint presentation, but for that I need to be able to, it's necessary to first stop the presentation that is ongoing right now so I can share my screen if that's possible.
Yes, sir, we've made you the co-host now.
All right, thank you so much. All right, thank you again. Thank you for the introduction. For now, we're going to look at the legal challenges of COVID statistics and the accompanying data protection law. The agenda for today is a very quick overview of how COVID statistics are important and relevant to everyday politics, especially in Europe right now, and it keeps the relevance keeps remaining high almost everywhere in the world. So it is necessary to look at the data protection aspects of it, because those have been kind of living a more insignificant life because it's not that important, considered to be not that important. However, we will look at it from a different perspective because COVID statistics are usually subject to generalization and anonymization, which according to legal standards is supposed to prevent any data protection relevance. The problem with that is the so-called database reconstruction theorem. That's not something that is actually very new, but it is just becoming relevant for statistics and therefore for legal purposes as well. We'll go over the quick mathematical basis for the database reconstruction theorem. This is just going to be a very basic overview, so nothing too complex. Then we look about the problems in the data protection area, especially the problem of re-identification. And then we'll just look at the possible solutions. There are basically two approaches we can choose. Either we're going about by legal approaches or just for mathematical solutions. Starting with the importance and relevance of COVID statistics. As we know, in general, statistics, they gather information of a very large group of data subjects. And what we're trying to do is able to provide a representative statistic of a large group that makes information about that group palpable and allows us to get an overview to address certain issues within that group. The content of the statistic can be anything. It could be an objective view, especially in COVID-19 statistics, but also it could be subjective representatives, polls about something, political views. And for the situation right now, the statistics are used to assess the situation of COVID and the environment. We're trying to get the best measures that adequately addresses the severity of the situation, and to assess the situation, we have to know the statistical overview. To establish the statistic, we use several mathematical methods. We're just using the data as the beginning, and then from that point on, we'll try to form the data into a more palpable idea. The data itself is unbiased and just collected in a huge method. Could be hospitals, could be polls, anything. We're just trying to get as much data as we can to provide the best result for the decisions. Once we have the statistic, we have a factual basis. The factual basis is usually the best justification for decision making, because you can provide a basis that is unbiased and again factual. And usually for COVID statistics, those are highly contested because those political decisions affect a lot of people and they can be very severe. It is an ongoing discussion on how effective that is. However, it's very important to establish the factual basis, because that works as an ultimate justification for those severe restrictions. Again, that is very obvious in the context of COVID-19. However, it's also important in census data collection, as we've seen in the US in the last year, because the US census data is necessary to provide the seats in the House of Representatives, which is a very political issue again, and therefore the data needs to be absolutely correct. Just as an example of how important and how detailed those COVID-19 statistics are, this is just a little overview of the area I've just been from in Dallas. As you can see, the amount of detail is pretty good. We have the population of the cases, the deaths, and the rates in comparison to other cities. And this is where I'm at right now in Hamburg, Germany. These are publicly available data on the Hamburg, Germany website. You have all the cases, the differences, people who are already vaccinated, people who have been vaccinated a second time. You have the deaths, and also you have a breakdown of the age groups. You see, we can see the cases from it's a breakdown in age groups and sex as well, and also a breakdown in the different districts of Hamburg. So as you can see, the data is very complex and very accurate as well. The problem with that is that, as we'll see in the next part, that the more data I supply, the easier it gets to use that data to reconstruct the underlying data set as a whole. But as for now, as we've seen, the COVID statistics have a lot of data as a background. The data they require is sensitive personal data because there are health issues, vaccines, the vaccination status is sensible data, it's medical history. The illness itself would also be a medical history, and their basis for political decisions, meaning that the statistics have to be absolutely accurate because it's required to justify the severe measures that are taken to combat COVID-19. They have to be publicly available because otherwise the public can't it is necessary for the public to see the data that the decision is based on. And finally, they have to be anonymized to protect the personal data. As we've seen, it's sensitive personal data as well. This is where the database reconstruction theorem comes in. As we've seen, we have the statistics as a background. They only provide general data. We're not given any specific personal information in the result. As we've seen, we've just given the information about how many people in certain districts are affected, how old they are in general, what gender they have, and so on. However, the law thinks that by giving only a general overview, there are no more personal connections. All the data is completely anonymized. It is not possible to get back to a single data set. The problem is that has been there have been studies to oppose that view, because if you're using multiple publications, so-called big data analysis, you can combine several statistics to re-identify personal data points. That has happened in multiple occasions. If you're using, for example, poll data of a certain area and combine it with the census data, you can easily identify certain specific data sets. And that has happened with hospital information in the US to reveal certain medical history just based on publicly available data. However, the database reconstruction theorem goes even a step further and says that at any point during the publication method of a statistic, you will have the problem that you will violate the personal right of any person involved in the statistics. And the more data I release in my publication, the more the violation of data protection increases. And even a single statistic concerns personal data protection, even if I have anonymized or generalized the data. To understand how that is possible, we'll look at a quick example. This is just something, this is fictional data. We're looking at a group of 7 persons, 4 of them are women, 4 are COVID positive, 4 have no symptoms, and 3 of the women are COVID positive. We're given the median age of each of these groups and the mean age of each of these groups. By applying the database reconstruction theorem, we can use just this set of data, the published amount, to completely reconstruct the entire data set that was the basis for this result. To see how that is possible, we'll just look at the first set. That would be, these are all the plausible combinations we have for COVID positive females with a certain median and mean age. Usually there would be hundreds of thousands of combinations, but given the certain data we have, we can reduce the amount of possible combinations to just these 36, and we can do the same with the combinations of all females, median age and mean age. And if we combine both of these results, we can see that just a couple of them are actually plausible, especially the one that is here marked in bold. That is actually the one that is correct in the end. So with all these information, we can reconstruct the data set that we've seen in the beginning. And that is a problem because data protection laws do not account for the database reconstruction theorem. Data protection law has, for example, as this is just an example for German and European law, it's only applicable if I have personal data, and if I don't have a possibility to identify a person, there's no personal data, meaning that a statistic legally contains no personal information and therefore is not in the scope of data protection law, which means that there is nothing preventing people from publishing a lot of data in the meaning of a statistic. Legal requirements exist in Germany, which require generalization and anonymization, and you're not allowed to publish single data points. However, in the case of COVID, that doesn't always work because in the beginning there were very few cases, and there could be a single case in a certain district, for example, and that would violate national statistics law. So the challenge we have is that the database reconstruction theorem allows us to re-identify always and in any case, and it's never possible to just it's never possible to get rid of the re-identification. It's always plausible. It's always possible to get to a plausible combination of data sets. So what can we do to prevent this from happening? The problem is that, as we've seen, these are the requirements for COVID-19 statistics. One possible solution we can have is that we address the accuracy and use something called data jittering. Another possibility is that we restrict the publicly available data, or we factually restrict that. And finally, we use something more than just randomization and generalization. Those are the existing solutions that we have. We'll look at the legal approaches first. Again, we have German and EU data protection law as an example. However, the problem is the same everywhere in the world. For example, in Germany, it is prohibited to cross-reference national statistics for re-identification purposes. That is something in the National Statistics Act. The problem with that is it doesn't apply to private statistics, and it also does not protect against a database reconstruction theorem because that only requires a single statistic and no cross-referencing. And again, is it really an effective method to prevent someone from illegally obtaining data and then using the database reconstruction theorem? If you're already criminally active, another prohibition won't probably affect you at all. Another legal solution would be to restrict the amount of data I can publish. However, the more I decrease the level of publication, that kind of does not entirely prevent the database reconstruction theorem from being applicable, and it goes against the transparency concerns of the public, of the political decisions, because the public wants to know what data is the actual basis for those restrictions. So purely legal approaches are questionable at best. We have mathematical solutions. We have those that are already implemented, randomization, generalization. I'm only publishing means. However, the problem with that is it's only the bare minimum. That's what we've been doing for decades already. And the issue is, again, it does not protect against the DRT as we've seen before. And it does not decrease the probability of solutions. The only thing that is new and that we've been trying to get into law for the last couple of years is something called data jittering. It uses the mathematical concept of digital privacy, and we're changing the data to some extent to prevent DRT from being applicable in a certain sense. It is a very difficult process and requires a lot of computing power to make that possible, because once you change the data, you don't want to change the outcome as well, because you still want to use the data as a meaningful result for the political decisions you're taking. As an example, as we've seen, that was the data set we had in the beginning. We're using data jittering to, for example, we are going to change the age, for example, of each person for the statistic purposes. The result would be the same, but the data set can't be re-identified because we've changed the set in the beginning. And that is helpful to a certain extent. So what can we do in the end when we're using data jittering? We have seen we can maintain the result of the statistic. However, we're essentially lying about the data points that we've created. Again, we have transparency concerns and the factual basic, especially with COVID-19. It is difficult to jeopardize public trust in political decision, as we've seen all over the world again. Therefore, jittering has to be used in a certain way, and it has to become less and less applicable the fewer data points we have. And as we've seen, the data points can be very few. So the only possible solution we have would be, in my opinion, we have to combine both of these approaches, and especially we have to legally implement the technical approach of jittering within the database construction theorem. So therefore, as a conclusion, we legally require the implementation of technical solution in published statistics, and that would be the best way to provide both of these results. And as we can provide the statistics as a basis for our political decisions, but also meaningfully respect and protect the data of those people involved. And with that, I thank you for your attention.
Thank you, sir, for enlightening us about the odds and risks while using machine algorithms using the example of census and COVID 2021 data. We are truly grateful for your presence. I can see that our speakers have been generous enough to answer all the questions in the chat itself. We're running short of time. So I thank once again all the eminent speakers of technical section 2 for joining our conference and gracing us with your presence. Thank you so much. I again request everyone to kindly switch on your cameras and allow us to capture this moment. I request everyone to kindly switch on your camera so that we can capture this memorable day. Thank you so much for your cooperation. Now I would like to inform all the participants and attendees of the conference that we have a short break of 5 minutes, and then we will commence with the paper presentations starting with track 1. Please stay connected, and in case of any query, you may reach your track coordinator.
A very good afternoon to you all. I am Varshika Pandit, student of IPM Law Academy. Once again, welcome you all to this international e-conference on intellectual property rights, the contemporary issue. The world is full of diamonds and gems, and we are having some of them here to read the business event. With this note, I would like to give my heartiest welcome to our chairpersons and people presenters of the upcoming track. Without further ado, let us begin with the first track of today's conference. The theme of this track is jurisprudential aspect of IPR and the emerging issues in patents. The chairperson of this track are Dr. Anna Mam, Adjunct Associate Professor, the University of Notre Dame, Australia, and Mr. Abhinav Kumar Mishra, Sir, Research Fellow, Institute of Intellectual Property, Tokyo. Please take note, each presenter has 5 minutes to present their paper. The first presenter of this track is Mr. Ashutosh Kumar, Assistant Professor at Amity Law School. He will presenting on the theme conflict of laws involved in bilateral investment treaty in India. Over to you, sir.
Thank you. I would like to congratulate entire IPM faculty members, distinguished guests here. Since we are allotted very small amount of time, so I will take opportunity, and it is a matter of privilege before the distinguished guest. And once again, I am thankful to all the dignitaries who are present. Am I audible? I need to just ensure one time.
Yes, sir.
Yeah. So my topic specifically deals with the conflict of laws involved in bilateral investment treaty in India. Let me tell you, whenever we are talking about the intellectual property rights, as Professor V.C. Vivekananda sir has already pointed out the importance, and all the distinguished gathering has pointed out blockchain, new emerging technologies and challenges of IPR. Now, one more thing which I am trying to highlight through my this research paper is India and the world. We are representing the developing countries, and developing countries' performance in the IPR counts a lot. And you all know, under WTO regime, we have a regional trading agreements. And why I have chosen this topic is that we, as a developing nation, are not on the forefront of intellectual property rights, patent, and all the innovations in our favor for development of society. As one of the key aspect, Doha Round Declaration, as Vivekanandan sir has also pointed out, the entire gamut of bilateral investment treaties start with the WTO regional trading agreements under Article 24. And Doha Declaration specifically pointed out that how we need to initiate the patent protection, copyright issues with respect to third world countries and developing countries. And here India is one of the stakeholders who pinpointedly, as we are going through the issues of public stock taking, patenting, and day before this yesterday, India has taken a leap forward against China in making of semiconductor. And semiconductor integrated design is also one of the aspect of we have in India a domestic law as well as international practice. So we are taking leap forward, but where we are facing trouble what we are facing is with respect to fragmentation of IPR treaties through bilateral treaties. As crores of rupees has been spent, we lost number of battles in international forefront. We have the Ericsson Vodafone dispute. Then we have seen Australian Whitewood Industries case where crores of money has been lost. And the stakeholders found, international experts presented, that the bilateral investment treaties are going to take leap forward in IPR. WIPO, World Intellectual Property Rights Organization, is also implementing the IPR from the bilateral investment model. So what is the bilateral investment treaty and why it is important for IPR? Because it depends upon the transfer of technology, trade, and entire gamut of economy is decided by IPR. So for the students For the communities, for the practitioners, it is very important to understand and focus on modern dimension of IPR has to be resolved in a technical manner, which is still absent at international forum. Why conflict of laws? If you will see the title is law are at loggerhead. Law of Africa, law of America, law IPR laws are not unified yet. Transfer of technology is one of the basic concern. And if you will see the paper, there is a sub theme which I have allotted because initially it gives only trade reflection. But let me tell you, this paper categorically covers the aspect of IPR with respect to trade investment. Bilateral, two countries are at agreement of sharing of transfer of technology, how their IPR has to be respected by each and other countries, and what will be its impact on global field. And international diplomacy is also going to counter these initiatives. And we need to, for day before yesterday, Director General of WTO focused on the specific issues of bilateral investment treaties. We need to think from the consonance and uniformity of the law. We have the Paris Agreement on the industrial artistic, and we have Berne Convention. We have many more IPR convention streamlining the process of protection of IPR. But why we are having IPR litigation? And these litigation, let me tell you, are very expensive, very expensive. India is also spending crores of rupees on this litigation with the foreign countries. Second is the investor points. Why investor is going to come and invest in India? And every country, specifically the third world countries and developing countries, are focusing on investment models. And we have, after 2013, learned a lesson. We lost the battle against Australian white industry case, Coal India case, and Vodafone phone tax evasion cases also. And somehow they all are interdependent on the model of investment India is following. Now, India, after 2013, halted its all bilateral investment treaties and gave a look that Asian model of bilateral investment treaties should be adopted. We were following the American model, we were taking the European model, and every country in the South Asia was mocking Indian model also. And that was a breakthrough in a negative manner. And that's why the focus is on how to make IPR, let it be the innovations, work for developing countries. And Doha Declaration, TRIPS agreement, trade-related aspect of intellectual property rights, focused in the consonance with bilateral investment treaty to provide impetus to the developing countries to really use their innovations, technology transfers, all the emerging dimensions of IPR, be it trademark, copyright, semiconductor integrated design circuit protection, plant variety. And let me tell you, the agricultural sector is mostly India is lagging. So with this, I will conclude that TRIPS has to formulate some new avenues to mainstream the say of developing countries, because developed countries are already marketing their IPR. Now it's time for protection of agricultural sector, plant varieties. We are losing our own traditional varieties. So what is there for the protection?
You to kindly wrap your presentation.
Yes. So with
as
this,
we are of short of
all
time.
yes, just I will take 2 more minutes. With all these litigation, the crux is that we will have to unify in the consonance, uniform, without fragmentation of international IPR in a, and WIPO, the role of WIPO should come forward to protect the bilateral investment conflict of laws. So with this, I will end my presentation. Thank you to entire team of IPM for organizing this wonderful international IPR, which is a learning ground and sure the students are going to be benefited. Thank you.
Thank you, sir. Our second presentation is IPR Issues and Challenges by Ms. Shubhangi Gupta, practicing advocate. Over to you, Shubhangi.
A very warm good afternoon to one and all present here. I would like to share my screen. Just a moment. Ma'am, I'm not able to share the screen. I request you to just allow this. So as my topic is IPR issues and challenges, first of all, I would like to explain that what we are actually talking, what exactly the IPR. So this is the intellectual property is basically a term mentioning to a brand, invention, designs, or other kind of information which a person or business has legal right over. Almost all businesses own some form of IP, which be a business assets. So basically the common type of IP, we all know that that's the copyright, patent, designs, trademarks. So what are the basic challenges towards it if we'll talk about that? So the basic challenge that is the Indian government for its part has been hesitant to enforce IPR to protect the interest in Indian residents in some illustrations. For example, under the provision of obligatory licensing, the government can force the patent possessor or get someone else to manufacture a vital drug in an emergency. Another tricky matter is Section 3D of the Indian Patent Act, which prevent large pharma businesses from ever gaining or enduring the patent in perpetuity by making negligible changes in former patents. As we all know, like IPR protection in agriculture is a sensitive topic in India. Under the TRIP's agreements subsidize like minimum support prices for agriculture produce and those for fertilizers, etc. have to be phased out since issues of food security and livelihood are involved here. Political parties are unlikely allow this to happen anytime soon. There has also been so resistance from farmers to the patenting of seeds by multinational corporations, and then the lack of awareness of intellectual property right. That is the basic problem in not only in India, wherever or whatever country we talk about. If people are not aware for that, then that's the main problem for any state, for any country. So the government of India has launched in 2014 the Make in India mission, has inspired entrepreneurs to launch their business with the help of government capital and oversees the investments of up to 100%. This footstep has led to an enhancement in people exploitation, their entrepreneurial assistance to begin a successful business. So Make in India mission also emphasizes on the importance of IP rights by endeavoring the to edit entrepreneurial minds of the importance and profit of their IP rights. And the next thing which I'll talk about, that is raising awareness on intellectual property laws for entrepreneurs. That is the basic thing which which the government should do, and we all should be aware with this. So entrepreneurs, business possessors must entrust lawyers, law firms specializing in the field of rights to guide and prosecute their trademark applications, understand or attempt to understand each and every step involved in prosecuting and registering a trademark application, and participate in negotiations leading to every step taken prosecution of their IPs. And of course, the approach of IP lawyers or law firms to get a gist of importance of IP protection along with the use of trademarks either before registering it or using the said mark for goods and classes not forming the trademark registration. Then the major change from process to product patent, that is, India is a part of World Trade Organization and a signatory of the TRIP. Therefore, the changes from process to product patent made in order to meet the TRIP's agreement necessities. As the name suggests, a product patent shield the end product while the process patent protect the manufacturing procedure of a creation. This reduces monopoly in the market in an emerging country like India, where IP work as a foremost source of monetization. And of course, one more thing, that reduce or remove the subsidies. There are numerous type of supports offered by the government of India. The subsidies are help provided by a state or public organization through money or services to meet the requirements of the people. But in order to meet the TRIP's agreement requirements, the government need to reduce, if not eliminate, these subsidies. Hence, maintaining a balance between subsidies and IP rights in India can eliminate some of the IPR issues in India. Now, the future forward government initiatives, if we'll talk about, so protecting IPRs can be a tough proposition in India, where awareness is low and enforcement is very weak, but protecting patent, trademark, and copyrights are vital for innovation and development. However, even with rapid progress on the industrial, scientific, and economic front, we lag behind countries like China. Good IPR protection will foster a culture of creativity and innovation that could help us close that soon. I would go for the conclusion. That is a very, you can say a simple conclusion, but if each and every person will understand it, then it will be very easy to understand that what exactly the IPR and why exactly it is important. So the IPR is a basic requirement to be a part of a local as well as world competitive trade, without dissemination of IPR knowledge. And just a second. Creating the innovative environment is really impossible. Essential for policymakers to include IPR in basic educational system. Promotes IPR registration by encouraging the innovators and creators. And of course, having all the capitals in terms of available raw metals. India already have these kind of things like the raw metals, cheap labors, innovation and creative dedicated manpower. No doubt that India and other developed countries will definitely harness its proportionate share in global trade, exploration, and intellectual property right. From dawn to dusk, a regular person comes across intellectual properties. The items have a very wide range related to food, shelter, clothing, things of survival, comfort, and pleasure. He deals with these assets, including waking up from a bed using a supportive mattress, sleep mattress, or pillows, getting a cup of Taj Mahal tea, to wearing a Nike tracksuits and shoes for morning walk, a modern bread or a Mother Dairy milk or at tea, or a cup of Nescafe, driving to the office in a Zen car, or using a compact machine, and coming back in a car in the evening, watching Sony television and setting alarm to wake up in the morning. So everywhere they are using these kind of products which have the brand and they have the patent and the productivity. And at the same time, he uses the item which are somebody's intellectual properties. These properties are protected by a copyright or a right to copying or a trademark. As the life of a common man, very closely connected with papers and goods that are under human property, protected by statute. Without the owner's consent, the copying, duplication, alteration, and illegal duplication of these objects, which constitute a serious offense. Therefore, for a common man, knowledge of intellectual property right is needed, because as I just explained in my conclusion, that from the day we start the day and we open our eyes till the end, like we are going to sleep, we are using everything which is someone else, which is made by someone else, and they have the right on them. So definitely people should know like what exactly the IPR and why exactly it is needed. Then only like we'll be able to cope up with the higher level of things, or we can talk about the globalized thing. So that is what all about this paper. Thank you so much.
Thank you, ma'am. Our first presenter is Ms. Khushbu Prasad, Assistant Professor at Amity Law School. She will be presenting on the topic compulsory licensing in India and international practices. Over to you, ma'am.
Thank you so much. First of all, I just want to congratulate IPEM University for organizing this international conference. Well, my topic is compulsory licensing in India and international practices. Before starting, I just want to give the overview what this paper is completely talking about. Well, the concept of compulsory licensing provides flexibility to the use of patent innovations for quick application with the certain considerations. As a concept of the compulsory licensing supports equity in the interest of the society at large. Since the inception of the provisions of compulsory licensing was made in Article 5A of the Paris Convention 1883. The intention behind for compulsory the licensing was to avail the industrial use of innovation to serve the public at large with balancing of the social interest as well as the individual interest of the patent holder, along with the parties to whom the compulsory licensing has been granted. Well, this paper attempt to simplify the common goals and the of the compulsory licensing in India with the status of compulsory licensing under the international mandate. Further, this paper will highlight the issue of challenging in the path of compulsory licensing of drugs, COVID vaccines. Well, with this introduction, I just want to give some overview related to the patent rights. Just a second. Patent is one of the form of intellectual property right available in industrial application domain. When any person, firm, or institution develop an innovative technique which is distinct, noble, and capable of industrial application to serve the society in the positive manner, then that the person, institution is eligible to find the patent, gets his or her work patented from the concerned office subject to the law of the land and get its registration on its name for its application rights exclusively. Now, the question of compulsory licensing arises that we can say that the compulsory licensing is the method to prevent misuse of the patent or the non-use of the patent by the patent owner. The notion of introducing the compulsory licensing is to allow the third party grant use of the patent acquired by the patent holder. As to move behind, the compulsory license is to allow the use of the product technology with the view of public utility and also to take advantage of the innovation such that it can be used for the society at large and the public health consumption. Further, the flexibility of guaranteeing the compulsory licensing is that the case in the case that the patent holder is not utilizing his or her exclusive rights involving the product or the technique for common good of the society under such circumstances. The patented product is called as unused product. For this, the notion of IPR is defeated, which is based on the societal benefit, as IPR asks for the social benefit available in the public domain. Thus, the grant of compulsory licensing is to entrust with the balancing of the interest of both individual who has developed his intellectual creation as well as the society which has innovation has been done. Thus, the compulsory licensing can be said as it grants which the balance between the interest of the stakeholders. Now I'll be talking about that the TRIPS and the compulsory licensing. The trade-related aspects of the intellectual property specifically deals with harmonizing the rules based on the IPR among the WTO members. The TRIP has also provided the impetus of the compulsory licensing mandate for developing the country's interest to safeguard the interests of the public order, morality, and the health. It undertakes the condition applicable for compulsory license and the mandate to access the drugs, health, and the facilities. As it has benefited developing the LCDs in having the access to costly the medicines and related the HIV and the COVID vaccines, etc. Now, why is the need that India and the TRIPS on the issue of compulsory licensing? Before 2005, when Indian Patent Act 1970 was not allowing the product patent and its compulsory licensing for availing the domestic market. As a result of which there was a confusion with respect to the pharmaceutical industries, resulting no compulsory licensing on the product. The patent as without the adequate patent protection. But after the amendment, the Indian domestic laws was amended and allowed the product patent protection and paved the way for compulsory licensing, availing to the product patented subjects, as under Section 84 and to Section 91 of Indian Patent Act deals with the terms and the condition of grant of compulsory licensing. Well, Section 84 of the Indian Patent Act provides to grant the compulsory licensing subjects for to the 3 years time limitation for not use in its limit. Further, it also includes the non-satisfaction, which is based on non-satisfaction, non-availability to the public, excess, high price. The above mentioned situations of the grant of the compulsory license can take with the proper care without affecting the right of the patent holder by providing the adequate protection. Well, we can say this, we can see in this, in the case of Bayer versus NATCO, the case is the landmark case of compulsory licensing, which is the rules of pricing on drugs, which are very costly and non-accessible to public. Well, with this, I want to discuss the compulsory licensing and the COVID-19. As compulsory licensing is a subject to the restriction and availability to the domestic laws mandate. As during COVID-19, Israel is one of the countries to approve the compulsory licensing of the vaccine for importing the patented drugs. The number of the countries relaxed the norms by granting the compulsory license for the emergency usage during the pandemic crisis. But still, the question of the compulsory licensing is not being used properly due to the trade restrictions and the barriers, as the vaccine and the pharmaceutical companies are reluctant due to the decrease of profit motive and the common consensus among the countries. Well, further, I want to conclude my paper on the basis of profit and the uniform consensus. As we all have witnessed that the crisis of the COVID-19 drugs and the huge price of drugs claimed the life of many peoples, which resulted due to non-accessibility of quantity as well as affordability. Even in such condition, the mandate of the compulsory license was not complied. Under all the flexibility shows non-utilization of the TRIPS flexibility favors in developing countries. The fragmentation of the laws and the lack of coordination among the nation to use this mandate to greater good life on the planet was compromised. And the diplomatic level, famously known as the vaccine diplomacy. Thus, the international law on IPR requires uniform and a coordinated approach on compulsory licensing implementation. If the issue of the compulsory licensing have been rationalized in true sense, it would have saved more life as well. The trade, instead of dispute or litigation on this on the issue of compulsory licensing, as IPR is meant for the greater good for the society beyond the individual interest of any country or the individual, as it serves in the balancing interest, well as even the international grant is very few and not utilizing the TRIPS flexibility. Thank you so much.
Thank you, ma'am. The next presentation is on the Patents Act 1970, an analysis of Indian patent law by Ms. Sonam Parasar and Dr. Monica Nair, Senior Assistant Professor, the Law School, University of Jammu. Their paper will be presented by one of the students at IPS, Shubham Gautam. Over to you.
Good afternoon to all the dignitaries, directors, academians, principals, and faculty members and colleagues. My name is Shivam Gautam and I am going to present the paper on behalf of Monica Narayanan and Shivani Pratana on the topic of the Patent Act 1970 and analysis of Indian patent law. Introduction. On the basis of type of invention and creation of human mind and their application, the intellectual property rights are classified as follows. First is patents, corresponding authors, industrial design, layout design of semiconductor integrated circuits, geographic indication of source, copyright and related rights. What are intellectual property rights? The term intellectual property is related to the human being applied for creativity and invention. Various efforts in terms of input of manpower, time, energy, skill, money, etc. are required to invent or create something new. The ultimate idea by which invention or creation took place is an intangible property of the person who took pains for the invention or creation. All inventions are not inventions under Patent Act. Section 3 of the Patent Act enlists the inventions that are not classified as inventions. Within the meaning of the Act, these may fall within the definition of the expression invention, but the Patent Act expressly excludes them from the definition. Innovations that are not inventions within the meaning of Patent Act and accordingly not patentable in India include: first is a matter of agriculture or horticulture, a process for the medicinal or other treatment of human beings and animals, and third is a mere discovery of any new property or new use for a known substance. Patents Act 1970 and Economic System Revolution in Medicine. Within the provisions made in the Patents Act 1970, the citizen of India got an opportunity to develop process. This led to a huge benefit in the economic growth of India, while drug manufacturers made use of the opportunity in manufacturing drugs in a bulk and selling at a cheaper price. Role of judiciary, legal regulatory acts Huffman La Roche Limited and another versus Shipla Limited. F. Huffman La Roche AG is a leading case on IPR in India. In this case, it held that where the infinite product process is a minor variant of the patented invention, there is an infringement of the patent. The court opined that in the present matter involving a life-saving drug, the balancing would have the factor in imponderables such as the likelihood of injury to unknown parties and the potentialities of risk of denial of remedy. Further, the court held that as between the two competing public interests, that is the public interest in granting an injunction to uphold a patent during the pendency of an infringement action, as opposed to the public interest in access for the people to have a life-saving drug. The balance has to be tilted in favor of the latter. Roche appealed against this interim order to a division bench of the Supreme Court. In April 2009, the court not only upheld the interim order but also imposed a penalty of INR 5 lakh for not making full disclosure about the specification of the product, whose patent is claimed to have been infringed amounting to patent of material value. Thank you.
Thank you, Shivam. Moving on to the presenter of this class, Mr. Ashish Kaushik, faculty, and Mr. Harsh Kumar, student at Institute of Legal Studies, CCS University, who will be presenting on the topic compulsory licensing, a move to ensure justice to common man. Over to you, sir.
Very good morning, all of you. I am Kumar, student at Institute of Legal Studies for the Central University, presented a paper titled Compulsory Licensing, a Mode to Ensure Justice to Common Man. Through a patent owner gets an absolute right to utilize, make, sell a product in its own country or to a foreign country and gets the time to revive the cost expended in producing the product, or if the invention is successful, it eventually turns into a profit. A compulsory licensing is a process in which government issues license to individual or companies without the consent of patent owner and also the other than patent owner to utilize rights of patent for sale, import or to make copies for the welfare of the society only. The concept of compulsory licensing is recognized at the both national and international level for the larger welfare of people. By this step, government try to balance the rights of individual and general human rights. According to Section 84 of Indian Patent Act 1970, mention the conditions for getting the compulsory license and internationally TRIPS agreement specified that license is only obtained for fair commercial terms. First intellectual property rights treaty held in Paris March 20, 1883 for the safeguarding of industrial property, and this treaty first time permits signatory nations to take legal steps providing for the approval of compulsory licenses to safeguard the misuse which might result from the exercise of the absolute right granted by the patent, for example, failure to work. According to 2019 World Intellectual Property Organization, on the exception regarding compulsory licensing draft reference document, 156 countries and territories around the world have contained the provision on compulsory licensing either in their municipal laws or a part of regional agreements. The basis of global patent program is the goal to give the founder the full right to exclude others during the life of time of copyright from any means to practice patented invention. This is the right to special exploitation of the invention is given to developer for the purpose of promoting innovative work and encourage innovation, maintenance. However, by all means, the aim is to be general welfare of people, and the reward for the developer is no more than fairness and money how to get the final result. To assure the early revelation of the innovation to the common people of the country is also another dominant consideration in industrial space. The patent systems of the USA and Great Britain are established on the notion of getting information for in order to get a valid patent. The secret must be fully revealed by the inventor for the welfare of whole community, and this is a mandatory condition. Since all information is diverged by the patent is open to use of general public when once the patent has expired. Paris Convention of 1883 is the first treaty that deals with the intellectual property rights. This convention of IPR established an alliance among member nations for the safeguard of and establish the property rights. Article 5A, Clause 2 of Paris Convention prohibits the misuse which might result from the use of exclusive rights given by the patent and every nation to take statutory steps providing for the grant of compulsory license. For example, failure to work. Due to COVID-19 pandemic has arisen the demand of several drugs worldwide, including in developing and also in the developing countries which have deficit capacity to produce vital medicines. Special patents are usually prohibited to access of less income people who need medication because of high prices. In addition, several WTO members, including developed countries, want to ensure that special rights do not prevent the production of adequate anti-COVID-19 drugs. As a outcome, many nations, including Germany, Canada, and Chile, have taken steps to make mandatory license, which is easier to apply. And lastly, I am concluding the whole paper that today many countries have taken steps to adapt compulsory licensing in their laws due to COVID-19 pandemic. A group of legislators recently introduced a bill in Brazil to allow the government to suspend all patents relating to medicines device that could be used to combat COVID-19. In Ecuador, a decision was made by the National Assembly to compel the national government to grant compulsory license and other measures to ensure free and affordable access to medical products and medical technology due to the declaration of medical emergency. Recently, to accelerate the process of compulsory licensing of medical products, Canada passed a bill which will be added to the list of countries seeking access to the pharmaceutical products and medical equipment, including the medical packages. With so many countries taking such measures and compulsory licensing is still in place, the biggest problem facing patents these days is the rising price that goes hand in hand in it specifically, has been heated debate on drugs for serious diseases like HIV, AIDS, and COVID-19. And thank you. This is all my question.
Thank you, sir. Next, we have Mr. Oman Kumar, practicing advocate, who will be presenting their topic on drug patenting in India, problem of public access to health. Over to you, sir.
Yeah. Good afternoon, everyone. I just need to know whether I'm audible. Can anyone confirm?
Yes, sir, you are audible.
Yeah. Good afternoon, everyone. So my topic for this paper is regarding drug patenting in India and the problems faced by the public access to health. Due to paucity of time, I'll just try to keep it as short as possible. First, I'll start with pharmaceutical patenting, what exactly it is. So at the point when pharmaceutical company initially builds up a medication to be utilized for a disease condition, it is first traded under a brand name by which the clinicians can endorse the medicine for use by the patients. The drug is secured under the protection of a patent, which implies that only the pharmaceutical company that holds the patent is permitted to produce, showcase the medication, and in the long run make benefit from it. The patent time period for the patent on a drug after getting approval is usually around 7 to 12 years. It is because the companies apply for a patent sometime before the clinical trial to survey a medicine's well-being. Once the patent has expired, the drug can be manufactured and sold by other companies. At this point, the drug is referred to as a generic drug. Coming on to the patent laws and pharmaceutical patenting in India, the Indian pharmaceutical industry has a strong generic base with almost 60,000 generic brands in 60 therapeutic categories in the market, which was nurtured by the then legal system concerning patent. The growth of the domestic pharmaceutical industry creates one of the success legends of the Indian economy. From the time being an import dependent enterprise in the era of the 1950s, the Indian pharmaceutical industry has achieved a global recognition in today's time as a cost effective generator of a high standard and high quality pharmaceutical product. Its yearly exportation turnover exceeds around $1.5 billion. This was achievable because at that time, no product patent system for drugs and pharmaceuticals existed. On January 1st, 1995, the TRIPS agreement went into force, which meant that India, as a member of the WTO, was required to abandon some of its long-held position of the intellectual property field to comply with the provisions of the TRIPS agreement. After the agreement, 5 years transmission period was given to India and 5 years in addition to amending the existing patent laws on patent protection of pharmaceuticals. And there several amendments were made in Indian patent laws. The first being the Patents Amendment Act 1999, which was relating to the increased exclusive marketing rights in the transition period. The second, the Patents Amendment Act 2002, which related to the widespread changes in keeping up with the TRIPS standard. And then the Patents Amendment Act 2005, which was regarding wide-ranging improvement before the expiration of the transition period. Among these, the most recent amendment is of 2005. It brought significant changes to the Indian patent laws. The most significant change introduced by the amendment is the omission of Section 5 of the Patents Act 1970, which provided that no patent shall be granted in respect of the claims of the substances intended for use or capable of being used as food, as medicine or drugs or related to medical prepared or produced by the chemical processes. Moving on, another part of the paper which deals with how the pharmaceutical patenting is causing problems to the public health and public access to health. Patenting has caused one major harm, which, as per me, which is regarding the increased prices of the drug. Drugs companies often abuse the monopoly of patents and use unreasonably high prices for patented medicines. Though this might not be that big of a concern for the developed economy, but where the healthcare system has been managed by the country itself, by the government itself, it is concern for the developing economies such as India, where we are trying to manage the economy. Mostly the economy is managed by the citizens themselves. In 2019, the Indian government stated that 6.7% of the population is still below poverty line. So 6.7% still counts out of the 1.25 billion people. It still accounts for around 8 crore people. Uh, in the year 2011, there was a Suresh Tendulkar committee which determined that on the basis of monthly expenses on food, education, health, transport, and electricity, a person who's spending around rupees 33 a day in urban areas and rupees 27 a day in rural areas live below the poverty line. So spending on medicine alone has pushed around 38 million people below the poverty line in India in 2011-12 itself. Of the 55 billion improvised due to total health costs, including lab tests and others. Move 10 years ahead, we have recent outbreak of coronavirus, which has seen the world order change completely. People had to adapt to new forms of lifestyle. The government was quick to respond with the lockdown, and pharmaceutical companies were very quick to producing vaccines to help us fight the virus. One such vaccine, Covaxin, is produced by the Bharat Biotech in collaboration with Indian Council of Medical Research, National Institute of Virology. As of October 2021, 110.6 million people of India have received this vaccine. And one thing regarding accessibility to public health about Covaxin and other COVID related drugs is that only due to the fact that coronavirus was declared a pandemic, that the Indian government came forward and provided these medicines for free and subsidized rate, which would otherwise have had been beyond 1,000 per dose. Had this been not the case, the vaccine would still be unaffordable for a good fraction of our citizens. Though patent laws are there to protect the ideas of the people and encourage them to innovate and produce something which gives a better tomorrow, on the same hand, the Indian government should make sure that laws do not deprive the poor and the needy of the basic access to healthcare. With this, I'll conclude with time. I'll come to my conclusion that with time, inventions and technology are also at a high pace. That is why it is essential to protect the ideas, creations, and innovations of people. This is the work of the patent laws that gives the right to the creator to earn profit from his creation. However, the scenes change when it comes to medicine, which are required by each and every individual, whether the country must achieve a meaningful balance between the utilization of patenting laws to motivate medicine companies to develop new medications for disease, and that cannot be treated today. And the opposite hand, the requirements of patients to profit from those drugs without bankrupting either themselves or state and federal budgets. With that, I'll conclude my paper. Thank you.
Thank you, sir. Our next presenter is Advocate Shatrunjay Shukla, partner at Vicky Sharidul and Associates, practicing advocate at Allahabad High Court, and Ms. Akansha, practicing advocate, will be presenting on the topic a study on alternate effects and applications of IP regime. Over to you, sir.
Hello, good afternoon, everyone. Hello. Please can hear my voice?
Yes, ma'am.
Hello.
Yes,
Good
ma'am, you are
afternoon,
audible.
everyone. Okay. I'm Akanksha Singh from Prayagraj. I have completed my LM and under preparation. Presently, I am practicing an advocate in Allahabad High Court. I am presenting my paper, which title is a study and alternate effects and application of the IP laws with special reference to admission to patent regime and alleged violation. First of all, intellectual is the inherent issue. Nobody is father of intellectual because information, knowledge, skill, intellect, and their fruits also travel from one place to another. So we cannot an injustice with the millions who have already had the idea and taken to benefit their societies and cultures through it. Basically, intellectual property rights depends upon the Western law, so it protects its uses. Here arises two questions: who get the own the idea when the question of economic benefits comes, and secondly, why would someone act on the idea if there can no gain associated with it? And we can talk about the vaccine, and the vaccination is one of the reason why human population was able to survive from many diseases. What we know about history of vaccination, it was the process invented by Edward Jenning in 1796. He invented first vaccine, but I think not is first in intellectualism. Yet the patent for the process and all its economic benefits were appropriated by the single individual. The greatest example was Dr. Jagdish Chandra Basu, who made a breakthrough in the field of radio communication. Yet just on the patent has been taken by Marconi. There are innumerable examples where regime of IPR has in the reality acted against the actual source and in favor of the one who has by superficial modification or obtained the right for such property. Let's come on the intellect is a property through which a mind rationally and logically finds way to solve the problems. However, not every solution has inherent, but it the every solution has inherent commercial value associated with it. Commercialization of intellect is the first major issue which come into the ambit of law. What intellect should be commercialized and what should be left out? Next important concept is intellectual property is property. Once a thing is a declared property apart from the coming into relation with the owner, it acquires certain trait, namely a legal right. With the regards of present discussion, these rights are generally proprietary right, with the difference that at the certain of the proprietary, the desire of compensation at not sole occupants as in the case of traditional proprietary right. Law relating to intellectual property, that is the patents, copyright, trademark, and trade secrets. Hence, the law of quite clear on the point that author, creator, in inventors should be the sole beneficiary of any sort of compensation or value arising out of the anything which is the declared by intellectual property. Right to protect right to protect the property in general freely available like right of defense in property in general, like under section 103, 104, and 105 of Indian Penal Code, and protect the property is under Article 300 of our Indian Constitution. But defense of intellectual property is often too difficult due to some reasons. Our access of the tribunals is expansionally difficult and often absolutely impossible. And next one is absence of municipal bodies that register IP of the basic level. And just we talk about the rights जो है, when we talk about rights, that jurisprudential basis of rights is often very vacillating. Rights generally counterpose of the duties. And ancient world was the opinion that the rights of nothing but power given to enforce the duties. And when the right to obtain a right across, even that was taken as duty of karma, which again itself originates from Vedas. Kritam me dakshine haste jayom me swa ahitam. It shall work with my right hand and endures with my left in knowledge, land, cattle, and sun itself, universe. And hence the ancient people were well aware of the worth of their efforts. And also Abrahamic origin, the core argument was the God has the created the world and God has become the master of it. And just example for the result of it, we can see the government of Robert Clive in India, 1765, where East India Company official have all the rights as to revenue, but bore no responsibility towards the administration. We are next is compiled innovation. By compiled innovation, defines those innovations which were merely compiled by the later researchers. These were pre-existent devices, methods which were being used by people science since time Emmanuel, and either not new or anything. New was merely superficial, such as the identification, synthesis, or stabilization, like neem for pesticides, drugs, and skill-like utensils making from the leaves of plants. We call that pattal and done. When we are discussing about the intellectual property rights, boon or ban, we will find out the core argument behind the supporting intellectual property right is the IP protection is the critical for fostering innovations. Without protection of ideas, business and individuals would not be reap the full benefits of their inventions, and would focus less on research and development. In the last, my conclusion is that my paper, the IP rights further prevent free experiment or uses, as in agriculture, where a farmer to increase his yield has to
Ma'am,
talk
I request you to
permission
kindly
from.
wrap up your presentation as we are short of time.
Almost I have done with single word. Big agriculture enterprises. Okay, thank you. Thank you so much.
Thank you, ma'am. Next presenter is Ms. Suchi Rai, student at IPM Law Academy, will be presenting on the emerging issues of patents, licensing policy in patents. Over to you, Suchi.
Hello, good afternoon, everyone. So the topic of my presentation is the emerging issues in patents, licensing policy in patents. Am I audible?
Yes, ma'am.
Okay, thank you. To give you an introduction, a patent for an invention is a kind of industrial property. The term intellectual property is also used, which is perhaps more appropriate since an invention is a product of the intellect. Development of technology and improvements in industrial techniques, which are so essential for the economic welfare of human society, depend largely on the growth of the invention capable of industrial application. In order to encourage the creation and manufacturing of new articles and improvements in existing articles or their manufacturing processes, a system of granting a limited monopoly to the inventors in return for the disclosure of the invention to the public has developed in almost all countries, and this is the genesis of the patent law. To talk about the evolvement of the licensing policy, primarily the compulsory licensing, it is mainly to stop the menace of abuse of patents. Abuse of the monopoly rights granted under a patent is a common phenomena in all countries. It may take various forms, that is, meeting the demand for the patented articles solely by importation from abroad and not by manufacturing the patented articles locally, thereby discouraging and prejudicing the establishment of new trade or industry, the development of an existing trade or industry, refusing to grant licenses to work the patent locally, imposing unreasonable terms on licenses, thereby discouraging voluntary licensing, imposing restrictive conditions on the use, sale, or lease of the patented articles by prolonging the patent monopoly rights even after the patent has expired. To remedy this, a system of compulsory working of the patent by the grant of compulsory licenses by a statutory authority and revocation of the patent for non-working has been adopted in almost all countries, including India. So the exclusive right means that the invention cannot be made, commercially made, used, distributed, imported, or sold by others without the patent right holder's consent. In India, compulsory licenses are authorizations given to a third party by the Controller General to make, use, or sell a particular product or use a particular process which has been patented without the patent right holder's consent. This concept of compulsory licenses is recognized at both the national and international levels with the express mention in both the Patents Act and the TRIPS Agreement. Here we discuss the requirement of a working of a patented invention as the same shall be commercially explored. Industrial application is one of the criteria for getting patent grant. It should accordingly be made or used in any industry. Section 83 of the Patents Act 1970 provides the requirements of working of patented invention and the consequences therefrom if the same is not worked in an industry. So the main aim before requirement of working is that the patents are granted to encourage inventions and to secure that the inventions are worked in India on a commercial scale and to the fullest extent that is reasonably practicable without undue delay. They are not granted merely to enable patentees to enjoy a monopoly for the importation of the patented article. The protection and enforcement of patent rights contribute to the promotion of technological innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users of technological knowledge in a manner conducive to social and economic welfare, and to a balance of rights and obligations, that the patent right is not abused by the patentee or person deriving title or interest in patent from the patentee. And the patentee or a person deriving title does not resort to practices which unreasonably restrain trade or adversely affect the international transfer of technology. Patents are granted to make the benefit of the patented invention available at reasonably affordable prices to the public. When the patented inventions are not worked or not available to public at affordable prices, then comes the provision of compulsory licenses. The provision of compulsory licensing is provided in the section 84 of the Patents Act 1970, which provides that at any time after the expiration of 3 years, From the date of the grant of patent, any person interested may make an application to the controller for grant of compulsory licenses on any of the following grounds. That is, the reasonable requirements of the public with respect to the patented invention have not been satisfied, that the patented invention is not available to the public at a reasonably affordable price, that the patented invention is not worked in the territory of India. So while deciding on the grant of compulsory licensing to the request to the applicant, the Controller General takes into the consideration that the patented inventions are worked on a commercial scale in the territory of India without undue delay and to the fullest extent that is reasonably practicable. That the interest of any person for the time being working or developing an invention in the territory of India under the protection of a patent are not unfairly prejudiced. Article 31 of the TRIPS lays out the set of conditions that govern the use of compulsory licensing by WTO members, the most important of which are the following. The entity applying for a compulsory license should have been unable to obtain a voluntary license from the right holder on reasonable commercial terms. If a compulsory license is issued, adequate remuneration must be paid to the patent holder, and a compulsory license must be granted mainly to supply to the domestic market. To give an example, the Patent Office in March 9, 2012 granted India's first ever compulsory license to Natco Pharma, the generic production of Bayer Corporation's Next Saver, that is a life-saving medicine used for treating liver and kidney cancer. Bayer sold this drug at exorbitant rates, with 1 month's worth costing around 2.8 lakhs. Natco Pharma offered to sell it around rupees 9,000, making it affordable for the people belonging to every stratum. And all the three conditions required under Section 84 were fulfilled, and the decision was taken for the benefit of the people. When we talk of compulsory license, another section from the Patents Act comes into the picture, that is the requirement of furnishing the working details of the patents to Indian Patent Office. That is Section 146. Working statement plays an important role at the time of compulsory licensing cases. With the help of working statements, which are required to be filed before the expiration of 30th September of every year, the details provided by the patentee or the licensee, one can estimate whether the patentee has fulfilled the reasonable requirements of the public by interselling the patent product at an affordable price or at a higher price, violating the Section 84(1) of the Patents Act. In this way, if the patentee fails to fulfill this important statutory information, the penalty in the form of compulsory licensing will take place. And it is also.
I request you to kindly wrap up your presentation as we are short of time.
Thank you. So the controller takes into account some more factors like the nature of the invention, the capability of the applicant to use the product for public benefit, and the reasonability. But the ultimate discretion lies with him to grant the compulsory license. Even after a compulsory license is granted to a third party, the patent owner still has rights over the patent, including a right to be paid for the product. Thank you so much.
Thank you, ma'am. With this, the first track of discussion is over. I request Dr. Anna ma'am kindly give her closing remarks. Over to you, ma'am. I request Dr. Anna ma'am to kindly give her closing remarks. I think, I think we Now I request the second chairperson, Mr. Abhinav Kumar Mishra, sir, to give his valuable thoughts.
Ma'am, are you there?
Yes, I was just wondering, do we have anyone else to present, or perhaps
No,
I?
ma'am. Ma'am, we are done with the track one, and we want you to give your closing remarks.
Oh, fantastic. So, first of all, I would like to say thank you very much for all the presentations. I was just kind of tweeting here on the side. A part of being a traditional knowledge student, I am very interested in pharmaceutical patent drugs. This has been another of the topics that I have been studying quite for 5, 6, 7 years. I left some remarks for the presenters, and I'm going to get started by Mr. Kumar, Ashtok Kumar, that he was the conflicts of laws involved in bilateral investment treaty in India. I think this is quite a good paper, very, very good paper, and very timely, because what we have to see is how international law is hindering sometimes what is supposed to be in the multilateral agreements. And this is so important because as soon as you have a bilateral treaty, that could clash with the multilateral agreement. So I was just wondering if he can give some thoughts on that on this paper. Another one that caught my attention, I don't know if the same paper with Mr. Kumar, if he has been looking at the investment projects from the World Bank in India. That will be very, very timely to have a look and see what are they proposing. Because normally what the World Bank, I mean, the Bretton Woods organizations, they do, they impose on countries, least developed countries, developing countries, they impose some conditionalities. And this is very important because as soon as they impose something, you have to follow that rule to have the money in the country. So I was just leaving this for him to think about it, if there is something that he can approach on his paper, or maybe he did, because I didn't have an opportunity to read his paper. So I go now for Ms. Gupta, the IPR issues and challenges. Very, very timely too. I just have a question of transfer of technology. And that goes exactly for the report of the Justice, 1958 report of the Justice N.R. Iyengar. This is a fantastic report. If you and your colleagues, they haven't read this report, it's 350 pages, but it's a very, very good report. They will, he goes into details in the patent system in India at that time, but however, he goes for UK, the US, Switzerland. So he does quite a good job on this report. I have been reading back and forth. So I would strongly recommend for anyone that is studying Indian patent drugs to look at this story. Yes, okay, Kumar. And I am happy to give you more feedback when time comes. I know that the time is restricted here, so I'm gonna go. Another topic on IPR issues and challenges. I saw that you mentioned that the government has to be involved and enforceability. Maybe I overheard it. Maybe it was not exactly what you have said. However, I work in the IPO here in Australia, and I must say to you, that is such a load of work that patent examiners and trademark examiners are under, that I think enforceability has to come from another branch of the government and has to be in harmony as well with the IPO, Intellectual Property Office in India. Have a look and see how many patent examiners you have for drug patents, because it's such a sophisticated matter. The claims are so sophisticated that you need at least, some days to look at those patent applications. It's not easy. It's not easy. So I'll leave you with this. The transfer of technology you're going to find on this report. And Justice Ainga says most of the transfer of technology doesn't, at that point, doesn't occur fully. So there is always a withhold of information from the patent owner. I just want to leave this there for you guys to have on the back of your mind. And when you study again, because see, all of the presenters, they identified the problems quite well. But we need a historical background of how those problems they came about. And I think the Iyengar report will be very, very good on that. So let me see what more remarks I have here, because I was just kind of taking notes. Compulsory license, I just put them in a book that I recently read. I read it specifically for Brazil, but I know that they have a point in India, and that she did quite a good job on identifying the historical, because you see, compulsory license is not only a problem of law, is a problem of the politics as well. The politics of the pharmaceutical companies, the politics that they are in play, and you have to recognize those. So while the AIDS, HIV pandemic, the threat of having a compulsory license in place put the United States a little bit on the back foot. Now the pharmaceutical companies are a little bit more savvy on this. Pfizer and Moderna, for instance, Moderna said that it wouldn't enforce her patent, but still she has a patent. So we are in the same problem. So the book is there with the ISBN. I believe that if you put them in on the ISBN on the website, on Google, sorry, you will find the book. Now, I have another comment from I think Umang Kumar, transfer of technology. And he was talking about the transfer and how much time you have to spend with clinical trials. I have some, and this is why most of the pharmaceutical remedy or medicines are quite expensive. I would challenge this view, and I'm going to tell you why. I have a paper about COVID-19 that I can even share with you guys, but I did a research about how much money the US, the United States, with Biden administration, and then after, there we go, and then after with, before with Trump, they actually put the resources into the US pharmaceutical companies. That was like $8 billion. Billion. I mean, something that I don't even have a sense of how much money is this. So I'm pretty sure the pharmaceutical companies had money enough to produce medicines. If you think about a medicine that 5 billion, you can have a 5 billion one product completely ready to go to the market. So there is so much money in the pharmaceutical companies for marketing. It's something that people don't look at. But in the US, for instance, if you go, you'll see it on TV, loads of pieces of marketing. So the money is going over there. I think we have to challenge the price from the point of view of, is this price just? Is this really what it costs to have medication in the market? I think that is something that one of your papers or the papers that you guys have presented could have a look. clinical trials is a problem as well, but I would say that the exclusivity for the medicine is a little bit more of a concern here. I would say that more studies are necessary on this. Now, yeah, so pretty much I finished my remarks. I would say thank you so much for your time. I enjoyed all the presentations, and I thank my colleague, Mishna, is there too. I think he wants to talk something, maybe, no? Otherwise, I will close. Is Abhinav there?
Now I request the second chairperson, Mr. Abhinav Kumar Mishra, sir, to give his valuable thoughts. Over to you, sir.
नहीं नहीं खा लिया खाना अभी बंद नहीं कर रहा आप खाओ नहीं खाने नहीं 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 बनाने मेरे को मना कर दिया हाँ
Due to some technical errors, Abhinav sir would not be able to give his remarks. I request Vanshika to move forward with the track 2.
Moving on to our second track of the day, the theme of the track is a copyright, a right of every creator. The chairperson of this track are Dr. Electria Ma'am, founder and general director of START EDR, and Mr. Vijay Kumar Mathyam, sir, IPR attorney, registered patent and trademark agent for Indian Patent and Trademark Office. Please take note, each presenter has 5 minutes to present their paper. Our first presenter of this track is Mr. Akash Khatri, practicing advocate, presenting on the topic of software protection, international instruments and trends. Over to you, sir.
Very good afternoon to all of you. I hope you can all see and hear me fine. If you have any trouble getting my voice, please let me know. So my topic is software protection, international instruments, and trends. So first of all, I'll start by defining what a software actually is. A software, in its simplest sense, can be understood as a set of instructions to the computer in order to produce a desired result. In other words, the program's explanations, procedures, commands are so designed or arranged that a particular task is performed, and thus it deserves a protection. It involves a significant contribution of time, labor, and skill. The most common method of software piracy are soft lifting, hard disk loading, unauthorized renting, etc. So when a software is copied, there's a noticeable difference between the quality of the original one and the pirated one. So it becomes very, very important to
You are
protect
not
it.
audible properly.
And there are huge
Sorry to interrupt, sir. I guess there's some technical error at your end. We are unable to hear you.
Can we have next speaker so that we can save the time?
Hi, can you all hear me properly?
Yes, now you're
Loud and
audible,
clear,
sir.
yeah.
Yeah.
Thank you. So I was defining a software. So software protection by way of intellectual property rights is very necessary to ensure that the creator is adequately benefited of his hard work. There are several international instruments which seek to extend the protection to the softwares. As we all know about TRIPS, the provision of the TRIPS agreement are the most extensive and the rigorous one in nature. It explicitly includes the computer software in its list of copyrighted works. Article 10 of the TRIPS agreement states that the member states should protect the software, whether in source code or object code, as literary works under the Berne Convention. However, the efficiency of protection offered by such copyrights is adversely affected by the idea expression code. So the algorithms, which are mere ideas, cannot be protected under copyright law. Source code and the object code are the products of algorithms. They are the expressions of the ideas contained in the algorithms, and therefore they can be protected against copying under the copyright law. Then we have the Berne Convention. Berne Convention became effective on the 5th of December 1887, and thus it forms the basis of the most international instruments of the protection of the intellectual property rights. Unlike TRIPS, Berne Convention does not explicitly extend the protection of copyright to software. But what should also be kept in mind is that the works enumerated in Article, the works enumerated in Article 2 of the Berne Convention, they are not exhaustive. So Article 2.7 of the Berne Convention extends the protection of work of applied art dependent on domestic legislations. Then we got the WIPO Copyright Treaty. The WIPO Copyright Treaty is a special agreement under the Berne Convention which deals with the protection of work and the rights of the authors in the digital environment. Article 4 of the treaty expressly states that the computer programs are protected as literary works within the meaning of Article 2 of the Berne Convention. Such protection applies to computer programs, whatever may be the mode or form of their expression. Article 6 to 8, they equip the author with the right of distribution, right to rent, right of communication to the public. And now I'll be discussing some trends on an international level and global scale, which relates to protection of softwares. First, we are going to discuss about the United States of America. The issue of copyright protection for software products in the United States has its origin in the 1908 case of the White-Smith Music versus Apollo Company. In 1980, an amendment was made to the Copyright Act to include the provisions for the protection of the copyright softwares. The new amendment gave the owner a copy of protected programs two rights: the right to copy or adapt the program for use and the right to make backup copies. A copyright holder under the current law is afforded 5 exclusive rights. One of these rights certain that some are particularly relevant to the holder of the copyright for computer softwares: the distribution right, the reproduction right, and the adaptation right. In the United Kingdom and Northern Ireland, the software are protected under the UK under degree of creativity, which is very necessary. This standard requires that the idea begins with the author. The Copyright Amendment Act of 1985 specifically confirms that a computer program is a literary work and thus deserves protection. The new amendment also enhanced the criminal remedies of the Copyright Act of 1956 for cases of computer program piracy. Now coming on to
Sir, I
India.
request you to kindly wrap up your presentation.
Yeah, sure. All right, as we are all pressed for time, I would like to conclude by saying that I find that the Indian software industry has created a very new and valuable intellectual property in the past. But the rate of patenting and the copyright activity has accelerated dramatically in the last 2 years. Some copyright standards are equal to the world's most stringent ones, but the others are not. The enforcement is the principal weakness in our country. So both standards and enforcement are likely to be improved in the future, but immediately I don't think it's going to be that fast. So in conclusion, I would like to say that India has undoubtedly made great strides in the protection of computer softwares through copyright law, but the protection through patent law still remains at a nascent stage, as the strength of protection offered by patent law is much higher than that offered by copyright law. It would be of a great interest if attempts are made in this regard. Thank you for giving me your valuable time. It was a pleasure sharing this research paper with you all. Thank you and have a nice day.
Thank you, sir. Our second presenter of track 2 is Mr. Harshit Kumar, journalist at Zee Media, will be presenting on the topic Copywriting Digital Era. Over.
Hello everyone, am I audible?
Yes, sir.
Could you please allow me to share my screen? All right. So my topic is copyright in digital era. So I'm going to present this. First of all very good afternoon to everyone, and thank you everyone attending this international e-conference on IPR issues. All distinguished dignitaries and chairperson of this session, I am presenting research paper on very important topic of IPR law, that is copyright in digital era. As we know, we are still in a worldwide pandemic situation since 2 years. We communicate and do maximum work online. So currently we are living in a digital era. In my research paper, I tried to cover all the threats like infringement of copyright caused by digitalization. Also, I have mentioned how digitalization in a threat as well as a solution for this infringement of copyright. As I am a digital journalist, so I know how to handle on a daily basis of this digital copyright infringement. So here is my topic paper. Digital technology has been grown so far and it becomes one of the finest creation of the human mind. It has opened its gates for a wide range of possibilities in a various areas like entertainment, communication, advertisement, media, and education. However, it is very easy to access to material available on the internet, which can lead a great concern for copyright infringement. As we know, copyright is one of the most important intellectual property right, which denotes the right possessed by the creators for literary and artistic work. So, for the copyright, these are the challenges faced by the copyright in digital world. First is the internet, multimedia work, software, and social media. Like we are living in a digital era, so internet is reach of everyone. So that is the common thinking that if we do anything, if we search anything on internet and we can copy it and paste it and use it. But this is the main threat. This is not everything available on the internet is free. All are maximum things are copyrighted. So there are so many copyrighted works on the internet, including news, article, stories, image, graphics, electronic books or ebooks, videos, etc. Internet has ocean of information available, which makes it difficult to determine where the work is duplication or copy of the protected work. So now we come to the infringement of the copyright in cyberspace includes downloading and uploading of any material, copyright copying and exporting audio-visual works, copying and exporting multimedia works, derivative works. So what kind of multimedia involves in the infringement? Like copying of the works of a creator without his or her consent, distributing multimedia product except educational purposes, creating prints of literary or artistic works without prior permission, dubbing and selling through any of multimedia products, creating copy of software and selling it without consent of developer. Now, how computer software is affecting the copyrights. There are so many computer programs, procedure, documentation, which performs tasks on a computer device. In digital world, software piracy is one of the major reasons for copyright infringement. It involves unauthorized copying, distributing of copyrighted software. Software piracy involves creating or copy of selling of any of software or any of digital renting of software, selling of computer hardware machines with pre-installed or preloaded print pirated software, copying of software programs using CD or DVD-R technology, sharing of a copied content on social media without giving credit or taking permission of creator or owner. How can we prevent these infringement on digital era? So there are so many enhanced technology available right now in such blockchain technology, digital watermarks, and access control and copy control. These are the three things which is very important in this digital era to stop these kind of copyright infringement. First is blockchain technology, which is considered as highly secure decentralized public ledger, which is used to record peer-to-peer transaction. To each transaction, the party agrees to details to encode it into the block of digital data, which is uniquely signed or identified. It is an excellent technology to resolve very much problem of copyright in digital domain. Now we come to the how we can use the how we can use the copyrighted materials for our purposes. There is a fair use policy. The content creator or the owner of the copyrighted material should have given protection in conformity with the public rights. The human rights of any person should not be used to curtail those another. That is why the concept of fair use have been involved in copyrights. In India, Section 52 of the Copyright Act 1957 lays down provisions relating to acts which would not constitute a copyright infringement. There are some things if we use it for educational purpose, it cannot be the infringement. Now I am going to conclude the paper. In this digital world, content creators and owners have great opportunity to showcase their work and creation using internet and digital platforms. At the same time, there is also a great threat of infringement of the rights of original content creators and owners. We must agree that there are several efforts should have been made at both international and national level to overcome the obstacles to ensure the protection of copyrights in the digital arena. Still a lot of things to be done. At the national level, it is important to create awareness among the people to train the enforcement agency and develop proper mechanism to prevent infringement. At the international level, there is a need to ensure that the provisions and principles enriched under international treaties and conventions have been compiled with to ensure effective management for protection of copyright in this digital world. Thank you everyone for patiently listening this paper.
Thank you, sir. Our next presenter is Ms. Ishani Acharya, student at School of Law, Birla Global University, and Mr. Rahul Das, faculty at National Institute of Law, Shiksha Anusandhan, will be presenting their topic, Intellectual Property Rights, a Human Rights Perspective. To kindly please the same. They have sent us a video for presenting their paper. I request the technical team to kindly play the same.
Unable to hear your voice.
Sorry, there's some technical glitch. We are sharing it again.
Yes, I think the problem persists with the sound.
यहाँ से भी अनम्यूट कर दो।
Greetings of the day to one and all present here. Today I'm going to present a paper on intellectual property rights, a human rights perspective. So before we move into the main topic, it is very important to understand intellectual property rights and human rights on their own. So there couldn't be two more different fields of law than intellectual property rights and human rights. In order to understand the correlation of these rights with each other, it is important to understand their respective elements first. The World Trade Organization defines intellectual property rights as the rights given to persons over the creations of their minds. In order to protect these unique creations and encourage the generation of new ideas and inventions for the benefit of the society, these intellectual property are protected by law. This ensures that the owners of the intellectual property are recognized and rewarded for their efforts. So there are various types of intellectual property. We have copyright, we have patent, we have trademark, we have industrial designs, geographical indication, and trade secrets. So now let us understand what human rights are. The United Nations says that human rights are the rights we have simply because we exist as human beings. They are not granted by any state. These rights can be said to be inherent, inalienable, universal, equal, and non-discriminatory in nature. Human rights do not depend upon a person's nationality, gender, ethnicity, color, religion, language, or any other status, and are applicable to all persons equally and uniformly. The recognition of human rights is not a new phenomenon. It has been an important part of each and every society throughout history. These rights are being given extra protection, and all the nations are trying their level best to protect and promote these rights post-World War II. The first legal document to set out the fundamental human rights for universal protection was the Universal Declaration of Human Rights, which was adopted by the United Nations General Assembly in the year of 1948. Human rights are indivisible and interdependent. That is, one right cannot be enjoyed completely in the absence of other human rights. For example, progress in civil and political rights of a nation also ensures the enjoyment of economic, political, and social rights. Now let us move on to the relationship between intellectual property rights and human rights. So if we look at human rights and intellectual property rights individually, we can conclude that these two fields of law have had an independent evolution. While intellectual property rights are recognized by the statutes and provide for incentives for the contribution of individuals to various fields, including technological development, human rights are basic inherent rights which nations are bound to recognize so as to maintain the dignity of human life. The connection between human rights and intellectual property, it only became apparent during the 1990s. So this debate was triggered due to globalization. The reason behind this was that most of the developing countries are not in a position and do not have sufficient resources to implement all the standards as laid down by the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. So this agreement added a compromise on their development and also at the cost of their human rights. Intellectual property regimes seek to blend the moral and monetary privileges of creators, inventors, and innovators with the more extensive interests and wants of the society. The fact that incentives and rewards are provided to inventors is one of the biggest justification for patents and copyrights. So when we take into consideration the economic, social, and political rights of the people, we can see clearly how human rights and intellectual property rights are connected. When we analyze the situation from this angle, we will find that there are primarily two areas of conflict here. First, the neglect of the rights of the indigenous communities, and second, the social implications of the TRIPS agreement, especially in developing countries, with respect to the right to health and patents. Coming to IPR in indigenous communities, traditional knowledge is considered as a part of public domain as it does not meet the criteria established for protection or private ownership. This severely affects the indigenous communities. These indigenous communities have been claiming their rights on matters of their traditional knowledge related to agriculture, biodiversity, etc., and state that the government should recognize the same. The problem is, since this traditional knowledge does not have a particular owner, private enterprises utilize this knowledge to create further inventions and seek protection via patents, copyrights, etc. Thus, the indigenous communities remain unrecognized in these types of situations and lose out on their lawful share. So this ultimately leads to the infringement of their human rights and exploitation as well. So in 2007, the United Nations passed the Declaration on the Rights of Indigenous Peoples, UNDRIP. It defines and explains their individual rights as well as the collective rights of the indigenous peoples, including rights over their cultural expressions and ceremonial processions, identity, language, health, employment, education, and other issues. Their ownership also extends to the protection of their cultural as well as intellectual property. Under this declaration, discrimination against indigenous people is also prohibited. This declaration was made with the intention to encourage countries to work alongside with indigenous people to solve global issues like development, multicultural democracy, and decentralization. Sadly, as it is a General Assembly declaration, UNDRIP is not legally binding it is not a legally binding instrument under international law. Now coming to the TRIPS agreement and human rights. So the problem is that the TRIPS agreement advocated very high standards for the protection of intellectual property rights for all members of the World Trade Organization. Non-compliance of these terms was backed by trade sanctions. This negatively impacts the underdeveloped countries for which the protection of intellectual property rights is not the biggest priority. The transfer of technology to developing countries is adversely affected as the minimum standards for protection of new inventions and technologies are quite high as per this agreement. In addition to this, we should also take into consideration the impact of the TRIPS agreement on economic, social, and cultural aspects of human rights. The biggest example we can take here is the high minimum standards of protection towards patented pharmaceuticals leading
Due to time restraint, we are bound to stop the video. With this, the second track of this session is over. I request Dr. Electria ma'am to kindly give her closing remarks. Over to you, ma'am.
Can you hear me now? Can you hear me?
Yes, ma'am, you're audible.
Yes, okay, thank you. All of the presentations, I found all of the presentations extremely interesting, especially the last one, not especially the last one that combined the human rights aspect. If I may say a few remarks, indeed, I think patents health related to pharmaceutical in the pharmaceutical industry in underdeveloped or developing countries affect in a way the right to health, and we have to see that very closely in not just in domestic level, but on an organizational level. And another remark I would like to make with respect to new technologies coming in intellectual property right, and especially in the internet. I would agree with Mr. Khatri about the hazards of the internet, and that is actually indeed a myth around copyright in the internet. That's everything as far as out in the public is free, which is something that is not true. So I think blockchain technology and other technologies could be employed for the protection of copyright in the digital environment. But in my opinion, I think that we strongly need a revision of the copyright laws. Not just in a domestic level, but in international level as well, because we have treaties from the previous century that is the base for the copyright protection. I think it's time for a real revision of the copyright and to start talking about digital copyright law at the first place. So with this remark, I will give the floor to my co-chair, Mr. Kumar, if he wants to make any more comments, otherwise to close the session. Well, I think we have no other comments, so I will give the floor back to the host for the next track, I think, or for the break.
Thank you, ma'am. Now I request the second chairperson, Mr. Vijay Kumar Makkin sir, to give his valuable thoughts.
I guess we do not have Sir with us anymore. He is lost connectivity. I request Vanshika to move forward with the next track.
Since we are running short of time, so we will move on to the next two tracks, which will be hosted by Nivedita. Please stay connected. Over to you, Nivedita.
Thank you, Vanshika. Good afternoon, everyone. I'm Nivedita, student of IPEM Law Academy. Welcome you in today's International E-Conference on Intellectual Property Rights, the Contemporary Issues. We are now moving on the third track of the session, which is on trademark laws and challenges. The chairpersons of this track are Mr. Stephen Sir, Assistant Professor, Serious Law School, Germany, and Dr. Anna Lam, Adjunct Associate Professor, the University of Notre Dame, Australia. Please take note, each presenter has 7 minutes to present their paper. Our first presenter is Advocate Satya Jain, Research Scholar at Lovely Professional University, and the topic that she will be presenting is Publicity Right Interlocking with Intellectual Property Rights, a comparative study between USA and India. Over to Advocate Satya Jain.
Good afternoon, everyone. I hope I'm audible and visible.
Yes, you're audible and visible.
Great. Thank you. Hi, I'll be presenting my paper on publicity right interlocking with intellectual property rights, a comparative study between USA and India. Before I proceed with everything, let's understand what publicity right is. Publicity right is nothing but a right which is given to an individual against any misappropriation of their own name, likeness, or any indicia of their personality. And that use should be for commercial benefits only. Only then will it be said that there is a violation of publicity right. Now, the publicity right is an emerging branch of intellectual property rights. And in India, the right has been recognized only by the courts. The courts have, by many judgments, have recognized that there is a right that exists name under the name of publicity right, or the right of publicity, or personality right. Now, my paper is divided into two sections. First, it deals with how copyright and trademark are somehow able to protect publicity right. And the second part deals with how USA is trying to protect publicity right and how India is protecting publicity right. So moving with the first part, first is how publicity right is an interconnection with copyright and trademark. First of all, copyright. Under copyright, there are only two ways by which the publicity right can be protected, or I can say a feature of publicity right can be protected. First feature is the image right, and the first feature is image right, which can be protected through the photographs. But there's a very big lacuna here. That is that copyright gives protection to the person who is taking the photograph, that is the author of the photograph. But it fails to provide protection to the person whose photograph is actually being taken. So in this way, you can say that the theory that copyright is able to provide protection to the publicity right is debunked. Later on, moving towards trademark, I am so sorry, I'm making it really short because we are short of time. So I'll be moving a bit fast. So going towards trademark, under trademark, it is said that a person's name or likeness can be protected. Any person's XYZ, they can make their name as a trademark. But for the person to make their name as a trademark, that name should be distinctive, and it should have gained a lot of goodwill through the use of the time. Now, to prove that the person has gained a goodwill, it will take quite a bit of time. So this way, it kind of leans back as to how the person can protect their name. And the second thing is there are at least 45 classes under trademark. Not now, if I want to get my name trademark, I will not be able to get protection under every single 45 class of the under the trademark. So if someone else's, like I have protected my name under entertainment section, and there is a section which is for manufacturing. A manufacturing company wants to use my name, and I cannot stop them because I have protected myself only under entertainment. So thereby, even trademark lags behind in providing proper protection to the publicity right. So yes, there are a lot of lacunas there, and the theory about that copyright and trademark are able to provide protection to the publicity right is debunked. Later on, moving towards the second section of my paper, a comparative study between USA and India. So let's understand what India does to protect publicity right. As I've said earlier, that publicity right is a court proclaimed law, a right. So what happens is we find different ways in which we can try and protect publicity right. For example, copyright and trademark. And the third one is the right of privacy. Recently in 2017, the right of privacy has been recognized as a fundamental right under the Article 21 of the Constitution of India. And in that, it has been proclaimed that right of publicity is a part of right to privacy. But yeah, there is a drawback in that, because right to privacy protects a person's emotional right, whereas right to publicity is giving you the protection against the economic loss. So therefore, these two rights are very different. And to say that the right of privacy will be able to protect publicity right they won't be able to do that. Moving further with USA, what USA has done is that USA has actually done a very innovative thing. There are almost 40 states within USA who have made laws on right to publicity, that is Right to Publicity Acts or the Publicity Right Act or the Image Rights Act of California. So in this way, the states have provided protection to the publicity right. Now, what they have done, they have provided a balance. By saying that they have provided a balance is that the things or the features of publicity right that can be protected by trademark are protected by trademark. The things which are protected by copyright will be protected by copyright, and everything else which cannot be covered by these two laws will be protected by the separate state legislations on the publicity right. Further moving on towards my conclusion, I would say that yes, publicity right does have interlink with the intellectual property right. It is an emerging branch of intellectual property right. And yes, India is lacking behind in trying to protect the right. It is time that India comes at par with USA, realize that how USA is trying to protect the publicity right, how it has been given, publicity right has been given the importance, and therefore make a separate legislation on the topic of right to publicity or the publicity right. Thank you.
Thank you, ma'am. The second presentation of this track will be by Mr. Ravi Khan, PhD scholar at Law School, Dehradun, Uttaranchal University, and Ms. Garima Singh, teaching assistant research scholar at Jagran Lake City University, Bhopal, will be presenting on the topic exception of fair use in digital rights management systems. Over to you, sir.
Good afternoon. Can you please make me the host? I want to share my slides.
So you're not the co-host. You can share your screen.
Right. Is it visible now?
Yes, your screen is visible.
Good afternoon. Heartfelt gratitude to IPEM Law Academy, panelists, and all the participants. I hope you are doing well in this global pandemic situation. As my topic has already been introduced, so I'll briefly move to the. I'll briefly introduce my topic, and then I'll move to the issues, and further I'll conclude my topic in a very short period of time. So as we all know that because of this technological advancement, the copying, reproduction, and distribution cost of a digital copyrighted work has become almost zero. So this has caused financial loss to the content owners. So to overcome this loss, the content owners came up with technologies like digital rights management, technological protection measures. As we are aware that the national copyright laws in most of the countries incorporate exceptions for copying for the purpose of personal use, research, education, archival copying, library use, news reporting, which is based on the principle of fair use. But the scope of these exceptions varies across countries and regions, owing to differences in national jurisprudence. However, they produce a similar outcome as they are based on the same skeleton. Now I will quickly move on to the issues which I have dealt with in my research paper. There are majorly three issues which I have dealt. The first one is that there is no effective notice which is being given by the author. The second is no interoperability due to the implementation of TPM. And the third one is the privacy and security issues which are caused by this implementation of TPM. Now, under the first issues, as we know that adoption of TPM acts as a guiding light in the creative world of copyright holders. Hence, it is an appealing innovation for them digital content and products appear to be dissatisfied. When purchasing digital content, one of the users' concern is the need for transparency. Like, for example, content owners fail to provide adequate notice about what features will be disabled by TPM in a specific product. It perplexes the user who has paid for the content that he is unable to access or modify, thereby limiting his freedom of choice. And this TPM is used by any online music store to prohibit personal sharing of music or to implement more sophisticated restrictions. Like for take example, Apple's iTunes does this. The second issue is no interoperability. It can be also said that one of the benefits of digital content is its compatibility or interoperability between devices and platform. And TPM, by its very nature, create obstruction to this free flow of data, exchange and interoperability. Again, users are dissatisfied when such notice of restriction is insufficient. Again, the example of Apple can be taken here. Like Apple's website now nowhere reflects limitations imposed on interoperability with respect to its music store or music player. Its music player is coupled with TPM technology, so the songs from its music store, that is the iTunes, can only be played on its music player. The third issue is the privacy and security issue. The ability of TPM to monitor and maintain continuous surveillance on consumer usage jeopardizes their privacy interests because such monitoring is technically embedded in the device or product. The user is unaware of its existence. Like for example, content owners may in their interest send an update to a user on a device equipped with TPM technology to monitor his every activity on a computer and running programs. This is a classic case of users being misled by ineffective disclosure about the capabilities of TPM and the significance risk they pose to the computer security. The most significant risk posed by them in the digital media product is the concentration of power in the hands of holders of exclusive right, that is the copyright holder. There has been a great deal of effort in US to develop rules to implement the mandatory disclosure requirement. Not only should notice be given when the user first encounters the product, but also when the user interacts with related products and services. It is worth noting that section 1021 of Copyright Act in the United States and nor section 65 of the Copyright Act, Indian Copyright Act, deals with the notice of the scope of associated rights and restrictions. In this paper, I have adopted a doctrinal methodology. In the conclusion, I'll say that despite the fact that TPM had been deployed before the law provided protection, it did not consider the inconvenience of circumventing TPM technologies. Law around the world prohibits the act of circumvention. Furthermore, if the device or technology has a limited commercial purpose other than circumventing TPM, it must be prohibited. There is an unsettled debate between scholars who consider circumvention of TPM in any case as a criminal offense and versus the scholars who advocate doctrine of fair use. The scope of fair use in digital copyright has been reduced when compared to traditional copyright. Before imposing criminal liability, the alleged infringer's intention and purpose must be considered by the legal authorities. The court should develop fair use jurisprudence holistically in order to balance the interest of copyright holder and the societal benefits. The provision for TPM circumvention is an entirely novel concept, as we all know. So there shall be no conflict between copyright infringement exceptions and the TPM provision itself. The paper also demonstrates with a few examples that circumventing TPM is permissible in certain circumstances only. Now, there are a few suggestions which I have proposed in this paper. I have proposed a twofold mechanism to exercise the doctrine of fair use in this digital era. The first alternate which I have proposed is the formation of a new governmental department as a central agency under the copyright law in order to circumvent TPM. It will facilitate the circumvention of TPM. This would necessitate a legal procedure in which the user would submit an application to the department stating the purpose, intention, and scope of the use of circumvention. And after reviewing the application, the department must either approve or deny the request, declaring it ineligible. Now, if the department is unable to, in certain circumstances, is unable to circumvent that TPM, it must seek court intervention to compel the copyright owner to cooperate. Furthermore, in emergency situations, users shall have the tacit right to circumvent TPM in order to exercise fair use doctrine. As long as the government department is objective and neutral in balancing the rights of copyright holder and public interest, this would further require proper appointment procedure in department. The second option which I have proposed is to include the words other lawful purpose. While there are 6 specific exemptions mentioned under the general exceptions under section 65 subclause 2, but they are very ambiguous and poorly written. The word other lawful purpose, if included in the legislation, will be broad enough to include all legitimate reasons to avoid. Furthermore, like the USA, India should have remedial measures to rule-making procedure. That's all. Yes, I have done with my presentation. That's all. Thank you so much.
Next, we have Mr. Jalaj Govind, student at Calgutius University. He will be presenting the paper on the topic issues related to national non-conventional trademark. Over to you, Jalaj.
So thank you, everyone. Good afternoon, everyone, all present here. So my, as told by the presenter, my topic is very brief. So first of all, I would like to start with the basic introduction about the non-conventional trademark and its graphical representation. So according to Section 1 of the Trademark Act 1999, a sign must be graphically represented as required under Section 2 of the Act. The statements capable of being represented graphically would imply that the mark which is to be registered is capable of being registered in a physical structure in a particular form and furthermore to be published in any journal. The graphical representation of a mark gives a fixed perspective which indicates what the mark is. So a mark is said to be graphically represented upon the fulfillment of 3 criteria, which are: first, from the graphical representation itself, it is convincible to find out the mark without the requirements of any supporting examples. Second, the graphical representation can remain instead of the mark itself. And the third, the people investigating the trademark or reading the trademark journal are expected to understand the object of the mark from its graphical representation. So any color standards, musical notations, or scientific measurements represent marks must be exact and make it sensibly practical for the users of the framework to most likely acquire a reasonable perception of the mark and should be completely ready precisely to compare the sign with the applicant users or reason to use with other similar signs. The graphical representation of the non-conventional trademarks is to great extent of a practical issue rather than a legal issue. If seen with the concept of distinctiveness, it might seem like a genuine hindrance in the procedure for registration of the non-conventional trademarks, and it is especially correct in the case of smell, sound, and color marks. So there are basically different kinds of non-conventional trademarks. So the most common are the smell mark. It is one of the most complex trademarks that has a great deal of consideration in the recent times. Irrespective of the issue of registering a smell as a trademark, few products have been registered under the smell trademark, whereas many smells have just been taken back or dismissed by the trademark registers of the different nations. In one of the leading cases of the Ralph Sickman versus German Patent Office, it was held that the registration of the smell mark was dismissed on the basis of the non-satisfaction of the criteria of geographical representability among the different variables. The second mark is the sound mark. It is another type of the non-traditional trademark that is looked upon with the issue of graphical representation. The basic method about the graphical representation of sound mark is the utilization of the musical notations and written descriptions. In addition, the written musical notes, while analyzing the pitch in an ordinary case, will not show tone, and the different tones can be utilized in a particular musical notes, which give a proper description of the music, but however, not the simply the music. The third mark is the color mark. Colors can be categorized in the form of trademark in two forms: a single color trademark and a combination of color trademarks. In the case SmithKline and the French Laboratories Limited versus the Sterling Winton Group, it was observed that the corporations settle out the confusion of whether the combination of the colors could be a mark and whether it could be a particularly unique enough to be registered as a trademark, and the both were replied in agree in the House of the Lords. So now I would like to talk about the issues related to the registration of the trademark, non-conventional trademarks. So the main issue in the registration is the distinctiveness criteria. Irrespective of the fact that some non-conventional trademarks like the shape and color can be recognized easily by any consumer, while the other marks like the smell and taste recognition of these marks may differ from the perplexity among the consumers. This is difficult. This difficult is a practical hindrance in the registration of the mark and not a lawful obstacle in the registration. A mark can acquire distinctiveness through use, and by this way, it meets all the requirements to be a trademark. The second issue is the graphical representation of the mark that I talked about. So the basic, now I would like to talk about the basic historical development of the non-conventional trademarks. The reasonability of any trademark would rely upon its ability to make an effect in the minds of the consumers of a particular good. If the characteristics of the representation of the good is unique enough, then it would attract the individual's recognition and senses noteworthy. This concept has given rise to many unconventional trademarks by the manufacturers. With the development in the society and the advancement in the technology, all the growing organization might want to use a registered trademark. So now I would like to conclude my presentation that generally the trademark laws recognize the protection of the mark, which has some psychological functions. If any symbol or mark which has a new form and had made a great impact in the minds of the customers and consumers and also had shown a great economic significance are to be protected under the trademark law. This difficulty in registering a mark as a trademark on a paper should not go about as an obstruction to the utilization and new techniques for distinguishing and categorizing such mark are to be advanced in order to manage the cost of protection to the customers of such non-traditional trademarks. In the case of smell trademarks, a smell is made up of different odorant molecules, and each odorant molecule initiates a few odorant receptors, which forms an arrangement of an odorant pattern. Therefore, an exact odor pattern can be defined to classify and distinguishing smells. This concept may tackle the issue of graphical representation of the smell marks to the degree of probability of representation of such marks. The national flags of the countries all over the world are identified with the help of color combinations. In case of a single color trademark, the color using any recognized color identification code like Pantone might be considered to establish a graphical representation for such codes, which are to be exact and stable. In the case of sound mark, the rules of the trademark laws gives the guidelines for the graphical representation. While dealing with the sound trademarks provisions, that individual should make sure he or she have included the MP3 format file, which is not exceeding 30 seconds. And in addition to this, the graphical representation of the sound mark should also be presented. After dealing with the provisions related to the non-conventional trademarks, it is clear that the present laws have made the registration of the non-conventional trademarks more difficult and complex because there is no separate registration process for the non-conventional trademarks. At last, Necessary steps should be taken by the legislature and other law framing bodies in order to amend the present trademark law, which help in making the registration of the non-conventional trademarks much more easier. Thank you. I would like to now conclude this stop line. Thank you.
Thank you, Galan. The next presentation is on intellectual property rights and sustainable development by Mr. Ayush Vedi and Ms. Shruti, student at IPM Law Academy. Over to you, Ayush.
Good noon to all of you. So, as all we know about my topic, so it's intellectual property rights and sustainable development. Intellectual property rights play a vital role in the sustainable development. This paper assesses the discourse of sustainable development as it is applied within the global intellectual property system. The sustainable development goals aim to engage and animate networks in order to eradicate poverty and hunger, achieve dignity and equality, and will create a healthy environment. In part one, the ways in which the intellectual property system is currently engaged in the sustainable development agenda has been discussed. In part two, different dimensions of the sustainable development goals that can be achieved. In part two, different dimensions of the sustainable development goals that can be achieved through intellectual property have been examined. So I'll give you the conclusive remarks for this. The above stated list of SDGs helps establish the role of IP in development on a holistic grounds and identifies the need for IP in meeting the SDGs. The diffusion of technology is the key factor in promoting the goals mentioned above. IP can therefore not be treated in a seclusion since it is interdependent on many socio-political and economic factors, which in turn also determine not only the fate of SDGs but also itself. Forming partnerships and initiating collaborative ventures are of core value to the 2030 agenda for the realization of these goals while contributing resources, all countries alike should pool in their efforts without resting an arm on developing countries only. Also, the industrial and economic frameworks at the national, regional, and international levels play a critical role as they help define and regulate policies concerning the various sectors. Thank you so much.
Thank you, Ayush. Our next presenter is Dr. Meenakshi Das, BGU. Her paper on the topic of trademark registration and challenges. Due to prior commitments, she would not be joining us, so she has shared the video with us. Over to technical team.
Greetings of the day to all honorable judges, respected Bhavna, and my dear friends. Today I'm going to present my project research paper on IPR subject. Let me share my screen first. My research paper is on the subject trademark registration and its challenges. So what is trademark registration? It is an intellectual property registration under the Trademark Act of India. Trademark registration provides ownership of intellectual property rights to exclusive use of the registered trademark and legal protection in cases of trademark infringement. Words, slogans, business names, numerals, and more can be trademark registered. Once a trademark registration application is filed with the trademark registrar, the TM symbol can be placed next to the logo or business name to put others on notice that the trademark application has already been filed. Trademark registration can help prevent repetition or duplication of the goods or services by competitors or other persons. The objective of Trademarks Act 1999 is to register trademarks applied for in the country and to provide for better protection of trademark for goods and services and also to prevent fraudulent use of the mark. What are the benefits of trademark? The biggest benefit to having a trademark registered is for the protection of the brand and the business by contributing to the goodwill of the business. The owner enjoys exclusive rights, builds trust and goodwill, differentiate products, recognition to products quality. It helps in the advertisement of goods and services, protects against unfair competition. Trademark registration can be enforced against company name. Validity of registered trademark is like once a trademark application is filed with the trademark office, the applicant can begin using the TM symbol. If the trademark is registered, the applicant can use the R symbol. All registered trademarks are valid for a period of 10 years from the date of application. What are the documents required for trademark registration? A copy of trademark or of the logo. In case of trademark for word, logo is not required. Applicant's details like name, address, and nationality. In case of company or LLP, the incorporation certificate. Udyog Aadhaar registration in case the company is eligible for lower filing fee. Description of goods or services represented by the mark. Trademark class under the application must be filed. Then what are the common problems or challenges of trademark registration? There are two challenges, absolute grounds and relative grounds. Like absolute grounds of refusal comes under Section 9 of the Trademark Act 1999, deals with the objection that are related to the trademark itself and which cannot be registered due to its inherent problems. The absolute grounds are especially aimed at protecting the interest of the general keeper instead of any specific third party. Relative grounds of refusal comes under Section 11 of Trademarks Act 1999, deals with relative grounds of refusal, that is, a trademark cannot be registered on the grounds of being similar with the already registered mark. The purpose of this ground is to protect the rights of a party having similar or identical marks and to safeguard the general public from any deception or confusion. Trademark objection in India is that one has to follow multiple steps as prescribed under the Trademark Act 1999 and Trademark Rules 2017. On application of trademark registration is filed in the appropriate trademark registration office, which has the jurisdiction to do so. For example, if an applicant is living in Mumbai, the jurisdiction would rest in the trademark office of Mumbai. Once the entry of an application is made, it is allotted to an examiner for the examination of the application under the provision of Trademark Act and rules. Then what is the challenges in US? Registration of a trademark is carried out by the United States Patent and Trademark Office. Trademark objection, also known as office actions in the US, has the same characteristic that of trademark objection in India. It is an official letter that states various legal impediments in the trademark and its application and directs the applicant to justify those issues in order to continue with the registration of the trademark. Just like India, it can take a few months before such objection is raised. And what are the challenges in UK? Trademark process in UK is very similar to that of India. Registration of a trademark in the United Kingdom is carried out by the Intellectual Property Office. An application is
We are running short of time, and that's why we have cut the video and we are moving forward to our next speaker. Over to Vedita.
Thank you, ma'am. With this, the third track of the session is over. I request Mr. Stephen to kindly give his closing remarks. Over to you, sir.
I guess sir is facing some connectivity issues.
I request Mr. Stephen to kindly connect with us and give your closing remarks. Okay. I request the second chairperson, Dr. Anna, to give her valuable thoughts.
So Priya, thank you very much for your introduction and thank you for hosting this panel. Thank you for the presenters. I had quite an interesting remind of the challenges of trademarks. I'm just, if I skip someone, please don't get that as something personal. It's just that perhaps I miss it here on my notes. Miss Jane, Divya Jane, I'm sorry for my pronunciation. The publicity right. I was just wondering if on her paper, she's talking about as well celebrity rights, which must be something connected with, she was talking about goodwill. However, in the US, you have as well the false designation of origin. For instance, I cannot produce something like a perfume of a Kardashian perfume if I am not a licensee of the Kardashian person. I don't know even how many they have, but you got to have some connection with the source. So I was just wondering if, besides entertainment, if she's looking into the association to a unique source, which I will bring up another case that has come to my knowledge. It was the Amazon. I don't have Amazon at home, so I don't know the name. There is like a something with a voice, Amazon Electra, Amazon something. And apparently Amazon now can reproduce the voice of the Big B. That was the one that lended his voice for the Amazon device. So there are so many questions about this. I mean, the use of his voice without his proper consent for everything they are going to do. So I was just wondering if you're going to tackle those topics as well. For Mr. Havikant, the exception of fair use, Yes, I agree with you. Sharing of music, the iTunes, especially the iTunes, because you have to have a music player dedicated for this. You don't have compatibility with other devices. But I was just wondering if he had a look on anti-competitive practices. And I'm going to tell you why, because apparently, I think 5 years ago, Spotify initiated a case in the European Union against Apple because they were charging a commission of 30% on Spotify content while they were selling their own products. And this went, I think, for the commission, if I'm not mistaken. So I was just wondering if you are tackling as well, if you are focusing on anti-competitive practices and antitrust practices as well. For Mr. Javal Goville, non-traditional trademarks, this is a huge problem. Yeah, even here in Australia, the registration and how you're going to cope with perfumes, smells. So I was just wondering if you are, perhaps I missed at this point, if you are looking into Indian jurisprudence, and I was wondering about one case in particular, the Colgate Palmolive Company versus Anchor Health and Beauty Care. This is from 2005. It's a long way behind. However, I was just wondering if you are aware of this case and if you can use or it would be a good suggestion for your paper. For Mr. Daiveri, I'm apologies. I think the sound here on my computer was not very good, but I understand that your paper was about sustainable development. So perhaps I am a little bit off the point, but I was just wondering, for sustainable development, the public must be very well informed about intellectual property, how it works, trademarks, how does it work, geographical indications, how does it work, patents. And this is not something very easy to have. I mean, here in Australia, our intellectual property office is doing an educational courses, digital really, to teach people about their options. Because when you go to an attorney, patent attorney, trademarks attorney, IP attorney, obviously they are going to have their options, but the client should be as well informed before he comes to the office, so he knows exactly what he should expect from their application. So I was just wondering if this is something relevant for your paper. Now, with Mrs. Menashe, the trademark registration and challenges. Yes, absolute grounds and relative grounds. This is a problem even in the US, I must say, the time that I was researching this topic there. But I was just wondering if you can elaborate why, if I am in Mumbai, I have to have necessarily an attorney, IP attorney or trademarks attorney, or anyway, in Mumbai. Why is this dedicated attorney by city or by region? Because I was under the impression, perhaps wrongly, that the Indian trademark law was for national, for the whole country. So if this is true, it doesn't matter where the trademarks attorney or patent attorney is located, because that's national. So I was just kind of, and another observation I must do about the US. The US has a system that is hybrid. Before you apply for the USPTO, you can have 1 year in your state of use of your trademark without necessarily registration to be done in the USPTO. I would highly recommend that you have a look at the Leighton Act, and you are going to see that we have this 1 year of period of grace, let's put it this way, for the trademark user to actually make the market well, not make the market. I would say that he would establish his goodwill in the market that he wants to sell his product, so he could go nationally. So I was just wondering if you had any opportunity to read this in the Act. a part of this that was very enjoyable. Thank you very much for your time and for the presentations. Very well done. And with that, I'll send back to the host, to Supriya. Thank you, Supriya.
Thank you, ma'am. Now, our next track is on the sub-theme legal recognition to various IPRs. The chairperson of this session is Dr. Ajay Kumar Bernwal, LLM PhD, Public Policy and Law, associated with Faculty of Law, Banaras Hindu University. The first presenter of this track is Dr. Gagandeep Kaur, Assistant Professor SG at UPES, and Mr. Prashant Chauhan, Research Scholar, PhD at School of Law, UPES, will be presenting on the topic IPR and Artificial Intelligence, tackling the conflict between human and machine intelligence. Over to you, sir.
Ma'am, can you confirm that I'm audible?
Yes, you are audible.
Yes, you're audible.
Please go ahead.
Right, ma'am. Good evening to the chair and all participating in this conference. My title is IPR and Artificial Intelligence, tackling the conflict between human and machine intelligence. This paper has been co-authored by Dr. Gagandeep Kaur and myself, that is Prashant Chauhan. Basically, what we are focusing in this research paper is that AI has emerged as a very prominent tool in the modern era of technology, and it is definitely the future of technology itself. But there are several issues which are connected in this, and especially in relation to the IPR. The humanoids like Sophia and Nadine has taken the center stage, but the issues are to be dealt with at every level and every stage. The World Intellectual Property Organization, in their conversation on IP and AI in September 2019, July 2020, and November 2020, have come upon the deliberation and identified the existence of AI and propounded three categories of AI: the expert system, the perception system, and the natural language. Now, when we talk about AI, basically what we are dealing with is the way a human thinks, the way a human acts, and combining that means thinking humanly and thinking rationally infused in a machine, and the machine will act in the similar manner, that too as a human, and obtain the desired result for which purpose that machine has been created. But due to this effect, there are issues that in case a machine creates something new or creates something unique, who shall have the intellectual property right over that particular creation, whether the creator who created the machine or the machine itself? Because when we talk about artificial intelligence or a machine infused with artificial intelligence, we don't find any kind of a difference between the human intelligence and the machine intelligence. And especially when we talk about the calculation of the data or the processing of the data, the machine is far superior than the human intelligence. For example, like Sophia, when we talk to Sophia, or the question has been put to Sophia, the humanoid, it has responded in such a manner that you can't figure it out whether a human is interacting with the machine or machine is interacting with the machine. Now, when we talk about the IPR, basically we have dealt with the copyright laws, the patent laws, and the trademarks in India, US, and UK. Now, because of the shortage of the time, I shall be focusing on the gist of the entire concept. That is, in all these laws, the focus has been to give right or the intellectual property right to the individual, recognizing his mental creativity. So the focus or the subject matter of these laws have always been the human. But what about machine? In case a machine creates such kind of right, whether the machine can be granted such rights or not. Now, when we talk about the judicial aspect, be it the case of Google France or the Sensatian community, the case of Naruto versus Slatter, in which a monkey was involved in the copyright of a photograph, or the Harvard College, the Board of Appeal of European Patent Office, all the cases, if we analyze them, the perception of the judiciary has been that we cannot grant such kind of rights to the machine or the something who don't have the human like existence or the non-human things. Now, when we talk about the entire summary of that, because for the shortage of time, I shall be concluding it at early stage. The entire concept revolves around the human intelligence, because the artificial intelligence is somehow the pattern is similar to that of the human brain or the working of the human brain. Now, when the human intelligence or the replication of human intelligence is done and it is used in form of AI, the issues will definitely arise in relation to the liabilities, whether the machine can cope up with the liabilities which can be imposed by the laws, whether the machine will have the locus standi to stand before the court of law, what shall be the duties of the machine in this relation, in relation to the personal rights or the rights in rent, whether the machine can be punished for the acts, because ultimately what punishment you can give to machine, that is just you can dismantle it. Now again, if you create the same machine, whether it will be a new machine or new existence, or it will proceed with the previous acts which it has done. So as far our conclusion has been that the scope of conferring IPR is very narrow in relation to the AI, but we have some suggestions that there is a need to recognize the use of artificial intelligence or the relevance of artificial intelligence, and the laws must be updated and amended in that relation. Further, there must be classification of IPR, that how that whether it has been the creation has been the outcome of the human intelligence or it has been the outcome of a assisted human intelligence with the AI. And definitely there is a need to accommodate new technologies in the field of IPR and human, but there must be a thin line and riders must be drawn that where we have to draw a line. Thank you. That's all from my side.
Thank you, sir. The next presentation is on artificial intelligence versus intellectual property law, paradigm shift by Ms. Ramanshi Singh, student at Jamia Hamdard University. Over to you, ma'am.
Good afternoon, one and all present here. So let me share my screen, please. Okay, so is it visible?
Yes, your screen is visible.
Okay. So let me first tell you, all of you what my paper is about. As we all know, artificial intelligence is attaining widespread momentum in our country as well as outside the world, outside India. It brings forth pertinent queries regarding intellectual property rights, IPR, for it challenges not solely ancient notions of ideas like patents and copyrights, but also the emergence of queries. This paper seeks to produce insight into the increasing scope of IPR laws and computing in conjunction with the inevitable challenges it brings from the worldwide lens on the matter. Can AI possess over an IP? As AI has set its foundation in numerous industries and is about to alter the lives of human beings within the forthcoming years, whether or not it be socially, economically, or maybe nature. Computing has drastically modified the means humans perform their work by communication power with algorithms for fast and economical retention and retrieval of knowledge. Intellectual property systems are designed to incentivize human innovation and creation. Informatic strategists accustomed go along with the normal strategies of looking out whereas getting a patent. However, the evolution of AI modified the complete situation, and currently informatics innovators and strategists felt the necessity to safeguard AI in getting patents. Businesses use AI practices into work backgrounds to drastically improve informatics services from neutral patent translation to AI trademark search. The objectives of my paper are to know about relation between AI and IPR and what is the impact of AI in the world of IP. Whether or not the copyright ought to be attributed to original literary and creative works that square measure autonomously generated by AI or ought to a person's creator be required. The information processing as a section is increasing. It information processing trend monitors annual survey 2019 edition. 71 of the respondents discovered that the business has started receiving lot of ads simply in a span of year. Within next 5 to 10 years, IPR will grow endlessly alongside the globe and with the advancement in technologies and process data. The speed of inventions is ready to grow at a speedy pace. Management of information processing portfolio can become a mammoth task. For patent looking, researchers can got to use long booleans and complicated word searches to type through easier, quicker, and take away the responsibilities. The accessible information. AI will build this whole method easier, quicker, and take away the probabilities of error, all by applying machine learning strategies. Trendy search will resolve the inherent ambiguities that plague ancient keyword searches. Now, some key points of my paper are: first, impact of AI in the world of IP. The first one is work sharing. AI is capable of administrating information analytical works like information processing, profile management, patent looking, and trademark clearing. By introducing algorithms, AI will replace long, unproductive, and value-intense hours of labor with a simply straightforward procedure. Additional functions like patent filling, trademark filling, drafting agreements, and discovery may be performed by AI, but this would force a precise level of ability sets and judgment that AI isn't capable of nevertheless. However, may well be within the future. Second sector is law and system. The introduction of AI into the planet of information processing can bring changes within the existing laws and statutes associated with property. These laws might redefine ideas of creator, ownership, and invention, and might embrace a replacement dimension where AI is capable of owning information processing. Third is future. In the future, AI will definitely be the most developing sensible operating tools and which can develop new trends and open up new market segments. So I would like to conclude by saying that as we have tendency to depend upon technology to endingly grow and also the demand to provide quicker results, we are able to safely say that AI is about to mark its existence in one's everyday activities. Even now, AI tools like Siri, Alexa, Square Measure used as collegial bots to assist generate responses as on the brink of traditional human speech as potential. With the type of development that AI technology is undergoing at once, it will concur that AI are going to be present within the next 5 to 10 years. The possibility that AI can own information processing within the future cannot be dominated out, and countries ought to have a relook at its information processing laws and embrace a replacement dimension on market phase underneath its preview. However, before AI will flourish as information processing homeowners, the law ought to redefine ideas of possession, inventorship, associate degree, WHO will be granted, and information processing. Thank you. That's all.
Thank you, ma'am. Moving on further, we have Ms. Muskan Khanna, student at Department of Political Science, Delhi University, and Ms. Soumya Khanna, faculty at IPM Law Academy. They will be presenting paper on the topic and analysis on intellectual property rights, root of tribal distribution versus enabler of tribal development. Over to you, ma'am.
Am I audible?
Yes, ma'am.
A very good evening to the chairperson, organizers, and the fellow presenters. Thank you for the introduction. I directly start with my presentation. The paper is titled as An Analysis on Intellectual Property Rights, Root of Tribal Destitution versus Enabler of Tribal Development. To start with, I'd like to introduce the current state of tribal communities around the world, especially focusing India. The third slide. Indigenous and tribal communities around the world currently are in a state of crisis due to exposure to multitude of threats caused by the intrusion of outsiders, that is, the international actors. Other than that, erosion of identity because the traditional institutions, laws of tribal communities are coming into direct conflict with the modern institutions, which is creating apprehensions amongst them about preserving their identity. Moreover, globalization is also hastening the process of destruction of local products, local markets, leading to tribal pauperization. The benefits of shared traditional knowledge and products are not really going to the tribal communities, but are rather being monopolized by the MNCs, which becomes a root cause of tribal despair. On the international front, institutional solutions are definitely emerging to help out the tribal knowledge and products access and benefit sharing. As a result, in many areas, tribal products and their indigenous knowledge is getting exposed to the world as patented products, which is helping in uplifting their standard of living and is also contributing to their livelihood opportunities. However, there's a very wide gap between international discussions and the local realities. Evidently, there's an urgency to settle tribal apprehensions regarding the nature, role, and scope of the impact of intellectual property rights worldwide so as to allow the indigenous communities to involve themselves as participants of sustainable growth and development. Now, I'd like to talk about the need to protect traditional knowledge. It is definitely growing with the passage of time. The protection of traditional knowledge must also promote its wider and more efficient use. The problem of biopiracy is at the root of traditional knowledge protection. What is biopiracy? It occurs when traditional knowledge is commercially exploited without the proper authorization of the indigenous or local people associated with such knowledge. To protect traditional knowledge using IP tools, two protective paradigms have been used. The first paradigm particularly aims to keep others from using or securing the intellectual property rights over traditional knowledge, whereas the second protective paradigm, which is often referred to as a positive protection, seeks to secure legal protection for traditional knowledge. Now, I'd like to talk about certain important cases around the world. Some pertinent cases include bitterroot as a cure for malaria, which was discovered by some South and Central American tribes. However, Institute of Research of France patented it without even acknowledging the indigenous and local communities' help that was taken up for the research. Another example is about Indians living in the United States. They were granted a US patent for the use of turmeric in wound healing. But quick enough, India's CSIR was able to locate around 32 references, some of which were more than 100 years old and were written in Sanskrit, Urdu, and Hindi, indicating that the discovery was already very well known in India even before the patent was filed. This indicates the false narrative that the MNCs are trying to create, that they are trying to actually uplift tribes, but are rather exploiting their traditional knowledge for their own benefit. However, the benefit sharing models for indigenous innovations are beginning to emerge, and one such example is from India, which is worth mentioning. So, there's this medicine which is derived from a plant called as Arogya Pach. Scientists at Kerala's Tropical Botanical Garden Research Institute, they discovered the plant which is said to boost the immune system and provide some extra energy. However, this medicine is actually based on the Kani tribe's traditional knowledge. Now, there's this major Ayurvedic drug company in Kerala which is manufacturing the tonic and is also giving the benefit to the Kani tribe. So, moving on to the main research question, which talks about whether IPR, poses problems for the tribal people. So there are certain challenges. Traditional knowledge is not being protected due to the way the IP rights have been designed in modern commerce. Traditional knowledge is also frequently held collectively by the communities rather than by individuals. This traditional knowledge, moreover, is passed down orally from one generation to another within the community or within the families within the community without any adequate documentation. Moreover, the current IP system, it allows individuals to protect their interventions, IPRs, but it does not really allow the communities to collectively protect their knowledge in all areas. And even in areas where collective IP registration is possible, those communities do not really have any awareness about it. So, can we do anything about it? Do IPR really have any scope in uplifting the tribal people? Next slide, please. Since these cases, the global community and national governments, they are developing institutional responses to the challenges that traditional knowledge presents. There's this UN Declaration on Indigenous Communities, the Convention on Biological Diversity, the Nagoya Protocol, WTO's TRIPS, which definitely makes exclusive provisions for local products and knowledge. Even national governments are also enacting legislations to protect traditional knowledge. India's geographical indication tags to commodities sort of enhance protection of these products and also adds to the livelihood security of the tribal groups. So, to basically conclude our research study, I'd like to say that dehumanization has always been a part of human history, but traditional knowledge and public domain do not actually have to be at odds always. Local communities can be the custodians of their knowledge and they can benefit from any commercial exploitation of that knowledge, but that knowledge must be widely available. A traditional knowledge library or a repository could be a component of such a solution. National traditional knowledge systems can include legal support for the communities to make and enforce decisions based on traditional knowledge. There are definitely a lot of practical, legal, ethical issues to consider, but I believe the principle should be very clear. If traditional knowledge is moved out of the public domain and into the IP system, the decision should be made by the community that has created it. And any benefits that result from doing so should definitely be returned to that community to ensure that they are active participants in sustainable development and not merely passive recipients of it. Thank you, and I'm really glad to have presented it.
Thank you, ma'am. Next, we have Ms. Tripta and Mr. Gopal Yadav, student at IPM Law Academy. Their topic is need of stringent laws and better focus in IPR.
हाथ में रखो. Good afternoon all. I am Tripta Bushwa, student of MLG third semester. I am presenting my paper on emerging issue on patents. Intellectual property rights have been defined as ideas, invention, and creative expression based on which there is a public willingness to giving a status of property. Intellectual property rights provide certain exclusive rights to the inventor or creator of that property in order to enable them to reap commercial benefit from their creative effort or reputation. There are several types of intellectual property rights. Protection like patent, copyright, trademark, and patent is a recognition for invention which satisfies the criteria of global novelty, no-noviness, and industrial application. Intellectual property right is a prerequisite for better identification, planning, commercialization, rendering, and thereby protection of inventor or creativity. Each industry should involve its own intellectual property rights, policies, management style, strategy, and so on, depending on its area or specified. And so on, depending on its area. Pharmaceutical industry currently has involved in intellectual property rights, strategy requiring a better focus and approach to the coming area. With the provision made in the Patent Act 1970, the citizen of India got an opportunity to develop process. This led to a huge benefit in economic growth of India. But drug manufacturer made use of this opportunity in manufacturing drugs. The lack of pharmacy drug and vaccines.
Note that only the cause of concern at the moment as the world battles with the acute shortage of personal protective equipment, diagnostic kits, and volunteers. Thank you.
Thank you, ma'am. With this, the fourth track of session is over. Now I request Dr. Ajay Kumar Ranwal, sir, to give your closing remarks. Over to you, sir.
Good evening, everyone. This is Dr. Ajay from Faculty of Law, Banaras Hindu University. And it was really known to go through the some of the papers. I'm sorry because I was because of some of my busy schedule today, I wasn't able to join. But definitely, whatever papers has been presented in my session, it was really, I mean, given a kind of highlight that shows that how far artificial intelligence and IPR became very much important. As far as your some of the papers are present, especially presenters are there, whether it's Sumedha Gupta or of course Muskan Khanna. What I found basically, though the remarks were very nice, whatever they have presented, the presentation was good, but what I found, there was a gap. What kind of gap? The gap was between the title and conclusion. Specifically, I'm looking about the methodology of the presentation, and of course what kind of contents were incorporated in the presentation that I have been gone through. And then what I found basically, when we are going to present anything, what we need to concentrate is it is not about the you people only. Wherever the research parts are there, I mean, specifically when we looks about the research paper, we need to concentrate about the title and then conclusion. Though the presentation was good, whatever presented by Sumedha, definitely it was a good topic, and then the presentation was specifically good. No, and then whatever data, analytical data and methods they have been given for analyzing the data, taken care of objective, that has been nicely presented, but I found little gap between the conclusion and then title. Again, so far as second presentation, which I have specifically I wanted to tell I mean that the students of political science, I think Muskan Khanna, right? So she has presented very well, and then again the title is very nice, because such kind of work needs to be come out, that is specifically looks about the traditional knowledge. We had lots of work on that particular part, but if someone willing to work on that particular specifically into the traditional knowledge, definitely it will give more exposure, because we have Ayush Mantralaya. If you could have gone through, Ayush ministry is specifically sponsored by the government of India, and we do have lots of budget, so we can work over that. And then definitely it was a nice topic, but the thing is that needs to be focused specifically on the methodology part, because unless and until that part would not be a stronger one, it would be difficult to get connected with such kind of ministry, because they are not, see, whenever you are focusing on that particular specific title now, you need to concentrate on that particular part only, so you cannot include many parts so far as that particular, I mean, specific traditional knowledge is concerned. So the presentation was good, and of course title was very nice, so you can work further on that particular title. And of course I got to know that the political science students started working on the traditional knowledge, specifically on intellectual property rights. That's a nice, I mean, initiative, that the students of different departments, now we understand that the interdisciplinary departments are there, the interdisciplinary works going on nowadays, but the thing is that if the students of different departments are coming forward, it means what? It means such kind of things are in the interest of the country. So it was nice to present Muskan's, and then definitely the suggestions was somehow what I found in the conclusion. In the conclusion there was some suggestions, so I mean there must be some differentiations should be made while going for the presentations. And then in the last presentations, I would request you all that please, whenever you are presenting something, do not go with the writing. whatever you have written, you are just reading it. So please try to not to read whatever you have written earlier, because if you have written and you are reading the same, it doesn't gives a proper exposure. It means it needs some sort of, some sort of analysis, that what kind of work you have done on that particular title. This is all about, and after all, I can tell you, overall the presentation was good, the title was good, because I have gone through the entire title. It was a really nice title, and I think people has to work upon, उस पे work कर सकते हैं. This is all about from my side. Over to the chair, other chair, my co-chair.
Thank you, sir. I thank all the paper presenters for their valuable time and sharing with us your insightful views on the theme of the conference. In order to have a cursory view on all the papers that were presented today, I would like to invite Mr. Ravi Prakash Shukla, sir, faculty at IPM Law Academy, to share the summary of the conference. Over to you, sir.
Thank you, Nivedita. Good morning. Sorry for the interruption. Good evening, everyone. I, Ravi Prakash Shukla, Assistant Professor, IPM Law Academy. I'm here to present a report on a conference. Our conference was divided in 2 technical sessions and 4 tracks. Conference is started with the insightful knowledge of Professor Dr. V.C. Vivekananda, Vice Chancellor, HNLU. Dr. V.C. Vivekananda, we talked about significance of IPR during pandemic and also talked about the post and precondition of India before TRIPS agreement. Moving on technical session 1, which is divided into 4 papers. The 4 papers were presented based on the copyright and trademark design. First paper were presented by Dr. Enrico Bonavio, sir, and the copyright and book publishing agreement. He explained how publishers' commitment and labor serves as a fundamental role in book chain, and publishers to achieve this rely on copyright and also their expression. And also discussed how IP Act as a strong business strategy. And second paper was presented by Professor Colonel Dr. A.K. Vasishtha on Journey through IPR, a mesmerizing read. Colonel Dr. Vasishtha discussed about intellect, its evolution with civilization. Whenever any intellect or thinking mind creates something, by applying ideas as soon as it assumes tangible form, it assumes the form of property or an asset. This asset is called intellectual property right. Colonel Dr. Vasishtha further discussed laws related to trademark and patents in reference with the Indian scenes, and also discussed certain programs at the international platform available in the field of intellectual property. Moving on, third paper was presented by Mr. Rodney D. Ryder, sir, protecting brands, trademark, and corporate reputation on the internet. Mr. Ryder, sir, discussed how IP Act and evidence law run hand in hand to ensure safety from online risk, and also explained how for intermediaries are liable for distribution of copyrightable content. Moving on, fourth paper is presented by Mr. Vijay Kumar Makyam, sir, on contemporary issues in trademark law. He brilliantly explained how all the IPR, that is trademark, copyright, industrial design, can coexist. He discussed upon various modern issues in trademark laws in the present world to a variety of case laws, including Harpic versus Domex, Univic District India Private Limited versus Britannia Industries Limited. In both cases, it described that Indian laws provide the defenses to porous spoof makers against infringement of intellectual property owners if there is no chance or use of original work. Moving on our second technical session, the first paper was presented by Dr. Anna Pantiado and Old Contemporary Issues, Indigenous Knowledge and Orality. Dr. Anna discussed intangible asset protection for indigenous people that also includes idea of tribals, and also talks about the importance of adding value to orality. In indigenous knowledge is to acknowledge the community property in which ideas flows from one generation to another. She also addressed how the knowledge of indigenous people and tribal could help to tackle the situation of climate crisis throughout the world. Dr. Anna also focused on the aspects of intellectual property theory as she'd away from having a legal concept and morality in contract formation, and also discussed concept of morality as a main element for legal protection with reference to indigenous knowledge and IP right. Moving on, second paper was presented by Dr. Eleftheria Papadimitriou. Her topic was intellectual property right and blockchain technology. Dr. Eleftheria discussed how intellectual property infringement increasing with the rise of digital technology, and also suggested how new innovation in technology field could help in the protection of IP rights. One of them is a blockchain technology. Dr. Eleftheria discussed their role in managing as well as imposing of IP rights, and also explored various blockchain applications and their enforcement applications. The third paper was presented by Mr. Abhinav Kumar Mishra on artificial intelligence and new technologies and innovation. Abhinav sir described beautifully how AI is emerging these days, and also discussed blockchain technology in protecting and managing IP rights. Fourth paper was presented by Stephen Papastefano, whose paper was this database reconstruction theorem and invasion of privacy. Dr. Stephen discussed what are the odds and risks while using machine algorithm. Using the example of census and COVID 2021 data, while collecting large data during census and COVID 2021, there was a plan to separate the real names from the data and then anonymize the data for storage, collecting, and later on publishing purposes. We also discussed difficulties arise with anonymization through the database reconstruction theorem, and Mr. Stephen also discussed modern possibilities and risks while using machine learning, and also made recommendation about using that usually by private sector. Moving on our tracks, on the track one, total 9 papers was presented. Those were based on the sub-theme of jurisprudential aspect of IPR and emerging issues in patent. This track was chaired by Dr. Anna Pantiado and Mr. Abhinav Kumar Mishra. In this particular track, authors gave their insight about jurisprudential aspect of IPR as well as the emerging issues in patents. Authors discussed various treaties for protection of IP rights and also discussed the new issues and challenges. Patent laws were also discussed in reference to pharmaceutical companies, licensing policies under the patent laws also discussed. Moving on to track number 2. On the track number 2, total 6 papers were presented. Those were on the sub-theme of copyright, a right of every creator. This track was chaired by Dr. Eleftheria Papadimitriou and Mr. Vijay Kumar Makki. In this particular track, various possible aspects of copyright and issues related to those rights was addressed, and also suggested the points by which we can amend our laws to provide better protection of IP rights. Papers presented under this tracks were. Report under track 3. Under track 3, total 8 papers were presented. Those were based on the sub-theme of trademark laws and challenges. This track was chaired by Mr. Stephen Stefano and Mr. Rodney D. Ryder. In this particular track, authors elaborated trademark-related aspects, emerging issues regarding trademark registration due to introduction of new IP rights under the head trademark. Differentiate between various trademark laws of various countries, especially UK, US, and Europe. Moving on, track number 4, total 7 papers were presented. Those were based on the sub-theme of legal recognition to various IPR. This track was chaired by Enrico Bonavio and Dr. Ajay Kumar Banwar. Under this particular track, authors discussed various new possibilities under IPR, which needs recognition under various branches of IPR, and also describe various technological innovation which could help to protect IP rights. I thank you all for connecting with us in this conference. Thank you. Over to you, Nivedita.
Thank you, sir. Now it is my honor to invite our chief guest for the valedictory session, Colonel Dr. A.K. Vijishta, Member, International Council of Jurists and Peer Reviewer, Geneva Convention Court, to join us and share your valuable thoughts with us.
Very good afternoon to everyone. A very respectful namaskar. Yes, It has been a great honor to be a part of this excellent forum. Before I embark upon the valedictory address proper, I would like to place on record my heartiest thanks to the management of the IPEM Law Academy, the organizers of this program, particularly the dean, the head of academics, Dr. Neelam Singh, Dr. Meenakshi, the principal, Dr. Singhal, and the young students who have, with so much of enthusiasm, participated. I also place on record the heartiest thanks and an immense gratitude to the august the personalities who participated, the Dr. Vivekanandan, and that's from India, and Dr. Enrico, Rodney Ryder, Stefan from Germany, Madam Anna, and the lawyer from the Supreme Court from England, and everybody who has been a part of this August forum. Besides being a matter of honor, it has also been a time of great learning. These almost 7 hours of continuous non-stop learning in a field which affects everybody. When we talk about intellectual property rights, we are in fact talking about the finer aspects of life, human life. As the name suggests, intellectual property. It means something which is generated by the intellect. When we talk about intellect, we are talking about mind and not brain. Of course, the brain is behind it, but mind, that is the process of thinking. Whatever generates by the use of or by the interaction of the cognitive faculties, by the power of perception, falls within the ambit of intellectual property. I don't need to define it because there are people far more and far greater qualified than me to actually define it in its exact elements. But yes, I'm sharing my views with you. And as I mentioned during the course of my lecture, in the forenoon session, that I am a proud Indian, a very proud Indian, as every one of us is. But at the same time, I am also a very proud individual, as every one of us is, being a part of the whole world. If I am proud, it doesn't mean Professor Anna is no less proud, or Stefan is no less proud. Each one of us, I today witnessed, in fact, all of us, the whole world today witnessed the participation of intelligentsia from all over the world. Across the 7 seas, as we call it in the Indian parlance. One jurist sitting across the Indian Ocean, another sitting far, far away in Australia, another one sitting in the United States of America, then the one sitting in Germany, and various parts of our own country. One thing which I, as a student of law, as a student of English, Sanskrit, and the Hindi literature, as each one of us has been brought up by virtue of being citizens of India, and having witnessed various environments abroad during operations with the United Nations, or with the United Justice Division, with which I had the opportunity to work and see various circumstances, people thrown into various, by the force of circumstances, to their liking or to many times not to their liking. Having had all that experience with me and having run through all this, having seen tough academic times, one thing I can say it for certain, that the contribution which each one of you, the illustrious personalities who have joined this forum today, and to which the IPEM Law Academy has been instrumental. A very grateful thanks to the IPEM Law Academy, who have managed to get hold of such illustrious personalities all across the world. I first of all wish to applaud the IPEM Academy for this sterling effort. And at the same time, I also appreciate the effort which each one of us has put in. I was really impressed how much Professor Dr. Enrico effort he has put in. The interest which Anna has shown, the interest which Rodney has shown, it's unbelievable. So this platform, to me in particular, it's a platform where people of great excellence have got together and exchanged their views. As I was informed in the beginning by the management that the lectures, the papers which have been read out during this seminar, during this conference, will be compiled and will come out in the form of a book. I'm sure it's going to be it's going to be a treasure worth possessing. And I, for one, would look forward to it. And I'm very sure my friends, the scholars all over who have been a part of this conference today would be with me and would also wait for this book to come and would like to grab it at the earliest opportunity. So I also make an appeal to the IPEM Law Academy that kindly make sure that each one of us gets a hard copy of this. As soon as it's ready. And yes, soft copy, all right, but a hard copy to see a book and to hold it in your hands is a different feeling altogether. Intellectual property rights, we have been able to really speak a lot. I was impressed with the standard which these young students have shown. They're talking about visuals, they're talking about audios, they're talking about caricatures. It's unbelievable. The young Indian minds, I had a glimpse of all of them. I was listening to all discourses throughout. And another achievement which I personally feel the IPEM Law Academy has been able to make today is that it has been able to get people from all walks of life to be a part of this forum. It's very difficult to put people of so much of diversity together, focused on one objective. So compliments to IPEM Law Academy. The grateful thanks to the scholars who have participated in this, the Honorable Vice Chancellor of Hidayatullah University in particular. I'm sure he is the committee. I have been a witness to Hidayatullah University about a decade ago, and I had seen the kind of commitments this university has and its Vice Chancellor generally actually has. He's been able to find a time and to give such a comprehensive discourse on trips on intellectual property rights. I'm very sure, though it's not a convention or a covenant, but it is nothing short of it, that all of us are sitting here and discussing all facets of intellectual property rights, how these rights should be managed and how should they be regulated. One aspect which I personally feel has been left out a little bit, probably because the time in a one day's conference, this cannot be so much cannot be managed, is the applicability of the laws. We have been able to discuss These are the laws. These are the aspects of the law which is available. These are the aspects of the rules and regulations available on this subject. And this is the limited applicability, the limited corridor that is available to the practitioners of the intellectual property, the innovators of the intellectual property. We have not been actually able to analyze whether the laws which have been given out by various countries or even by the international community, the regulations which have been imposed by the international community are absolutely in keeping with the times, or they need to be modified. Of course, wherever a modification is required, the international community is aware, importantly, very aware that these modifications need to be incorporated. But we cannot forget that we have graduated from the bipolar world to a unipolar world, and now an absolutely diversified world. Whose word will be the last word in this is still not confirmed. The world or this universe is governed by leaders. Leaders are at individual level, leaders are at national level, leaders are at the world level. At places, people lead. At other places, the nations lead. I made a reference to Vasudhaiva Kutumbakam, that is, the whole world is a community, is a family. But the family also needs what in our domestic law, in our Hindu law, we call karta, the person who holds the reins and who keeps the whole family in discipline. When we talk about WTO, when we talk about TRIPS, when we talked about WIPO, or when we talk about the Uruguay round, we are talking about disciplining or putting in discipline the intellectual property rights and their exercise. I personally feel that to a very large extent, this forum has not only granted an opportunity to exchange views on intellectual property rights and their management, but also this will help in forging and formulating a roadmap. And this, the brochure, which eventually will come out with all the papers that we have presented before this on this platform, will become a reference book, a guideline, not only for India, not only for one institution in India, but all the institutions in our country and the institutions abroad. I wish a very bright future to all of you, to all of us, and profusely thank each one of you to have been there on this platform, for having graced this platform by your august presence, by sharing your brilliant ideas. I also wish each one of you a Merry Christmas and a very Happy New Year and a great future ahead. We'll all be together, safe, healthy, and shall move together ahead, and ahead. Thank you very much. Thank you so very much. God bless you. Namaskar.
Thank you, sir, to share your valuable thoughts and blessing us with your presence. I would now like to invite Dr. Meenakshi Tomal ma'am, Principal of IPM Law Academy, to give the vote of thanks. Over to you, ma'am.
A very good afternoon to all, one and all present over here. It is my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this event successful. I, Dr. Meenakshi Tomar, Principal of IPM Law Academy, on behalf of the entire faculty of the institution, extend my sincere thanks to the dignitaries for spending their valuable time with us, which help us in making today's event a great success. On behalf of IPM Law Academy, I extend a hearty vote of thanks to our keynote speaker, Dr. Professor V.C. Vivekanandan, Vice Chancellor, Hidayatullah National Law University, for sparing the precious time from his busy schedule and for gracing the occasion with his presence. Today we had an opportunity to hear your thoughts, and this will surely encourage us in all our future endeavors. The thoughts have enlightened our minds and have shown us a new path. I also want to thank our eminent speaker, Dr. Andrea Bernardo, Colonel A.K. Vasista, Mr. Rodney D. Ryder, Mr. Vijay K. Mathyam, Dr. Anna, Mr. Stephen, Dr. Elithuania, for their active participation in our event. You all truly made the day enlightened for us. I would again like to thank respected Director Sir Dr. R.K. Singhal for his support and guidance. His deep and intellectual way of inspiring knowledge has added the glory of this event. I think all the speakers, as we have no word to offer gratitude for their valuable presence here, you have deep insight into the topic and revealed some interesting facts also. I thank entire team of IPM Law Academy, as on event like this cannot happen overnight. The wheel started only weeks ago. We have been fortunate enough to be backed by our IT team for being always proactive and dedicated support. And last but not least, I thank all the students and the audience who made this event successful by their presence. I hope you all will always be there to support us in future events also. It has remained a profound pleasure. Thank you once again. Thank you all.
Thank you, ma'am. We have now reached the end of today's conference. I thank all the dignitaries who blessed us with their presence and our eminent speakers who made this conference a success. Thank you to all the faculty members for your support and the student coordinators without whom this event could not have been possible. I request all the participants and the attendees to kindly fill the feedback form through the link that has been shared in the chat box and give us your valuable suggestion to better ourselves for the next event. Thank you all. Kindly turn on your cameras for the group photograph.
Recording in progress.
Thank you all.
Thank you, everybody. I think it should be time to leave.
Those who have not filled the feedback form yet are requested to fill it. Everyone else can leave the session. Thank you for joining us.
Bye-bye. Take care.